Good afternoon. The first item of business is time for reflection, and our time for reflection leader today is the Right Reverend Rosie Frew, moderator of the General Assembly of the Church of Scotland.
Thank you. Good afternoon. The 8th of March is International Women's Day. It's always the 8th of March. So that was Sunday past, a global day celebrating the social, economic, cultural and political achievements of women. And there have been many throughout history and in the present day. There's a lot to celebrate. But there's still much work to be done, both here in Scotland and worldwide, in raising awareness and advancing gender equality, be it the gender pay gap, lack of representation in leadership roles, gender-based violence, unequal access to education and opportunities, and quite simply, in showing basic respect to girls and women. On Sunday coming, the 15th of March, we will remember some particular women. It's Mother's Day. In nurseries and primary schools, the length and breadth of the land, cards are being created, presents are being made. By the weekend, the shops and supermarkets will be filled with cards, gifts, and overpriced bouquets in shades of pink. Hotels and restaurants will be fully booked. There will be an air of expectation and anticipation on the part of both children and mothers. The date for International Women's Day is fixed. The date for Mother's Day changes each year, and it's all tied in with the timing of Easter. The first Sunday after the first full moon occurring on or after the spring equinox of March 21st. Mothering Sunday, the fourth Sunday of Lent, is 3 weeks before Easter Sunday. And it was the day when those working away from home, those in service, were given time off to return home, to visit their family and to worship in their mother church, the place where they were nurtured in their faith. I like that wider meaning. A time to remember those who nurtured us, those who helped mould us into the people we are today. A day to show our appreciation. So have a think. Who are these people for you? The people who nurtured you, shaped you, inspired you. Parents, grandparents, aunts, uncles, teachers, youth leaders, faith leaders, people in positions of power and influence, neighbours, friends. Remember them, give thanks for them, and show your appreciation. We are now these people in positions of power and influence. So think again. Who are those you nurture? Those you influence? Those you may inspire? What do they see and hear? What should they see and hear? In this place, at home, in your neighbourhood, your constituency, your local schools, on the telly, on the socials. I'll leave that one with you. Thank you.
Thank you. Thank you.
Have a good day.
Thank you. The next item of business is consideration of business motion 21032. In the name of Graeme Day, on behalf of the Parliamentary Bureau on changes to business, any member who wishes to speak to the motion should press their request to speak button now. And I call on Graeme Day to move the motion.
Move, Presiding Officer.
Thank you, Minister. No member has asked to speak to the motion. Therefore, the question is that motion 21032 be agreed. Are we all agreed? The motion is therefore agreed. The next item of business is consideration of business motions 21033 and 21034 on variations to standing orders. I ask any member who wishes to speak to the motions to press their request to speak button. And I call on the Minister on behalf of the Parliamentary Bureau to move the motions.
Move, Presiding Officer.
Thank you. No member has asked to speak to the motions. Therefore, the question is that motions 21033 and 21034 be agreed. Are we all agreed? The motions are therefore agreed. The next item of business is topical questions. At question number 1, I call Annie Wells.
Thank you, Presiding Officer. To ask the Scottish Government what its response is to the fire at Union Street in Glasgow.
First Minister.
Presiding Officer, let me begin by paying tribute to our emergency services, particularly the Scottish Fire and Rescue Service, for their response to this major incident. 250 firefighters were involved and, at its height, 18 fire appliances plus specialist resources were deployed. From 8 o'clock this morning, SFRS scaled back the response to 4 fire appliances and 2 high-reach vehicles, although it is important to point out that it remains a live incident. When I visited the site yesterday, I commended the work of SFRS and others to the commanders and partners who led the response. It is a huge relief that there were no injuries, and that is thanks to the efforts, professionalism and dedication of the emergency services. A huge effort is underway to identify any safety issues within the train station, which must remain closed for now. The Transport Secretary has been briefed constantly and yesterday met with Network Rail and ScotRail as they assess the ongoing challenge of restoring services. Above all else, Presiding Officer, let me be clear today. The Scottish Government will stand with the City of Glasgow as it recovers from this fire, and given the significant cost the City faces, we will back those words with cash. To get that work started, a Ministerial Oversight Board has been established, chaired by the Cabinet Secretary for Justice. We will rebuild, we will restore, and Glasgow will flourish again.
Thank you. Annie Wells.
Thank you, Presiding Officer. I thank the First Minister for his response. And I want to also place on record my sincere thanks and admiration for the firefighters, first responders, paramedics and police who worked tirelessly throughout the night. Their professionalism and bravery undoubtedly prevented an even greater tragedy. And I just want to say as well, Presiding Officer, that I remember every fair Friday of my childhood going to Glasgow Central Station to get the train down to London or Bristol or Derby to visit family. And it's a place where people in Glasgow hold most dearly. But the fire has caused serious damage to a historic part of Glasgow's city centre, including the loss of the amazing Victorian building that we saw. And the First Minister has said, but can I just get a further commitment to ensure that all necessary support will be to restore this important part of Glasgow?
First Minister.
Presiding Officer, I acknowledge the significance of the site in Glasgow, and it's obviously iconic within the city. There's a whole number of steps will have to be considered in terms of the recovery process that is underway. But the Government will work collaboratively with the City Council to enable that to be the case, and obviously a whole sequence of decisions will be required by the City Council to enable that to do so. But let me reassure Annie Wells that the Government will be partners with Glasgow City Council in enabling that to be the case.
Annie Wells.
Once again, I do thank the First Minister for his response, but as we know, many small businesses have lost everything as a result of this fire, from Whitechapel, where the owner has lost specialist tools and stock, to local businesses such as Soglo and 100 Demons and Amber Rose Nails. These are people's livelihoods, First Minister, and can you outline what immediate practical support can be offered to those businesses in the local area?
First Minister.
Presiding Officer, I'm acutely conscious of the impact on a range of businesses, not just those in the buildings that have been affected by the fire, but in the surrounding areas where there is an exclusion zone and there is difficulties of access. And obviously that may persist for some time to come. So I'm clear about those impacts. CoCab Stewart, the local member, has briefed me on the dialogue she's had with individual businesses, and obviously the City Council will be in dialogue with those businesses as well. What I made clear yesterday when I visited the site is that I recognise those impacts, and as we discussed with Glasgow City Council, the support that can be available from the government, making sure that business owners, many small businesses, as Annie well says, people just getting on with making their living, who've had their world turned upside down, we've got to put in place support to assist them at this difficult time, and the government will look to work with the City Council to do that.
Thank you. Bill Kidd.
Thank you, Presiding Officer. I have been contacted by a number of constituents concerned over the huge proliferation of so-called vape shops and the obvious dangers they pose due to highly combustible and reactive substances contained in them, as was evidenced in the fire. Can I please ask the First Minister to say whether the Scottish Government will consider the possible need for further regulation of such premises?
First Minister.
President Officer, it's important that I stress at this stage that there is a full investigation of the site underway, and I'm obviously conscious of the very clear imagery that has been circulated from the weekend, which appears to show that the fire started within a vape shop. So it's important that we allow the investigation to be carried out to establish the facts about this issue and to identify if there are the lessons that have got to be learned. I do also understand the public concern on the issue about safety of vape shops. As I indicated yesterday, I'm open to the need for further regulation and legislation to ensure the safety of people in buildings, especially when it comes to the storage and disposal of combustible products.
Pauline McNeill.
I'd like to sincerely thank the First Minister for being here today and for the very strong statement he's made about Glasgow. And if I may add my sincere thanks to the fire and rescue workers and everyone else still making sure that this fire has been dealt with, and to senior officers who briefed me last night. It is truly heartbreaking for Glasgow. I probably am Glasgow's longest serving elected member, and I find it deeply emotional, so thank you. We're still waiting to find out what the damage is to Glasgow Central Station. Through recent media reports, there's an indication that there's no major damage, though the architect of the glass roof has expressed some concern for that. I'm sure the First Minister agrees that it must be very difficult for thousands of commuters to rely on the station, but for the network itself. I know you've been having discussions, and I presume the Cabinet Secretary, Fiona Hyslop, will be having discussions as well about these implications. I wonder if there have been any talks about what more could be done to get people to work and to appointments, such as running more buses, until we know when Central Station will be fully open.
Minister.
I understand entirely the deep emotional connection that Pauline McNeill sets out, and frankly that's why I'm here today, because I understand the depth of sadness that's experienced in the city of Glasgow about what has happened. So for those reasons I think it's right that the First Minister is answering this question today. In relation to Glasgow Central Station, I want to make it clear that every effort is being made to open the station as soon as it is possible, but it can only be done when we are assured about the safety of the station. And colleagues will understand the potential vulnerabilities that exist after such a major incident so close to the station. I think it has to be said that the efforts of the Scottish Fire and Rescue Service, as they explained them to me yesterday, were astonishing to avoid the spread of the fire from the building into the Central Hotel, as I will always call it, and the Central Station. And their efforts were intensely targeted to make sure that was avoided. And I think, although the site is devastating, we have avoided a much greater incident by the skill and professionalism of firefighters. So the safety assessment will be undertaken, and I give Pauline McNeill and members of Parliament the assurance that that has got the highest priority, but it can only be concluded when the investigation has been carried out and we're satisfied that it is safe for access to the station to be delivered.
Sharon Dowie.
Thank you, Presiding Officer. Well, we must wait for the outcome of official investigations to confirm the exact cause of this fire. It's been widely reported that the fire originated in a vape shop. These premises often contain large quantities of products powered by lithium-ion batteries stored on shop floors and in back rooms. Following the proactive decision to ban disposable vapes from June 2025, it's worrying to see the continued impact the industry is having in our communities, and despite the risks, there's currently minimal responsibility placed on vape manufacturers and retailers for the hazards their products can create. Can the First Minister tell us more about what the Scottish Government will do to address this?
First Minister.
So the one thing I understand the concern that Sharon Dowie puts out, but I want to just take issue with one point that she raised, which is about the responsibility of business owners. Business owners are intensely responsible for the safety of their businesses. So there is an obligation on any business owner, and particularly an owner of a vape shop, to make sure that their business is safe. And we may well be looking at the implications of that failure on other adjoining buildings. So there is a regulatory infrastructure in place, but as I said in my original in my answer to Annie Wells, I am open to further consideration of these issues. There is legislation going through the United Kingdom Parliament at this time, and the Government is engaging constructively on that question to ensure that the provisions extend to Scotland. But I think we've got to be very clear about the responsibility of business owners to make sure their businesses are safe.
Kenneth Gibson.
The fire and the closure of Glasgow Central has exposed how dependent Ayrshire communities are on rail. The last X36 service leaves Glasgow Buchanan Street bus station for the Garnock Valley at 17:15. And the final bus from the Garnock Valley, population 20,000, leaves Dalryse early as 15:32, and there's no other buses serving these communities. Given that Stagecoach won't enhance this service and neither will SPT, what can the Scottish Government do to ensure a decent and reliable service from my constituency to and from Scotland's largest city?
First Minister.
I recognise the importance of travel connections from Ayrshire and Mr Gibson's constituency, and there will be greater challenges arising as a consequence of the fire. Transport Scotland will continue to engage with its public transport partners and stakeholders to see what measures can be put in place to mitigate the impacts and also to build up the resilience of services, and obviously to support Mr Gibson in his efforts to make sure there are stronger public transport services in Ayrshire. There is a point that Polly McNeill made that I didn't respond to, which was about more bus connections, and my apologies for omitting an answer there. ScotRail are operating a range of services that are coming into, for example, Paisley-Gilmore Street, and there are then onward bus connections from there available, and there are other intermediary stops that are being made to try to maximise that connection. But the Transport Secretary is working with the rail service providers and other agencies to make sure that we maximise bus connections in replacement of rail services for as long as this incident goes on.
Paul Sweeney.
Thank you, Presiding Officer. This is one of the most iconic Victorian architectural set pieces in Scotland, and to see the loss of this building is truly heartbreaking. It stood there for 175 years. Can the First Minister give his assurance that conservation-accredited registered engineers with the right expertise will assess the remaining elevation to Gordon Street for any possibility of preservation of that frontage, and commit to a faithful reinstatement with the building owners, bringing together that Ministerial Oversight Board? This building is so critical to Glasgow's built heritage, and indeed right across the road in 1987 the Cadoro building was faithfully reinstated after a major fire, so it can be done. Can there be the political will and commitment to do that at the highest level?
First Minister.
I understand Mr Sweeney's long-standing interest in these issues, and I welcome the comments that he has made. Every effort will be made to progress the site and to live up to the aspirations that Mr Sweeney has set out, and the Government will work with Glasgow City Council in that respect. But we are at the very early stages of that process in working out what can be undertaken. And in the short term, there will be particular challenges about the stabilisation of what is a very vulnerable site to enable access to Central Station. So if we want to have access at the earliest opportunity to Central Station, which is certainly my priority, there will be difficult decisions to come to conclusions about in relation to the existing site. But all of the issues of historic environmental protection that are part of the legal framework in Scotland will be applied in this case, and obviously members will be kept up to date on the developments that are taken forward.
Question number 2, John Mason.
To ask the Scottish Government what discussions have taken place with football authorities concerning the recent deplorable fan behaviour after the match between Celtic and Rangers.
Minister Siobhan Brown.
Thank you, Presiding Officer. I join the member in condemning the appalling behaviour of those fans who invaded the pitch and acted in a violent and a disorderly manner, ruining what had otherwise been an exciting football experience for fans. Disorder of this nature is not acceptable and risks the safety of the players, the fans, the stewards and also the police officers. I spoke to Police Scotland yesterday evening and have this morning spoken to both the Scottish Football Association and the Scottish Professional Football League. We are of one mind that this behaviour is not acceptable and that the action must be taken to prevent recurrence. We all need to play our part here, and I'm reassured that police, football authorities and football clubs want to work with us to ensure that there is no repeat of the scenes that we witnessed on Sunday.
John Mason.
I thank the Minister for that response, and she uses the word prevent, which I think is important. It seems to me the police said clearly that some individuals had armed themselves before coming into the stadium. So clearly they were not searched. The stewards were not checking on who was carrying what, including pyrotechnics. And surely there needs to be better stewarding at games, that people are actually checked. Everyone is. I went to a Napoli game, I was checked at security. Surely everybody should go into Scottish games, should be checked.
Minister.
Yes, absolutely. It is quite complex when entering the stadiums to find masks, for example, where they're hidden, or pyrotechnics, which is challenges that they have faced. Just before every single game, clubs, Police Scotland and all local authorities make sure that they've got robust measures in place through the Safety Advisory Group process. But in saying that, when there are those that are determined to engage in disorder, it's difficult to entirely prevent this. But with the speed at which Police Scotland and the stewards did deal with the issue on Sunday does suggest that there was an appropriate level of policing and stewarding was in place. But of course, there are lessons to be learnt, and they will be looking into what happened on Sunday.
John Mason.
Well, I would associate myself, because from what I could see, the police and the stewards handled it well once the problems had started. But I think we have to look further. And I mean, my colleague James Dornan has frequently raised the issue of strict liability. And I really wonder if the government would not consider that. I feel they have dragged their heels over this over the years. Fans don't want it, the clubs don't want it. But surely, as in European competitions, the clubs should take some responsibility for the behaviour of their fans.
Minister.
Thank you. Yes, so our preferred solution has always been that football proactively shapes and delivers a robust and meaningful solution to tackle this unacceptable conduct by supporters. Solutions have been made from the clubs over the last year on pyrotechnics, for example, and the misuse of them. And I know the SPFL are taking a really strong stance on this, and they've been instrumental at looking at how we strengthen the FBOs, especially with pyrotechnics, over the last couple of years.
George Adam.
Thank you, Presiding Officer. The behaviour we saw after Sunday's match between Celtic and Rangers was completely unacceptable. But does the Minister agree with me that all fans, as the vast majority of them already do, must exercise personal responsibility to ensure that those around them can enjoy the game safely, and that football clubs also need to take some responsibility for the behaviour of their own fans?
Minister.
Yes, thank you. Of course, just as everyone has a responsibility to behave appropriately and in line with the law, no matter where they are, just because you're at a football match does not mean the rules of society or the rule of law are not in place. And no one should feel that because they are in a stadium on a match day, that this somehow gives them permission to act in ways that they would not in other parts of society. There is clearly a minority of those who attend football matches who believe that they can behave in any way that they want, and no thought to the safety or the security of the vast majority of fans who go to the matches to support and to enjoy watching their football team. But for the minority of fans that do behave illegally and irresponsibly, Action will be taken by Police Scotland and should be by the clubs.
And Graeme Simpson.
Thank you, Presiding Officer. I thought the scenes at the match were absolutely horrific, and it wasn't just the pitch invasion. You know, we've seen scenes of fans bursting through a disabled access point. There was vandalism at the ground. Innocent people got hurt, and then we had the pitch invasion by masked yobs, wearing balaclavas and what appeared to be uniforms. Ultimately, could I ask the Minister if she plans to speak to both of the clubs, because I think there is an issue here about the way clubs allocate tickets, both to home and away fans, and maybe that's what should be addressed.
Minister.
Thank you. Yes, so as I said, I have spoken to the SFA and the SPFL this morning. The SFA did confirm to me this morning that they would be speaking to both clubs to establish the facts regarding the events on Sunday, and I am keen to let that process play out. The SPFL has confirmed, and it will also be part of the judicial panel process as well, so I don't want to interfere with that. The SPFL has confirmed it is considering very carefully its scheduling of the remaining Old Firm fixtures in consultation with Police Scotland, and the Scottish Government does speak to both organisations very regularly, and we will continue to do so on this issue. But as the member says, the behaviour of invading the pitch, engaging in violence and setting off throwing pyrotechnics and vandalism is appalling and completely unacceptable.
Thank you. That concludes topical questions. The next item of business is consideration of business motion 21024 in the name of Graeme Day on behalf of the Parliamentary Bureau, setting out a timetable for the Stage 3 consideration of the Assisted Dying for Terminally Ill Adults Scotland Bill. I ask any member who wishes to speak to the motion to press their request to speak button, and I call on the Minister to move the motion.
Move, Presiding Officer.
Thank you. No member has asked to speak to the motion. Therefore, the question is that motion 21024 be agreed. Are we all agreed? Yes. The motion is therefore agreed. The next item of business is Stage 3 proceedings for Assisted Dying for Terminally Ill Adults Scotland Bill. In dealing with the amendments, members should have the bill as amended at Stage 2, that is Scottish Parliament Bill 46A, the marshalled list and the groupings of amendments. The division bell will sound and proceedings will be suspended for around 5 minutes for the first division of the Stage 3. The period of voting for the first division will be 30 seconds, and thereafter I will allow a voting period of 1 minute for the first division after a debate. Members who wish to speak in the debate on any group of amendments should press their request to speak button or enter RTS in the chat as soon as possible after the group has been called. Members should now refer to the marshalled list of amendments. We move to Group 1, Meaning of Terminal Illness. I call Amendment 136 in the name of Daniel Johnson, grouped with Amendment 1. Daniel Johnson to move Amendment 136 and speak to both amendments in the group.
Thank you very much, Presiding Officer. And it's with quite a great deal of trepidation that I rise to speak to move the first amendment in the first grouping of this. And can I begin actually by paying tribute to Liam McCarthy in the way that he has stewarded this bill through Parliament. This is not an easy topic, and it's one that I think everyone in this chamber is considering with a great deal of care. And it's why I have brought forward these amendments regarding the definition, and with a view to both tightening the definitions, improving the clarity of their scope, and providing clarification. And they're very much in addition to the existing provisions within the definition, rather than providing alternatives to them. Because I believe that Parliament has a choice about what kind of bill it wants this bill to be. Do we want it to be something that simply is about enabling an act, making it possible as straightforwardly as possible, and that is an absolutely valid view, or is it a bill that we wish to provide a dispensation in very particular and very precise circumstances? And my view at Stage 2, the committee undertook its work diligently, but the view seemed to be much more of the former rather than the latter. And as someone that voted for this bill at Stage 1, because I believed in the principle, I'm very much of the view that if we are to progress, we must progress with caution, which is why we need clarification, particularly around what is meant by terminal and progressive. In my view, that currently, as it stands, that it is open to interpretation, which is why in Amendment 1 I provide expanded definitions that provide greater clarity. But over and above this, I believe that simply a terminal and progressive condition that is likely to shorten one's life is not sufficient condition in order for us to extend this possibility. That in addition to this, that somebody must be approaching the end of their life, and I'll deal with that in the next grouping regarding 6 months, but also that their condition that they find themselves is intolerable without possibility of improvement. Very happy to.
Martin Whitfield.
I'm very grateful to Daniel Johnson for taking the intervention. I have great interest in the amendment that he's brought forward for the reasons that he's already set out. But does he share my concern that we're ending up with a subjective test that sits on top of what previously have been in the main objective assessments that would be the same? Could you deal with that matter?
I'm happy to deal with it. I actually disagree with that, because I believe that we have to be frank that all of the decisions and judgments that we are asking professionals to make in the course of this will be subjective. There is no possibility of true objectivity. We could set some standards, expectations, values, conditions, but ultimately what this will boil down to is doctors and other medical professionals making judgments based on their experience and their knowledge of the person, but those will be subjective judgments. And all we can do is ask for qualifications and conditions of those. And much was made of international comparison through stage 2. And I think it's important to note what international comparison tells us of this. I will give way to Patrick. I think Patrick Harvey was first.
Patrick Harvey.
I'm very grateful. I wonder if Daniel Johnson would simply give us a little bit more about his reasoning for choosing the form of words in the second of the 3 bullet points at the end, the condition that treatment that can relieve or improve the condition is no longer providing relief or improvement. It seems to me that this implies that a treatment which provided even the most marginal, barely registrable improvement, if it provides that improvement even at a theoretical, very marginal level, this would rule out the individual from being able to make their own choice. Surely it's for the individual to decide whether it provides sufficient improvement to change their mind.
Daniel Johnson.
I thank the member for that intervention, and he makes a fair point, but I would also argue that without this, that if there is the possibility of a treatment that improves the person's condition, do we want to allow them to proceed? Because I think there is a question that somebody could have a terminal condition, be at the end of their life, but actually have a good quality of life, have that possibility. And I think we need to ask ourselves whether we think that in those circumstances that is appropriate. And indeed, I just draw people's attention both to New Zealand legislation and the Australian Capital Territory legislation, both of which provide similar conditions. Both the New Zealand legislation and the Australian Capital Territory, those additional qualifications of whether or not someone's condition could be improved by treatment and that they're approaching their end of life are both present in the way that those legislations are set out. So I think it's important that when we are making those international comparisons that we're clear about what they make. Very happy to give way.
Jamie Hepburn.
Just briefly, I think we'd all be drawn to the notion of or certainly I'm drawn to the notion of intolerable suffering as a criteria, but clearly we're doing more than just legislating for a form of words. It has to have legal interpretation. I see when there is an attempt to do that, Mr Johnson's referred to legislation from other parts of the world, but I just wonder if there's anything that can be drawn from legislation or from law here in Scotland where this notion of intolerable suffering or some suffering intolerably can be drawn from it. Is there anything else in Scots law?
Daniel Johnson.
I would simply draw on the legislation comparisons, both of which have either similar or very comparable forms of word, but I would also argue that the fundamental definitions here of both terminal illness and progressive are similarly ones that require legal interpretation. And I acknowledge that in many ways I would prefer this to have been further looked at. And indeed, I would argue much of this bill could deal with a great deal more deliberation and scrutiny. So just to the amendments as I have tabled them, 136 introduces the concept of intolerable suffering. And I would stress at this point that this is in addition to those other two conditions of terminal illness that is progressive. And then Amendment 1, which then provides the expanded definitions, because I do believe that there needs to be clarification, both for intolerable suffering, but indeed for the meaning of what terminal and progressive means. I think without those, we are simply relying, in terms of a definition, of 2 lines of legislation. And I would just note that it is considerably less than most of the international comparisons, if you choose to look at them, that are available in other jurisdictions. And with that, I move Amendment 136 in my name.
Thank you. I call Jeremy Balfour.
Thank you, Presiding Officer. And can I thank Daniel Johnson for bringing these 2 amendments this afternoon. I rise to speak with serious concern about this bill, particularly in regard to its impact on disabled people. For many disabled people, the debate around assisted dying does not feel abstract or theoretical, but feels deeply personal. At its heart, this legislation sends a deeply disturbing message that some lives, especially the lives of disabled people, are more eligible for ending than others. Many disabled people fear that the bill could make them feel implicitly that their lives are automatically considered illegible simply because they live with a disability. This is a message this Parliament must never, ever send. Supporters of the bill will point out that it is framed around terminal illness, not disability. And I see what Daniel Johnson is seeking to do with these 2 amendments. But the reality is that many who are terminally ill will also be disabled. And the line between the 2 can become blurred in practice. Disabled people in Scotland already face serious inequalities and barriers, higher rates of poverty. Yes, Mr McCarthy.
Liam MacArthur.
I'm very grateful to Jeremy Balfour for taking the intervention. We had some of these exchanges at stage 2, but I wonder whether he would reflect on the evidence of the detailed research carried out by Professor Bellen Colburn at Glasgow University, which indicated across all the international jurisdictions with assisted dying laws of this type, there is no evidence of a disproportionate impact on those within the disability community. Moreover, no detrimental impacts in terms of wider rights or perspectives of disabled people as a result of the introduction of these laws.
Jeremy Balfour.
Can I thank Mr McCarthy for his intervention? I have to say that is not the evidence that the disability community is saying to me. And that is not the evidence that is coming out loud and clear from those with lived experience, particularly within Canada and in parts of Australia. And I have to say I disagree fundamentally with the presumption that Mr McCarthy has put forward this afternoon. As I was saying, Presiding Officer, people with disability have higher rates of poverty, limited access to healthcare, social isolation, and at times a sense that society does not fully value their lives. Against this backdrop, the legislation risks compounding those pressures and subtly signalling that the lives of the most vulnerable are less worthy of protection. How we treat those with terminal illness and disability speaks volumes about the people and the type of society we are. And make no mistake, we will be judged by this. I welcome again what Daniel Johnson is trying to do, because we see in the House of Lords just recently, Lord Faulkner taking forward the bill in the House of Lords, saying these words on the 16th of January. Your financial position might be an element in what makes you reach a decision. He went on to note, the evidence from abroad is that if, as people from perhaps more financially secure circumstances who make the most sort of choice. His argument is assisted dying is framed around choice. But the implication is again disturbing, that difficult circumstances, poverty, vulnerability, domestic abuse might make assisted dying an option for some. Let me be clear, I believe that is outrageous and not the type of society I want to live in. Being poor or living with disability is not a choice, and it should never be used as a reason to facilitate ending someone's life. Many people have told this Parliament that their fear is not just overt coercion, but subtle pressure, the sense of being a burden, the worry about consuming scarce resources, the feeling that others might be better off without them. These pressures, let me tell you, are real, and legislation that treats disability as a factor in eligibility risks legislation with these fears. Let me be clear. We heard again from Daniel Johnson about legal definition and about it being clearer. And we all know that if this becomes an act, it will be interpreted by the courts over time, and even the safest safeguards could well be awarded by the courts. In conclusion, Presiding Officer, the measure of a society is not only how it protects autonomy, but how it safeguards those who are most vulnerable. If this bill passes, it will define us as a Parliament and define Scotland as a society by the way we treat those who are weakened, most at risk and often overlooked. We have a duty as parliamentarians to ensure that no disabled person ever feels that their life is conditional, less valued, or considered assisted suicide as a way that brings economic benefit. Every life must be respected and protected and affirmed without compromise. How we act, how we stand is a measure of the integrity and moral character of this Parliament and of our society, not just in the eyes of history, but in the judgment of the people of Scotland, and most importantly, the most vulnerable amongst us. Thank you.
Thank you. I call Pam Duncan-Glancy.
Thank you, Presiding Officer. And I'd like to say at the start, thank you to the member in charge of the bill for the way in which he has taken the bill through Parliament, and to other members for the way in which they've engaged in the debate. A very sincerely personal debate, and I know that members are taking the weight of these decisions very, very seriously. I'd also like to thank the legislation team who've done a power of work in getting us through many, many amendments, and of course Parliament staff for the time that they're going to be putting in to help us get through these amendments. Presiding Officer, as currently drafted, the bill defines someone as terminally ill if they have an advanced and progressive disease, illness or condition from which they are unable to recover and that can reasonably be expected to cause their premature death. That definition is, as my colleague Daniel Johnson has pointed out, incredibly broad. It includes many disabled people. Indeed, as I said at stage 2, it could include me. And I recognise that amendments in this group try to provide greater clarity, but I don't believe they resolve this fundamental issue. The provisions in them are highly subjective, and I acknowledge that the member who's put them forward recognises this, but I want to talk briefly about why that is important. People's experiences and their views about what they can live with change over time. They are shaped by the society in which we live, as well as our views of ourselves. Absolutely everything I have, I've had to fight for. I had to fight to get overnight care so that I could go to the toilet because the council had said it would be cheaper for me to use incontinence pads. That fight, in particular, nearly broke me. I was ill, I was crying daily, and the pain from my advanced stage arthritis, which will likely result in early death, got worse because I was worn down fighting. I'm one of the most empowered disabled people in the country, one of 129 people who has the privilege of sitting in this place. And I have been broken by how hard it is to live like everyone else, or to try to live like everyone else. Even when pain is intolerable, it is the everyday ableism and discrimination that makes me feel like I can't go on. When I have the support I need, when I'm not fighting, me and people like me can live well. We can thrive. We believe life is at that point tolerable, well worth living even. And we believe this in circumstances even when others don't think a life like ours would be worth living. And so I want to take a moment to talk about the views of other people and tolerating loss of function and why this is also a complex and subjective concept. People often portray the lives of disabled people or people who have lost function as intolerable. Paralympian Tanni Gray-Thompson, who members I'm sure will have had the opportunity to meet recently, was told by someone that they would rather be dead than incontinent as she is. They said this to the Paralympian while she was sitting in our House of Lords. People question how people live with loss of function, how I cope, for example, on a daily basis. They feel it is acceptable to assume that a life like ours would be intolerable and not worth living. People question this regularly. Presiding Officer, someone has to shower me. Someone has to take me to the toilet and help me in the toilet. Someone has to do almost everything for me. Many people find this undignified, and they're not afraid to tell me that. And on occasion, it can be like, for example, if I have no care or the toilet isn't accessible, it can be quite undignified. But the point I'm hoping that I am making here is that I have learned to live with the good, the bad, and the ugly of my life. And that doesn't mean I'm not scared of loss of function, as everyone, I imagine, is. Of course I am. The little function I have left, I want to keep. And I'm worried about what would happen if I didn't. But I have seen people face adversity on a daily basis, overcome it, and enjoy life. With the right support, people can lead great lives, despite otherwise intolerable pain or suffering. What is intolerable to me has moved over time and might not be tolerable to someone else. If help aids adaptations, significant care from another, the inability to use the loo or shower by ourselves are circumstances that could be interpreted as indicators that someone's life has become intolerable, we must be very cautious about the message that that sends. And we know that disabled people's quality of life is often viewed as being lower by others. When we ask people to rate their quality of life, even in very difficult circumstances, disabled people often rate it higher than the professionals may rate it in their lives. And I think that's an important fact for us to remember when we're considering the very detail on this piece of legislation. Happy to take the intervention.
Martin Whitfield.
I'm very grateful to Pam Duncan-Glancy for taking the intervention, and I have to say, from a personal point of view, these amendments I swing roundabouts with. But having listened to the member's very powerful contribution, would you say that the fear of that sort of unintentional reinforcement by the other of an assumption about your quality of life really challenges the wording that's been chosen in this amendment when we look at the human rights basis that we have, or even the Promise Bill, which will come before this Parliament next week, that actually the choice should be to try and give dignity and autonomy without that prejudice?
Pam Duncan-Glancy.
I thank the member for the intervention, and he gets to the heart of why I am concerned about the amendments that I think have been drafted with good intention, and I fundamentally believe that, and I can see what the member is trying to do. But an individual's subjective view of tolerability and suffering at any one time can change, and so too can the view of someone else of that other person. It's a very difficult objective test to have, which is why the amendments in this group, I think, will not give the safeguards that I think the member is seeking to give, or indeed that are required to make the bill less of a risk. So we know that disabled people's quality of life, and people too, sometimes at the end of life, and people who have lost function, is viewed by others as being lower than they would rate it themselves. And we cannot therefore rely on this as an objective measure to consider the bill or indeed assisted dying to be safe. It is this subjectivity of quality of life and all of that that makes the well-meaning amendments in this group, I think, impossible safeguards. And so I would ask members to think very carefully and see that these additions look to be adding protections, but that they are fraught with difficulty and still leave many, many people at risk. Thank you, Presiding Officer.
Thank you. I call Jackie Bailey.
Thank you, Presiding Officer. I listened carefully to Daniel Johnson as he moved his amendments, and there is concern that this expands rather than restricts the definition of those who would be considered as eligible for assisted dying, which I understand is not his intention. But I wanted to share an email from a constituent about his sister, and this is what he had to say. My sister is in a nursing home in Helensburgh, and I have power of attorney for her, so I speak on her behalf. She has had a severe form of psychotic depression, which has caused her much suffering for nearly 45 years. She has been near death at least once from refusing food and drink. She can be strongly influenced by outside suggestion. However, the last 8 years have probably been among the happiest of her life. Previous to that, advice as to assisted suicide would have at times been accepted by her, and I think if she had lived in Canada or Holland, she would now be dead. I am concerned that she would fit into the definition set out by Daniel Johnson, and I would be grateful for his comments when he sums up.
Thank you. And I call the Cabinet Secretary.
Presiding Officer, I would like to set out to Parliament the Scottish Government's position for Stage 3 of Liam MacArthur's Assisted Dying for Terminally Ill Adult Scotland Bill. The Scottish Government continues to remain neutral on this bill. We also consider that we have a duty to assess the technical, legal and deliverability implications of amendments as to whether the bill is workable in practice if passed. We therefore published a commentary on some amendments at Stage 2 and published a similar document on Stage 3 amendments yesterday. This approach reflects the Government's neutral position as we provide no comment on ethical matters. That is for MSPs to decide upon. However, we do think members should be aware where there are implications for deliverability or the public purse in relation to some amendments being passed and part of a final bill if passed. It is therefore my intention to speak only in relation to amendments where the Scottish Government has identified potential issues around legislative competence or significant legal or deliverability challenges, including where it is felt that amendments will have major financial implications. In relation to some amendments, I will speak to where there is already Scottish Government work in progress. I will also speak to my own amendments lodged in consequence of the Section 30 order that was approved by this Parliament last month. Presiding Officer, as Parliament is aware, it is the view of the Scottish Government that the bill in its current form is outside the legislative competence of the Scottish Parliament, and there is a responsibility to maintain the integrity of the devolved statute book. Therefore, in respect of the Stage 1 vote and the wishes of this Parliament, and in recognition of the fact that the Scotland Act order process is intergovernmental, I committed to engage with the UK Government to try to address the legislative competence issues identified. That engagement has taken place in good faith, and the amendments lodged by me and some that I have provided to Mr MacArthur are the outputs of that. For my part, I have lodged amendments I deem necessary and consequential to the Section 30 order that has been agreed by the Scottish and UK governments to cover the identification and regulation of substances and medical devices for use in assisted dying. I am of the view that Section 18 should be removed from the bill in its entirety, as the provision may relate to the H1 employment reservation and possibly to the G2 regulation of health professions reservation. Likewise, I am of the view, I will do in a second, likewise I am of the view that the training provisions in the bill should be removed, as they may relate to the G2 reservation. I'll give way to Ross Greer.
Ross Greer.
Thank you. And it was on the Cabinet Secretary's last point there that I just wanted to intervene, because in the letter from UK ministers to the Westminster Scottish Affairs Committee, the phrase training, qualification and experience and qualification and experience are used interchangeably. It's the view of some outside this place, including a number of organisations who have engaged extensively on this bill and have sought legal advice, that training is not subject to those reserved matters, even though they acknowledge qualifications and experience are. I wonder if the Cabinet Secretary could detail a bit more why the Scottish Government believes that training is covered by that reserved matter, because that certainly wasn't my understanding before we began dealing with this particular bill.
Cabinet Secretary.
Presiding Officer, I appreciate the interventions from Ross Greer. At this stage, I can only say that provisions within this bill may or could
be out with the competence of this Parliament, because ultimately that would be a decision for the Supreme Court to take. I have set out the Government's position of those areas where we feel it is beyond our legislative competence, and I will speak to those issues as we go through the bill. As I will come to in a second, the UK Government has also published its approach to the negotiations around Section 104 to come after the passing of this bill, should it pass. And I'm happy to obviously liaise with Mr Greer or anyone else during the course of this bill as to where I am setting out issues of legislative competence. The provisions... I will give way to Mr Hepburn.
Just on the issue of the Section 104, we obviously have had sight of the letter that went to the Scottish Affairs Select Committee, which I know wasn't sent to MSPs directly. I think it should have been, but that's really an aside. The Cabinet Secretary has already set out that for those elements of the bill that relate to medicines, we're going to be able to deal with that by Section 30 order. Can the Cabinet Secretary set out what reasons the UK Government gave, if any, that this area couldn't have been dealt with through a Section 30 order rather than a Section 104 order? I think it would be much more preferable if it had been a Section 30 order process. Thank you.
Can I just, before the Cabinet Secretary responds, remind members that we will come on to these issues, and it's very important that we continue to focus on the issue in front of us at this moment?
Of course, President Officer. I think Mr Hepburn raises an important issue, because this is a point that I know is concerning MSPs around those elements that are to go through the 104 process. It would have been preferable for all of these issues to have been dealt with through a Section 30 order. I think that is clear. It's neater, given what we're wrestling with some of those elements of a 104 process. We did negotiate in good faith with the UK Government, and it was their position that the elements that are to be dealt with within Section 30 are within Section 30, and they were clear that they wanted the remainder to be dealt with through 104, and that will be for them to explain as to why that was the case. Presiding Officer, I feel it is important to set out the Government's approach to the bill and set out for transparency and clarity how we are approaching, or how I am going to approach on the Government's behalf, the proceedings over the coming days. As Mr Hepburn has already set out, the UK Government have agreed in principle to resolve legislative competency issues via a Section 104 order, and the UK Government has sent a letter to the UK Parliament's Scottish Affairs Committee confirming this, and the letter has been, I will do in a second, and the letter has been published by the committee. Should the bill pass, Scottish and UK Government officials will continue to engage on the final form of the order. I give way, I think finally, Presiding Officer, to Mr Kerr.
Concur.
Grateful to the Cabinet Secretary for giving way, but can he confirm that the Section 104 order means that part of this bill will be subject to secondary legislation?
Cabinet Secretary.
It depends on the vehicle that is decided upon as to how the 104 processes are to be delivered. So it is potentially through secondary legislation, it could be through other means. It depends on the vehicle that is negotiated on and the UK Government agrees to by negotiation after the course of this bill. Whilst competence is not a requisite requirement of amendments lodged to any bill in this Parliament, I would encourage members to consider our responsibility for ensuring that legislation is within its competence. As members are aware, there will be a gap between the Stage 3 amending part of the bill and the final debate and vote on the bill next Tuesday. Our intention is to again provide an assessment of the bill as amended ahead of that final vote. This will be as we have done at Stage 2 and Stage 3 amending stages, and provide commentary only on areas of legislative competence, legal or deliverability challenges and major financial implications. And with that explanation, Presiding Officer, I have no specific comments on the amendments within this group.
Thank you, and I call Liam MacArthur.
Thank you, President Officer. Can I start by echoing the comments from Pam Duncan-Glancy in relation to the way in which colleagues across the board, irrespective of their position on this bill, have engaged with it over the last 4.5 years. Can I also echo her thanks, not just to the legislation team, but to the Non-Government Bills Unit, who have been performing heroics, but also to my own team, who have been supporting me, but I know over recent days and indeed throughout this process have been supporting other colleagues and their offices in relation to this bill. Can I also reciprocate the very generous comments from Daniel Johnson by thanking him for the constructive engagement we have had on this issue throughout the process. As he has ably demonstrated, he may be able to lay claim to being the only member of this Parliament who's not only read the legislation from the Australian Capital Territories and New Zealand, but I'm fairly sure he's read New South Wales, Western Australia and Oregon as well. He's brought forward amendments at stage 2 and now at stage 3 that I think have enabled debate and allowed Parliament to take a view on some pretty key issues, and for that I am very, very grateful. I say all of this as a preamble to hopefully softening the blow of confirming that I can't support his amendments in this group. I remain of the view that the definition of terminal illness as set out in the bill is appropriate. Adding subjective terms like suffering intolerably in Amendment 136 is likely to add confusion. I think Jackie Bailey's concerns are probably valid in this respect too, perhaps illustrated by the attempt to then define it in Amendment 1. Advanced and progressive are terms well understood by medical professionals, as the Health Committee heard in evidence, and there are good reasons not to circumscribe them. I understand Daniel Johnson's intention. However, I'm concerned this definition includes the requirement that treatments are reasonably available and acceptable to the person, have lost beneficial impact. I acknowledge that this amendment places emphasis on what the person finds acceptable treatment. But the requirement that those treatments have lost beneficial impact means someone may wish to refuse treatment such as chemotherapy because they no longer find it acceptable due to the side effects. But given that the chemotherapy may still have a, quote, beneficial impact, they may not be deemed eligible for an assisted death. We may be requiring an individual to undergo invasive, risky medical procedures that they have made a conscious decision not to choose, something I know Daniel Johnson would not wish to see. On the inclusion of suffering intolerably, I am concerned that the definition is somewhat subjective and appears to be limited to physical pain. I take an intervention with Michael Maher.
I thank the member for giving way. I wonder if he would reflect on the evidence in the Royal College of Physicians and Surgeons of Glasgow, who have talked about just the issue of, in essence, the subjectivity of diagnosis, the amount of time that somebody can have if they are told that they have 6 months and that actually many of them will be alive 3 years later. I think there's a core question here relating to subjectivity and objectivity in diagnosis that we will deal with in future amendments, but I think it's key to this area as well, because actually the terms that he is using are equally as subjective according to these physicians.
Liam McCarthy. I thank Michael Mara for that intervention. I think I'd probably respond to that by saying the assumption that simply because somebody is going through the process, having made a request, that they would then inevitably and automatically seek to exercise that choice immediately after, I think is not borne out by the evidence we see in other jurisdictions around the world, where you go through a process, and it may well be that it's many months, possibly even years later, that you would seek to then follow through with that request. And at that point, there would still be the requirement to establish that capacity and consent is valid. So people's motivations are rarely singular, and symptoms they find intolerable at the end of life may go beyond pain, such as vomiting and fungating wounds. Physical pain is not always the primary concern cited by dying people. In jurisdictions where assisted dying is legal, the top 3 end-of-life concerns which are recorded by the doctor on behalf of the patient are loss of autonomy, being less able to engage in activities that make life enjoyable, and loss of dignity. Taken together, these amendments risk narrowing eligibility in ways that don't reflect the complex and deeply personal nature of suffering at the end of life, while potentially requiring individuals to undergo treatments they would have otherwise refused. Throughout, my policy has been that it should be for assessing doctors, with input from other professionals where necessary and supported by guidance under Section 23 of the Bill, to determine these aspects of the terminal illness definition. As we've heard during Stage 1 evidence, doctors are already making these kinds of assessments on a regular basis, and clinical judgment should prevail over fixed definitions. And on that basis, Presiding Officer, I ask Daniel Johnson not to press his amendments and urge Parliament not to support them if he does.
Thank you. I now call on Daniel Johnson to wind up and to press or withdraw Amendment 136.
Thank you very much, Deputy Presiding Officer, and can I thank everyone that has contributed to the debate in this briefing. There is a fundamental, I think, conundrum that we're all facing, in that at the moment we're being asked to ponder legislation whose key definition is simply that somebody has an advanced progressive disease, illness or condition from which they are unable to recover and that can reasonably be expected to cause their premature death. Save for perhaps that second last word of premature, that covers a huge range of conditions. One could, and I say this without any degree of glibness, that we all suffer from a condition that is progressive and is going to limit our lives. That is life. And there are a great number of medical conditions that do that. And without any other conditions, simply the prognosis or the diagnosis that someone has a condition from which they're not going to recover, that is likely to kill them, is sufficient for them to exercise the capacities under this bill just in a moment. And I think it is really important that we add some additional protections. And there's a sense of regret of mine that these amendments aren't being considered along with the amendments in the next grouping. Because to my mind, having a terminal condition, yes, is a necessary condition, but is not sufficient. I would, in my view, that it has to be that someone is not just has a terminal condition, but they are nearing the end of their life, and that the condition they find themselves is one that no other medical treatments can provide them satisfaction. Indeed, I think there's a range of other amendments we'll be discussing through the coming days, and making sure that those things are extended to people and ensured. And I think it's important to try and capture those as best we can in the definitions themselves. Happy to give way to
Liam MacArthur.
I thank Daniel Johnson. I mean, to some extent, and without wishing to have a spoiler alert, it sounds to some extent as if he's teeing himself up for amendments we're likely to come to very shortly around prognosis period, which I think speak to the very concern that I think he's quite legitimately articulating there.
Daniel Johnson.
So, just to deal with indeed, I do acknowledge that. Just to deal with the points raised, first of all, to Jackie Bailey, this is certainly not an expansion. And my reading of it, because of the "and" in this clause of the legislation, this is an additional requirement. This is not intolerable suffering instead of terminal illness or instead of its progressive nature. It's as well as. And I think that is very important. In terms of its legal clarity, I would point members to the definitions in both New Zealand legislation, where a person is eligible if they are in an advanced state of irreversible decline in physical capability and experiences unbearable suffering that cannot be relieved in a manner that this person considers tolerable. Or in the Australian Capital Territory legislation, they have been diagnosed with a condition that either on its own or in combination with one or more other diagnosed conditions is an advanced, progressive and expected to cause death, that they are suffering intolerably in relation to the relevant conditions, and then goes further to clarify that the individual is declined and not expected to improve, and that any treatments for the condition that are reasonably available and acceptable to the individual have lost any beneficial impact. That is what other benchmark legislation state, how they have defined it, and have done so unproblematically. So I believe that this amendment improves an additional requirement and clarification. And in addition to that, I do also believe that it is important to provide some clarification of what we mean by progressive and terminal. And just finally, can I thank both Jeremy Balfour and particularly Pam Duncan-Glancy for their observations. I think it's really important that we seek to tighten this legislation. I do not wish it to be the default, and most particularly, I do not wish it to be considered the norm, because as they both rightfully point out, struggle and suffering is actually a part of many people's daily lives. Indeed, one could argue it's a part of everyone's daily life. And therefore, understanding when this might constitute a threshold is incredibly difficult. And I acknowledge that it's difficult. I acknowledge the concerns that this may raise. But I would actually argue that if we're going to pass this legislation at all, we need to understand that we are dealing with matters of subjectivity. And I would urge members great caution in suggesting that we have objectivity. Ultimately, as I said in my opening remarks, we are going to rely upon the judgment of professionals and the ability of individuals to make decisions for themselves regarding what they find acceptable or not, and whether or not they wish to take this very significant decision for themselves. Subjectivity is at the very heart of it. And claiming that simply that the amendments introduce subjectivity, I think, is to somewhat ignore actually what the vast bulk of this legislation will ultimately do. But most importantly, I would like to say to Jeremy Balfour, I think he is quite right, and I don't believe this is the last time that we will talk about the possibility of judicial expansion. I am very worried that unless we define more tightly what we mean by terminal illness and progressive, and indeed I think that we put in some additional requirements about not just that the person has those things, but actually that those things are causing suffering, we potentially leave this open to essentially something that is ultimately discretionary. And so I think that that is important, that we provide those expansions, because I would also note that we have I think a short definition here, where many other pieces of legislation have far more substantial descriptions of the conditions that make an individual eligible. And with that, I close and move Amendment 136 in my name.
Thank you, Mr Johnson. The question is that Amendment 136 be agreed to. Are we all agreed? The Parliament is not agreed, and there will be a division. As this is the first division of this Stage 3 amendment stage, I will suspend for around 5 minutes to allow members to access the digital voting system. Thank you, members. We will now restart proceedings, and we will now proceed with the division on Amendment 136, and members should cast their vote now. The vote is now closed. Thank you. The result of the vote on amendment number 136 in the name of Daniel Johnson is yes 8, no 111. There were 3 abstentions. The amendment is therefore not agreed. I now call amendment 1 in the name of Daniel Johnson, already debated with amendment 136. Daniel Johnson to move or not move?
Not moved.
Not moved. We now therefore turn to Group 2 on eligibility to be provided with assistance. I call Amendment 2 in the name of Daniel Johnson, grouped with amendments as shown in the groupings. I point out that if Amendment 161 to be debated in Group 7 on assessments, including supportive of terminally ill adults, is agreed to, I cannot call Amendment 162 by way of preemption. I call on Daniel Johnson to move Amendment 2 and to speak to other amendments in the group. Mr Johnson.
Thank you very much, Deputy Presiding Officer. And I do assure members that I'm not going to be speaking at the beginning of every single grouping. Just so happens that I got my amendments in early and in these sections. And nor do I intend to rehearse much of what I said in the previous grouping, because I think much of the logic applies to the amendments that I have within this group, Amendments 2, 316 and 322. In my view, I think we do need to tighten the scope of this through the definition and through Amendment 2. What I seek to do is to narrow the eligibility for accessing assisted dying to those who are reasonably expected to live no more than 6 months. Now, I think what is important here is that what I am attempting to capture here is not about an accuracy of prognosis. It's about that principle that this is to be something extended to people at the very end of their life. One of my fundamental problems, especially after consideration stage 2, was that, in my view, looking at the definition as it stands, that simply having a terminal and progressive condition was sufficient as the bill was drafted. And that could mean that you could receive that diagnosis, have it deemed to be progressive and irreversible, and have many years left to live, maybe even decades. And that simply is not what I would consider acceptable. To my view, if this bill is to pass, it must be a narrow bill for exceptional circumstances when all other options are exhausted, and it has to be at the end of life. I'm very happy to give way to the Deputy First Minister.
Deputy First Minister.
I'm grateful for the member taking an intervention. I'm very conscious of the argument that he puts forward there. I've been very struck by the work of Dr Scott Murray, the palliative care doctor, who had said just recently in the Times that evidence from palliative care, primary care and prognostic research paints a very uncertain picture of the impossibility of making a prediction that somebody only has 6 months left to live. He writes that predictions are highly unreliable, and with modern treatments forecasting, this is largely guesswork. Wonder how he squares the sort of appearance of a safeguard of 6-month prognosis with the reality that doctors say, particularly palliative care doctors say, that their experience is that is very uncertain.
Daniel Johnson.
Look, I thank the Deputy First Minister for raising that, and I note the concerns made both by the individual that she cites and indeed others. And I think if we are considering this and consider passing it, we need to understand what we're passing. And it is not about forecasting, and it certainly can't be about accuracy. We are dealing with matters that are inherently uncertain. But what we are saying is that for what individuals and what circumstances do we want this to be considered? Do we want this to be considered at any point in someone's life simply by virtue of having a terminal condition that is progressive and irrecoverable? Or do we want to say that this is something that we essentially want to reserve for those who we think are very likely to be in the final section of their life? In other words, what this amendment seeks to do is, rather than about providing the accuracy or providing a threshold, it provides a yardstick. We're saying that this is something that we wish to extend to those whose life is measured in months rather than years. And we have to acknowledge in so doing that this is an imperfect measure. It is a fallible measure, but it is simply the best one, I think, available to us, and one that is used elsewhere. Very happy to give way to Meg Chapman.
Michael Chapman.
I thank Daniel Johnson for giving way. I'm interested, I suppose I've got two questions. Why 6 months and not 12, for instance? And also, what if somebody has multiple conditions, maybe a terminal illness alongside something like dementia, that might mean that within that 6-month prognosis they will no longer be of capacity to make this decision, but would want to make the decision while they still can, which is out with that 6-month period?
Daniel Johnson.
I think the member makes a fair point, an important point, and we're dealing with complexities. I think one of the things we may all need to accept and wrestle with, that this is something that, because of its serious nature, because of the requirements of the decision-making, may not be available to all people. And I think that is something probably all members will need to understand, that because we have to have thresholds, we have to have standards, and that might well mean that we exclude some people. And so I acknowledge the problems. She asks, why 6 months? And I think that it is just simply the best way of capturing the intent that I think is important, that's available to someone in the final stages of their life. And also it is a threshold or a measure that we see actually used across a great deal of other similar pieces of legislation in other jurisdictions. I'm happy to go again.
Michael Chapman.
I thank Daniel Johnson for giving way again. He said in response to my question that we need some cut-off, and you did use the word. He did use the word threshold, and yet earlier had said this isn't a threshold; it is simply a yardstick. And so I'm a little bit confused as to how definitive the member thinks the 6-month yardstick or threshold or prognosis actually is.
Dan Johnson.
Well, with the way that it's drafted, it's certainly not definitive, because it talks about reasonable expectation of 6 months. And that reasonableness is a concept that we use and invoke across all manner of areas of legislation. I know Brian Whittle, and I will give way in a moment. Is this a threshold? No, it's not. I'm saying that there are other thresholds that exist within this legislation, whether it's in terms of capacity, in terms of age, in terms of ability to take the substance themselves. We have a great deal of other thresholds, and I think that we just need to acknowledge that we have those in there. I know, Alistair, I think Brian Whittle was seeking to intervene first. Very happy to give way to Brian.
Thank you. Very grateful for Daniel Johnson for giving way. I listen with great interest to what he has to say, but I wonder if he would agree with me that whatever we pass, if we pass something, it cannot be open-ended. And by saying 6 months, that doesn't necessarily mean whoever tries to access assisted dying accesses it at that point, but within the 6 months. But we cannot have an open-ended timescale in legislation like this.
Daniel Johnson.
I'm quite happy to give way to Alistair Allen if you'd like to intervene.
Alistair Allen.
Member for giving way. I appreciate the motives behind the amendment that the member is putting forward. I just wonder if he has a view on how courts or others would be expected to interpret the 6-month rule. One of the ways that has been used for interpreting it in the benefits context has been, would you be surprised if this patient were alive in 6 months? And Marie Curie has found that as a measure has perhaps an error rate of 46%. So I don't doubt why the member is putting this amendment forward, but does he accept there are multiple ways of assessing the criteria he's established?
Dan Johnson.
I do accept that, but for the reasons that I think Brian Whittle gave, I think it is very dangerous to pass this legislation in a completely open-ended manner. I think what the 6-month does, or provision does, is state that essentially we are wishing this to be used by those in the final stage of their life. And it is indeed something that courts in other jurisdictions have been able to interpret. And indeed, at stage 2, it was discussed about whether or not this was something that was prevalent. And if you look through recent legislation, whether that be in Colorado in 2016, which has a 6-month criterion, the Victoria legislation in Australia, 12 months, likewise Hawaii, New Zealand, 6 months, various other areas of Australia. The jurisdictions which do not, I think, are in the minority in terms of the legislative passed recently, and indeed even the Australian Capital Territory, which was used an example of somewhere that does not. And while it does not use 6 months explicitly, it does have a stipulation that those to be eligible must be nearing the end of their life. Now, that is always going to be a difficult decision, but courts in other jurisdictions have been able to interpret this criterion. But most importantly, what it does is say that we wish this only to be used in those final stages. And just finally, and just to Maggie Chapman's point, and I'm glad Brian Whittle I think intervened, because I think many of his amendments coming in later stages about advanced care directives are really important in terms of having that clarity of intent about future conditions, because we are dealing with people whose capacity may vary. And this isn't about essentially making a decision at that time. And I think in conjunction with some of the other amendments that we were considering either today or in following days, this is a useful, as I say, yardstick or measure by which we want to define who it is that we want to say qualifies to use these possibilities set out in this bill. And with that, I move Amendment 2 in my name.
Thank you, Mr Johnson. I now call on Stephen Kerr to speak to Amendment 137 in the name of Sue Webber and other members of the group. Mr Kerr.
Presiding Officer, Sue Webber cannot be here to speak to her own amendments, 137, 318, 324, so she's asked me to present her remarks to the Chamber, which I do gladly. These amendments deal with a serious omission in the bill: what happens if a woman seeking an assisted suicide is pregnant. Whatever members' views may be on abortion, pregnancy raises profound legal, medical and ethical questions that the bill simply does not answer. Because in those circumstances we are not dealing with one life alone. There's also the life of the unborn child. That alone makes this situation fundamentally different from the rest of the bill. The problem becomes more acute when we consider the question of viability. In Scotland, a pregnancy beyond 24 weeks is legally understood to involve a viable child. Yet the bill provides no clear guidance about what should happen if a woman who meets the eligibility criteria seeks an assisted death at that stage. Would the law allow a doctor to prescribe a lethal substance, knowing it will also end the life of a viable unborn child? Would clinicians be expected to proceed even where the pregnancy is well beyond the point at which abortion would normally be permitted? The bill is silent. And that silence is not a minor oversight. It's a fundamental gap in legislation dealing with matters of life and death. Without clarity, doctors would find themselves placed in an impossible position. I give way to Emma Roddick.
Emma Roddick.
Very grateful. I'm interested here because the amendments proposed, of course, also don't differentiate between prior to 24 weeks and post 24 weeks. Why is that? And could the member explain a little bit more about the justification for, presumably, we would have to test women who are seeking assisted dying to see if they are pregnant? To force somebody who's terminally ill and close to death to go through an abortion before they do that seems to be quite inhumane.
I don't think that's what Sue Webber's amendments are suggesting. I think the amendments as drafted capture all women who are pregnant for the reasons of the lack of clarity in the bill in relation to the subject in total. So as I was saying, without clarity, doctors would find themselves placed in an impossible position, asked to facilitate an assisted suicide for a pregnant woman while knowing that doing so could also end the life of her viable unborn child. And when the law places doctors in an impossible position, it is usually a sign that the law itself has not been properly thought through. This is not a purely theoretical concern. Serious illness during pregnancy does occur. Medical research suggests that cancer arises in around 1 in every 1,000 pregnancies. While not all such cases would meet the bill's definition of terminal illness, some clearly would. And if the bill cannot explain how the law would operate in one of the most ethically complex situations imaginable, then the legislation before us is not ready. My colleagues' comments seek to provide clarity by making explicit that a woman who is pregnant would not be eligible for assisted suicide under this bill. Where legislation fails to confront questions of this gravity, we risk passing not careful law, but bad law. And for that reason, I ask colleagues to...
Liam Kerr.
I'm very grateful. I'm listening very carefully, and I just wonder if the member might actually respond to the point that I think Emma Roddick was making, that the Sue Webber amendment specifically just says are not pregnant, but the member has confined himself to talking about at 24 weeks as a crucial part. But he didn't answer the challenge that Emma Roddick posed, so I wonder if you might do so now.
Liam Kerr.
I think what I've tried to do, and I think what Sue Webber is trying to do, and I recognise in taking on this intervention from Liam Kerr, and my learned colleague, what I think Sue Webber, in her remarks and my remarks, trying to make clear is the doubtful nature of the law that would be passed if we do not identify the issue of pregnancy as a consideration. Hence, the very simple amendment that's been put forward by Sue Webber. I give way to Rhoda Grant.
Rhoda Grant.
I'm just a little concerned about the precedence that this would set, because we know the case is that if someone is suffering from an illness that requires medication and that they're pregnant, that is a decision for the woman to take, whether she has that medication that could damage the unborn child, or indeed while she refuse that medication. And this seems to me that is taking the choice away from the woman, and I think this is maybe somewhere this bill doesn't want to go.
Liam Kerr.
Well, the nature of the amendments covers the viable pregnancy, the viable other life, which in Scots law is recognised. So I'm not entirely sure that restricting, as Rhoda Grant has done, her view to simply the issue of a pregnancy before 24 weeks is the right approach. Because what my colleagues' amendments seek to do is to create the clarity in law that would be required about a woman who is pregnant, and therefore, with these amendments, would not be eligible for assisted dying under the bill. I give way to Rachel Hamilton.
Rachel Hamilton.
Does the amendment mean, again, to clarify a question from Emma Roddick, that a pregnant woman who is in a palliative state would have to take a pregnancy test, or indeed any other person who was possibly someone who identified as a woman but was perhaps a 90-year-old man, then have to also take a pregnancy test if they were palliative?
Stephen Kerr.
That is an incredibly hypothetical scenario. A 90-year-old man portraying himself as pregnant, I think, is stretching the point, if I may say, to Rachel Hamilton. I think the actual amendment is actually very clear, it's very straightforward, and it deals with women who are pregnant. And these amendments from Sue Webber arise because the bill as it stands fails to confront the question, which is a grave question. Happily give way to Jamie Hepburn.
I think the fundamental point people are trying to strive at, though, is presumably the inverse of demonstrating that a person's a woman is pregnant, would they have to demonstrate that they are not? And the only way they could do that is by demonstrating they've taken a pregnancy test. This introduces a whole area that I don't think we even expected to go into in terms of this legislation.
Stephen Kerr.
I'm sorry, but if someone is receiving medical treatment, I think it will be very clear to the doctors that are treating them whether or not that person, that the woman is pregnant. So I think, again, we're reaching beyond the very straightforward nature of a clarification in law that these amendments seek to produce. And for the reasons that I've outlined, and I'm grateful to all of my colleagues who have intervened on these amendments in the name of Sue Webber, I would ask colleagues to support Amendments 137, 318 and 324.
Thank you, Mr Kerr. I now call Douglas Ross to speak to Amendment 138 and other amendments in the group. Mr Ross.
Thank you, Presiding Officer, and I'll speak to the 3 amendments in my name in this group. At present, the bill only requires a doctor to inform a patient that they can be referred for a palliative care assessment. And I quote the relevant section of the bill, section 7(1)(b)(4), which states that this assessment would explore whether any additional support could be provided to them. For those at the end of their life, that is simply not enough. My Amendment 138 goes further. It ensures that a person is only eligible for assisted dying if they have been offered and actually have access to a fully funded and costed palliative care pathway specific to their individual condition. It is, I will give way to Emma Roddick.
Emma Roddick.
Grateful to the member. Just a very brief clarification. I agree with the amendment in principle. I think it's really important, but I'm just curious why the plan would be fully costed and why that information would go to the patient. It just seems an unnecessary burden to them.
Douglas Ross.
I think it's to provide that reassurance, because there are people at the moment, and I'll come to later amendments during the process of this bill, who do not have access to the palliative care they clearly require and seek because of location, geography and otherwise. And I think having that available to the patient is very important to them to be able to see that at the point that they are seeking that further help and support. And I go on to say that I do think it's unthinkable. Could I give way in a moment, if that's okay for Ross Greer? I do think it's unthinkable that anyone should feel pushed into ending their life early because they cannot afford or cannot access the care that they need. And if this bill truly values individual care and autonomy, then that choice must exist in reality, not just as a theoretical option. And I'll give way to Ross Greer.
I'm grateful to the member for taking the intervention. Like Emma Roddick, I sympathise with the outcome that he's aiming for here, but I'm concerned about this phrase around fully costed, and that it might have the opposite impact to what Mr Ross is proposing, and that it might actually make the patient feel like a financial burden on society. And I would ask him, in reference to Bob Doris's Amendment 23, does that not reach the same outcome that Mr Ross is aiming for, but without the potential disadvantages of using that phrase fully costed?
Douglas Ross.
I am listening to members' concerns about the term fully costed. I don't share the same concerns as they do, and we do have an option. Members can support my amendment, Bob Doris's amendment. I would actually like to know, if I'm ever in this situation, I would like to know that the work has been done to ensure that the costings have been fully sought, fully understood, fully laid out, and it's clear to everyone. And that's why they're included in my amendment. But there are alternative amendments that people can look at with this bill. I'll give way to the Deputy First Minister.
Maybe I was misreading it, but I had read that line as being that it was essentially a fully resourced palliative care offering rather than providing the accounting details to the patient. And I wonder too if the member, in terms of the reason for this, was struck by the research from Marie Curie last week, that I know Miles Briggs took a particular interest in, just around the need to ensure that there is that universal equity of palliative care. Otherwise, people might feel more inclined to opt for a relief of their symptoms rather than get the palliative care that they need.
Douglas Ross.
Yes, and I'll come on to that in Group 18 when I speak to my amendments on this issue. But I think the briefing that we got from Marie Curie on this issue was very important. But I do accept what Emma Roddick and Ross Greer and the Deputy First Minister said. You can read this in different ways. I tried to say in my response to Emma Roddick that it was to ensure that people actually get the palliative care that they should get. If Ross Greer reads that in such a way that it's almost a bill above someone's head that could then maybe prevent them seeking to get that, then that's his interpretation. But my view was the view of the Deputy First Minister. By including that, it is to ensure that people get the care they need. But there are some individuals who would want to know the cost of that care to be able to go forward in that way. Now, I'll give way to Bob Doris.
Bob Doris.
I thank Douglas Ross for giving way. We'll turn to some similar amendments in Group 7 and my name referred to by Ross Greer. I'm just wondering, under the provisions in your amendments, Douglas Ross, what would happen if the person is adamant they don't want to explore further palliative care options? Could they opt out of a further palliative care pathway? Would that then debar them for going forward with assisted dying, or could they still go forward with assisted dying? I give no view either way, just for clarity, what the effect would be of the amendment.
Douglas Ross.
Well, we simply cannot force someone to do something they don't want to do. So if they choose not to hear or to consider or to accept the points made about palliative care, that is a choice and a decision they have made. But by putting it into the bill, it is providing them that opportunity. And for the maybe one person that doesn't want it, there'll be 99 others that at least should have that information presented and made available to them. And I think we should ensure that this bill, if it is passed, it is robust as possible, that people get the palliative care that they need. Because I believe, Presiding Officer, that people shouldn't be presented with a voice choice, forced between unimaginable suffering and premature death. The Government must ensure that palliative care is fully funded and accessible, so that those facing terminal and debilitating illness can receive expert support, pain management and holistic care. As the Scottish Partnership for Palliative Care notes, the desire to hasten death can often disappear when the right care is available. Moving to my Amendment 143, I believe this strengthens informed decision-making by requiring that a first declaration includes a written statement from the patient confirming that they understand the nature and the scope of palliative care and the pathway that is offered to them. Patients must know all of their treatment options if assisted dying is to be offered at all. Without this, the bill risks fundamentally undermining the patient-doctor relationship and the integrity of our NHS. Moreover, mental health support cannot be overlooked. Amendment 139 in my name would require that those seeking assisted dying are offered psychological counselling and have not been treated for suicidal thoughts or self-harm. Without this, individuals whose autonomy is already compromised by depression, PTSD or other mental health issues and conditions could be funnelled towards a premature death instead of receiving the support they truly need. I'll give way to Maggie Chapman.
Maggie Chapman.
I'm grateful to Douglas Ross for giving way. I'm curious in the second half of Amendment 139 that people not having previously been screened or treated for suicidal thoughts or self-harm. There's no timescale on that. So somebody might have had suicidal ideation as a young person and yet is seeking assisted dying much later in life and will be ruled ineligible for that. And I'm just wondering why there hasn't been some kind of time limitation on that, because they might be completely separate incidents. They might, a whole life lived in between, and yet no acknowledgement or understanding of that change.
Douglas Ross.
I've never personally experienced suicidal thoughts, but I don't think they would end at a specific period in my life. So if I tried to put in a time bar to this amendment, I will give way in a moment. If I tried to put in a time bar, Maggie Chapman would rightly say, why is it just 10 years and not 15? Why is it 15 years and not 30 years? Why is it 1 year and not 1 month? So I think the complexity of putting in a time bar or a time limit here would suggest somehow that someone who has had suicidal thoughts would suddenly, at some point in their life, stop having those thoughts and reset, when actually many people who have suicidal thoughts will continue to have suicidal thoughts, but just not take them forward. I know Alex Cole-Hamilton wants to come in, and then I'll give way to Claire.
Alex Cole-Hamilton.
Very grateful to the member for giving way. Presiding officer, we, all of us, have moments of profound mental crisis in our lives, and some of us may have had suicidal ideation. We may have even shared that with a relative or even a clinician. But I think that the point is that all of us have the capacity to get well, to recover, to move on with our lives. And I think that I understand the intent of Douglas Ross's amendment, but I don't think we can legislate for a stigma that will then follow somebody for the rest of their life when they are as far as is possible to be from that dark period in their life. So I would ask the member to reflect on that.
Douglas Ross.
I do reflect on that, but I also say without this amendment, people who currently have suicidal thoughts here and now, if this bill goes through, would use this legislation to end their life. And I don't think that is what the member is looking at. I know he will come on and say the other safeguards that are in here. I, as someone who opposes this bill, question some of these safeguards, but I'll give way to Claire Hawkey, who sought.
Claire Hawkey.
I thank the member for giving way. I'm quite astounded, presiding officer, by the characterisation of people who have thoughts of self-harm or who have suicidal thoughts, that they can never get over that or never recover. I'm absolutely astonished at the stigmatisation of people who express themselves in the most difficult moments of their life or in the depths of mental illness, that they cannot then get on with their lives. And to try and use that to prevent people accessing assisted dying at a time when they're suffering from a terminal illness, and I come from a point of not supporting this legislation, is absolutely discriminatory.
Douglas Ross.
I listen very carefully to what Claire Hawkey says in her role as the convener of the committee that scrutinised this bill, and with her previous government role in this area. My point was that there is a difference between someone having suicidal thoughts at the moment and someone who had them in the past. I did not say, I would never say, that those thoughts could then never be cleared. But what I did say to Maggie Chapman was, I can't put a 1 year, a 1 week, a 1 month, or a 10-year or a 20-year time limit on that. And to try and do that in legislation, I think would meet with the exact same opposition that I'm hearing at the moment. So members will take a different view on this. I think we can hopefully have a respectful debate where what people actually say is articulated by others, rather than jumping to conclusions about what was meant. And finally, Daniel Johnson wanted to intervene.
Daniel Johnson.
I'm very grateful. I mean, really further to Claire Hawkey's point, we are dealing with extending the possibility of ending an individual's life. By definition, we are dealing with people that are contemplating their end. I just fear that he's actually blundering into something that's a tautology. I mean, by definition, people are contemplating ending their own life. You may wish to use different terminology, and in a sense, there's a real danger here that we're talking about good contemplation of the end of life and bad contemplation, stigmatising one form in one context and another. Now, I understand what the member's trying to get at here. We don't want this being used by other people, but I actually think that he's trying to create a distinction that might actually be incredibly difficult for practitioners in the moment to really delineate between people who are just contemplating assisted dying within the bill and somebody contemplating suicide. I think that might be quite difficult.
Dr. Johnson.
But I think Daniel Johnson has also got to the point in accepting what I am trying to do with these amendments proves that the bill as it is currently drafted leaves that as a deficiency within the bill. And if we don't have amendments to try and address this and at least have a debate about this issue, then the bill is deficient in that area. And that's what I'm seeking to do with this specific Amendment 139. Presiding officer, if this legislation is to be about compassion and genuine choice, it must guarantee that both palliative care and mental health support are fully accessible and properly understood before any decision about assisted death is made. I will in one moment. Failing to do so risks pushing people into an irreversible choice simply because care is either too expensive or unavailable.
Briefly, Mr Kerr, Mr Ross has been very generous with his amendment, so briefly, please, Mr Kerr.
He has, and I think I'd just like to take Mr Ross back to the Amendment 138. It was just something that occurred to me because it requires that to be eligible for assisted death, you have to have access to a fully costed palliative care pathway. But doesn't the member think that that risks making eligibility dependent upon the service provision rather than the person's illness?
Douglas Ross.
Well, I believe that service should be available to every single person that needs it in every part of Scotland. And the fact that it is not is one of the concerns I have about this bill, that people are going to be forced into a choice of taking their life early because the palliative care that they should have is not available, either because of the cost of it, the availability in general of people employed in that, or just because there are many of our constituencies in this Parliament that don't even have a hospice within them. So people are forced to move far away from home if they are going to seek to get that support. So I think on that point, it is absolutely the ultimate aim that we have that availability and that accessibility of palliative care for everyone that needs it. And the fact that we do not in Scotland in 2026, I think, is a shame on all of us. But I have outlined my points on the amendments in Group 2. Thank you, Presiding Officer.
Thank you, Mr Ross. I now call Emma Roddick to speak to Amendment 140 and other amendments to the Group. Ms Roddick.
Thank you, Presiding Officer. Colleagues who've heard my arguments throughout this bill's progress will know that despite wishing I could feel comfortable with this proposal and knowing that there are many situations in which I would want people to have the choice, my concerns about health inequalities, societal pressure and expectations on disabled people have led me to conclude that I cannot support it. I am concerned that it would remove more choice than it would offer, and I want to associate myself with comments made by Pam Duncan-Glancy and Jeremy Balfour around the pervasive negative attitudes that exist towards disabled people. I don't think folk realise how common it actually is, that you will regularly hear everything from "how do you cope" to "I would have killed myself" when you lead a life that some people will readily describe as undignified. My Amendment 140 seeks to introduce additional safeguards for people with learning disabilities. This is not in any way to prevent a person with a learning disability from accessing assisted dying if it were available in Scotland. I want to be very clear that I have no wish and would not support efforts to remove autonomy from this community or any group based on diagnosis. My concerns stem from the way that people with learning disabilities are often treated, and the lessons that I've learned from those with lived experience include really terrifying descriptions of individual rights and freedoms being belittled, ignored or even overridden during COVID. We must legislate with the worst-case scenarios in mind, and should there be another pandemic while assisted dying is legal, nobody should be in any doubt that the people who were at risk in 2020 will be at risk then, and in that case the result could be pressure to end their lives early if we don't bake in protections. This amendment ensures that time is taken to ensure that the individual, not just their carers, their advisors, family, fully understands what they're signing up to and that they have all the multidisciplinary support that can be offered ahead of taking what is a very important decision. I will take an intervention.
Daniel Johnson.
I'm very grateful to the member for taking the intervention. I'm very supportive of the intent in the amendments that she's put forward in this group. However, I have one concern in terms of her framing in Amendment 140 of including developmental or cognitive conditions, which I worry might encompass people with ADHD or dyslexia, other cognitive conditions, and may indeed compound stigma faced by those people or require additional support to people who actually don't really require it. So while I totally accept that there are people with the vulnerabilities that she outlines absolutely do need support, I just wonder if this amendment is drawn a little bit too broadly.
I would rather be too broad than too narrow, and I think there is probably an argument that could be made that this amendment would capture me. And I would be very happy in the situation that I were seeking assisted dying to have a conversation with a social worker who's making sure that I have everything that I need to make the right decision and to be confident in understanding the gravity of it and the impact and what the other options are. It's not about making somebody pass a test or making it more difficult for them to access it, but we are people, if you've got a learning disability or you are neurodivergent, you are in many ways marginalised and vulnerable to coercion, to pressure, and just having that extra safeguard of a conversation I think it's better to include more people than to include fewer. The amendment ensures that people have that time and space, and from experts who are used to supporting people in very difficult situations, to have the time to think about it. It does not exclude. It recognises a vulnerability which is not on those with learning disabilities, but how they're often viewed and treated, and ensures that time and care is taken to make sure that this is their choice. Amendment 141 would prevent eligibility where a request is influenced by financial hardship. Disability costs money, a lot of money, and when you're terminally ill, the cost can be overwhelming and look impossible for you or your family to overcome. Poverty, loneliness, domestic abuse, bereavement, homelessness, breakdown of relationship and feeling like a burden will not be uncommon experiences for those diagnosed with a terminal illness. Yes, I will.
Maggie Chapman.
I'm grateful to Emma Roddick for taking my intervention. I'm sympathetic to what she's attempting with Amendment 141, but I just have a question about the process and how. The amendment says somebody looking for assistance in their own life, if it is established that their request is influenced. What is the process to establish that influence?
Emma Roddick.
I think, again, it comes down to a conversation, and it's people who understand and have these conversations regularly are trained to understand the responses that they're getting as part of their work. I have spoken with social workers about this amendment. I understand the concerns around you can't be too prescriptive and you can't be not prescriptive enough. And a lot of this is judgment calls. But for me, these amendments are simply adding a step that is an opportunity for people to notice that maybe something else is going on, or there's some coercion or influence that we weren't picking up on initially. I will take an intervention from Christine.
I thank the member very much. I have to say to the member, I am satisfied with the bill as it's drawn at section 3, subsection 2B, which is about capacity. And capacity is well understood in Scots law. When people are making a will, power of attorney, even buying a house and so on, they have to demonstrate to the agent that they have capacity. They understand this, they are not being coerced, they understand fully the consequences and so on. It's well tested. And I feel the definition that we have here, which says, are capable of understanding information and advice about making the request, making a decision, communicating the decision, understanding the decision and retaining the memory of the decision, covers those areas, quite rightly, that the member brings to the Chamber's attention. But for me, this is well tested in Scots law, and we don't need to, forgive me saying, clutter it with the amendments suggested.
Emma Roddick.
I appreciate the members happy with the section as drafted. I'm not. And I know that many others are not either. And my amendment is not simply about demonstrating capacity. It's about digging into the individual's social context. It's not just that they may be able to understand their illness, to understand assisted dying. It is about ensuring that they are in a place mentally where they're able to accept that there are other options, that they fully understand what those look like, and that somebody separate to their home life, perhaps, is able to take another look at that and make sure that the decision that they're making is entirely their own and that they understand alternatives that are open to them. Now, to go back to Amendment 141, these issues that people with a terminal diagnosis will experience very commonly, the primary response that we have to those should be support and trying to tackle the issue, regardless of how long the person has left to live. And discussions about the reason that a person is seeking assisted dying, which will undoubtedly always be complex and multifaceted, might give us the opportunity to ease those burdens. But I'm clear that if they are the primary reason for such a request, that's not what assisted dying is for. And we have to be alive to societal context. For example, there's very strong evidence that in the event of terminal diagnoses, marriages and relationships are more likely to end when the person being diagnosed is a woman who's in a relationship with a man. This is a difficult time for far more reasons than the diagnosis alone, and there will be people suffering from elements of some or all of the situations I've listed who also genuinely wish to end their lives purely due to the pain and the symptoms that they face due to illness. That can be clarified, but it should be clarified as the primary reason. Thank you.
Thank you. I call Bob Doris to speak to Amendment 162 and other amendments in the group.
Thank you, Presiding Officer. This is my first opportunity to speak in this afternoon's debate. Can I just clarify that much of my amendments over the next few days have been worked out and developed in partnership with the Scottish Partnership on Palliative Care, who are neutral on assisted dying and have consulted their members widely. The members will have their own individual views on the legislation. This is the Partnership's unbalanced view of how to improve this bill, but remaining neutral in that stance. I also put on the record that I'm the convener of the Cross-Party Group on Palliative Care in this Parliament. In speaking to my amendments 162, 317 and 323, I want to offer my support for the substantive amendment in this group from Daniel Johnston, Amendment 2. It is almost identical to my amendment at Stage 2, where I had sought to bring in a condition that the person applying for assisted dying must reasonably be expected to die within 6 months. I had sought to make the case that this reasonable expectation should sit within a section on eligibility criteria. At Stage 2, Daniel Johnson sought to bring the 6 months threshold into the definition of a terminal illness, something that I had disagreed with. I am pleased the member has lodged his amendment under eligibility criteria, which means I did not have to. It is the correct place for such an amendment to sit. I would urge members to support this amendment. I would remind members that the policy memorandum accompanying the bill at paragraph 32, page 8 states, and this is important, it is not the intention that people suffering from a progressive disease, illness and condition, which is not at an advanced state but may be expected to cause their death, but which they may live with for many months or years, would be able to access assisted dying. That's in the policy memorandum. The bill says something completely different, and that's why, in a moment, yes, that's why, as imperfect as Daniel Johnston's amendment is, it's a very important amendment to realise the member progressing this bill's own policy intent. Yes.
Maggie Chapman.
I'm grateful to Bob Doris for taking my amendment. I posed the same question to him that I posed to Daniel Johnson earlier. It's about that 6-month prognosis. What if somebody who seeks assisted dying, an assisted death, has other conditions that would limit their capacity to make that decision within that 6-month period, but know full well what's coming and would want to make that decision out with that 6-month period?
Bob Doris.
I think Maggie Chapman for the intervention. I think Maggie's right to put that to me. I think I would answer it in this way. Irrespective of how this bill is passed, whether it is passed or not, irrespective of what amendments are accepted in this bill or not, there will be a whole series of unforeseen, unintended consequences. Maggie Chapman's perhaps identified one, but there are a series of unintended consequences which would flow from not having some form of time restriction. So I wrestle with that also, Maggie Chapman, but I have to say, on balance, I don't think it's appropriate for a bill that's got a policy intent to say this is for people in the last months of life, to then have a bill that doesn't dictate however long you have left to live. So I think that is not an appropriate way to pass legislation, if it is indeed to be passed in this place. The current definition and eligibility criteria is not an effective way to identify a narrow group of people who are near the end of life. I think that's clear. As drafted, assisted dying would likely include some people who would otherwise live for a considerable period, which is at odds with the stated policy intent of the bill. I think that's the point. I do not pretend any of this is easy, and there are also challenges regarding a time frame for any prognosis. We've heard that also. However, I firmly believe that having a time frame is preferable to leaving the matter completely open-ended. In that regard, my Amendment 162 is crucial if Daniel Johnston's policy intent around Amendment 2 is to be fully delivered. As the bill stands, a registered medical practitioner carrying out an assessment under Section 6 must, if they have any doubt as to whether the person being assessed is terminally ill, refer the person for an assessment by a registered medical practitioner who holds qualifications or has experience in the diagnosis and management of the terminal illness involved. So Amendment 162 ensures similarly that if the registered medical practitioner has any doubt the person can reasonably expect to die within 6 months, they must make a similar referral. The amendment therefore gives the full policy intent to the substantive amendment, Amendment 2. Amendments 317 and 323 ensure that both medical practitioners' declarations include the 6 months requirement. I note that amendments from Daniel Johnson, 316 and 322 have a similar policy intent, and I am content to support those, and I do not intend moving my amendments 317 and 323, assuming Daniel moves his amendments. Before I close, I want to draw attention, and this is important, Presiding Officer, to Amendment 262, which will be debated when we reach Group 19. My goodness, that seems like a long time away, doesn't it, colleagues? On guidance, it requires the Scottish Government to prepare and publish guidance on how to interpret and apply in practice the eligibility requirement that the terminally ill adult can reasonably be expected to die within 6 months. It's important to make members aware of that amendment in Group 19. The merits, of course, we'll discuss later when we reach that, but it is an acknowledgement of the complexities involved and the importance of condition-specific registered medical practitioners in this area and the challenge presented for non-specialist practitioners. Another reason Amendment 162 is of such importance. No further comments, Presiding Officer.
Thank you. I call Pam Duncan-Glancy.
Thank you, Presiding Officer. Amendments in this group, I think, get to the heart of some of my concerns about the bill as drafted. That without support to ensure the equality and human rights of all, we could end up legislating to make it easier to die than to live, and to deepen some already quite entrenched inequalities. Some amendments in this group highlight the societal factors that could lead to someone believing it is easier to die than go on living: a lack of care, poverty or financial hardship, social isolation or loneliness, feelings of being a burden, breakdown or loss of significant personal relationships, inadequate or unsafe, insecure housing, pain that is untreated, palliative support that is not there, or inequalities denying access to that support. And I recognise that members have brought forward the amendments in this group with the intention of tightening the criteria and clarifying it in an effort to strengthen safeguards within the legislation. And I will address those amendments in turn. First, I'll talk briefly, though, if I may, Presiding Officer, of the amendments in the name of Daniel Johnson and Bob Doris to introduce a 6-month timeframe until death. And I'd like to associate myself with some of the comments Bob Doris has just made on the record about the memorandum, the policy memorandum accompanying this bill, and to note that, as stands, the bill does not deliver on that. I know the amendments in this space are well-intentioned. However, throughout scrutiny and in the Chamber this afternoon, we've heard from a number of experts about the difficulty, indeed the near impossibility, of accurately predicting how long someone has left to live. In evidence to the Health and Social Care and Sport Committee, Dr Sarah Mills said any doctor who feels they are able to adequately predict somebody's prognosis in months and years is usually mistaken. Until we improve the precision and accuracy with which we can identify somebody's prognosis, it can be meaningless to include a timescale in the bill. Similar concerns have been raised more widely. Concerns are supported by research from the Association of Palliative Medicine, which says that across thousands of prognosis assessments, doctors' assessments of which patients are likely to die in 6 or 12 months are correct less than half of the time. And so, whilst they attempt to narrow eligibility, and I take on board the points that my colleague Daniel Johnson has made about the need to have something that narrows it, I think it is very difficult to make happen, and so I'm left worried that people could end their life prematurely still. Moving now to amendments in the group, I think, that seek to address the wider societal pressures that could drive someone to choose to die. And I should say that the amendments in this group that make provision available specifically, not just compel a discussion or recording of the discussion as the bill currently includes, or as later amendments, particularly in Group 7, suggest, but specifically that require the delivery of support or that inequalities be addressed, are important, because a discussion or a signpost is not sufficient, and a plan without it being costed or indeed funded, to speak to some of the debate we had earlier on about this, is not delivery of support. I think in a bill such as this, we need a high bar, because this is a matter of life and death. Without requiring these issues to be addressed, we risk making it easier, as I say, to choose to die than live. So the question facing us now, I guess, is whether we believe that such support, crucial healthcare, social care, psychological support, is likely to be available and available to all equally. Amendments 138 and 143 in Douglas Ross's name seek to ensure that terminally ill adults are only eligible for assisted dying if they've been offered and have access to a fully costed palliative care pathway. I think that's really important because of what we know about the significant unmet need that exists and the impact that that can have on quality of life. And the point of costed, I think, is important as well, because we know that often people can have what they think their needs are, or what other people even indeed identify their needs to be in an assessment. But these things are not then funded, nor indeed provided. And support that's identified as needed but not provided isn't support at all. And it can be the difference between whether or not someone may choose to continue to go on. And I was listening carefully to the intervention by my colleague Liam Kerr earlier around the decision, should it be based on support or illness? And actually, I think we're grappling with this very question throughout the discussion on the bill. And support is often what's needed and what can be the difference between wanting to continue in a circumstance or not continue in the circumstance. And so I think is absolutely essential. However, I'd also say that even if these amendments are agreed, I don't believe they go far enough. Because we know that thousands of people have already been assessed as needing support, yet are still waiting for care packages to be put in place. And we know from all of the excellent organisations, hospices, palliative care specialists and many, many more, how unequal access to palliative care is. The Dying in the Margins report from Marie Curie is an example of that. Amendment 139 would make eligibility dependent on someone having been offered and having access to psychological counselling and on whether they've previously been screened or treated for suicidal thoughts or ideation or harm. I think those amendments are pretty crucial. Illness can and loss of function can lead to the experience of low moods and mental ill health due to a variety of factors, societal factors included, but they are there nonetheless. And we have to recognise there is a relationship between mental and physical health, and we have to support that. And this amendment, I think, tries to do that. I also think it's important, particularly given the exchanges we've heard this afternoon on this particular amendment, to remind ourselves of the statement by the Royal College of Psychiatrists, who said that suicide prevention remains a duty when someone is terminally ill. And I think that's incredibly important, and these amendments could help protect us, could help us do that. For someone given a terminal diagnosis, the inevitable loss and grief associated with the end of life should be acknowledged and supported, they go on to say. And so that's why I think it is also an important amendment. However, I am still concerned that it would fall short of making the bill entirely safe. I'm happy to take the intervention.
Emma Roddick.
I wonder if the member shares my concern listening to this debate that if you require somebody not to have suicidal ideation in order to access assisted dying, that encourages people to not be open about the suicidal ideation that they understandably face when dealing with a chronic illness. Should we not be encouraging people to talk about that so that they can be offered alternative support if that is going to address the feelings that they're having?
Pam Duncan-Clancy.
I thank the member for that intervention. And the thoughts of suicide and suicidal ideation, as many members across the chamber will know, are deeply, deeply complex, personal, and can affect a whole aspect of people's lives. And indeed, we spend quite a lot, rightly, of time in Scotland looking to support people with those thoughts, including at the end. And it's really important, I believe, that that is considered in this bill. Happy to take the intervention.
Thank you very much for taking the intervention. One of the more upsetting things, I think, from our Stage 1 debate was hearing examples of people who are unable to access assisted dying and therefore feel that they need to take action to end their own lives because they are not able to get the medical help they need because assisted dying currently isn't legal in Scotland. Does the member not worry that, particularly if this bill should be made too narrow, that we are then forcing people back to taking matters into their own hands, causing themselves physical harm, causing themselves increased injury, when in fact the medical assistance through this bill might be available to them. And if we say, if you try this, if you're so desperate, but for whatever reason we haven't made this eligible to you, and you try this on your own, you can then never be eligible for that help. I think you risk forcing people down an even ever more desperate path because you're pushing them away from the medical help that they actually really want.
Pam Duncan-Glancy.
I thank the member for taking that intervention. I think it's incredibly important that in all aspects of people's lives, we help them to understand the value of living and support them to continue to doing that. That's one of the reasons why I think the work that we do in suicide prevention in Scotland is indeed world leading, but also incredibly important. And I think that applies throughout the life course, including at the end of life. Support at the end of life should not be limited, of course, to only those with identified psychological conditions. And support for psychological and mental health should not be limited to those at the end of life. But as all of us in here will know from our inboxes, from our families, from our neighbours, it is difficult for our constituents to access the sort of support that they might need to support their mental health. This amendment, I can see, will help some people who are looking at these options, but it would not protect the thousands who need mental health support before that point. It won't help them. It won't help give them help that could make it easier for them to choose to live. Presiding Officer, Amendment 140, in the name of Emma Roddick, requires specialist multidisciplinary information and support to be provided to people with an intellectual disability or developmental or cognitive condition. And I think this is also an important safeguard, especially when we consider that people with learning disabilities are likely to die 25 years earlier than others. Their social circumstances, other matters that impact of them mean that if they become terminally ill, they are less likely to access the care that they need. There is real risk that this bill could create an inequality where people with the most can see that life is an easier choice, but others who choose could choose instead to die. These amendments can't undo that deep-seated inequality, which of course also includes homeless people, or disabled people, or indeed people who die early because of where they live, aspects that are related to society as opposed to their inherent health. And so whilst I urge members to support this amendment, I again believe it doesn't go far enough to protect people or to ensure it is easier for them to choose to live. The amendment is specific and relates to this bill, but before someone covered by this amendment gets a terminal illness, society has already discriminated against them. They've already experienced significant inequality that they will carry, that will affect their life, their view of themselves, and indeed inequality that will have already shortened their life. To address that is beyond this bill, but this is the risk with this bill, that we pass it in a world that makes it easier to choose to die. Furthermore, this amendment provides access to clear information, specialist advice and multidisciplinary support to specific groups, which I welcome. But it shouldn't be limited to particular groups. It should be available to anyone considering accessing assistance in this bill. Indeed, it is the absence of this in general that worries me. And until this is available, it could again be easier to choose to die than live. Amendment 141 recognises that individuals may seek an assisted death not solely because of their illness, but because of external pressures of suffering. And whilst I support the principle behind this amendment again, I do remain concerned that we can never really be certain whether such factors have influenced a person's decision to seek assistance to end their life. Research by Marie Curie highlights the scale of unmet need in Scotland. In 2022, around 18,500 people, roughly 30% of those who died, experienced unaddressed symptoms and concerns, whilst also lacking sufficient access to GP care at the end of their life. Every 5 minutes in the UK, someone dies without the care and support they need. And as set out by the British Association of Social Workers ahead of today, societal and institutional pressures, some of which we'll come on to in Group 4, including pervasive narratives around being a burden, the cost of care, or the emotional and financial toll on families, can shape a person's decision in the way that are profound and deeply difficult to detect. So, Presiding Officer, I'd also remind members that today, rights for disabled people are not yet realised, and amendments in this group seek to address it, but it's difficult to say that they can be by one amendment. Research shows disabled families are 62% more likely to fall into deep poverty. 1 in 4 disabled people don't get the palliative care they need, and 10,000 are stuck in their own homes because they're inaccessible. So taken together, the amendments in these groups reflect a clear recognition that stronger safeguards and better support are needed. But I don't believe they can address the circumstances that lead to the deep-seated inequality that so many of our citizens face. Happy to give way.
Stephen Kerr.
I notice in her compelling remarks that she has not addressed Sue Webber's amendments. And if nothing else, don't those amendments point out how incomplete this law is currently in respect to the potential legal and moral dilemmas that we might be placing doctors in?
Pam Duncan-Glancy.
I thank the member for that intervention, and I think Sue Webber's amendments are an example of the inadequacies, I have to say, across this bill that we are being asked to discuss today. And there are many decisions that we will be asked to take, sometimes in cases where we don't know what the future could hold, particularly some of the discussion we heard earlier around Section 104. So the amendments in this group, I don't believe, can address the circumstances that lead to the deep-seated inequality that so many of our citizens face. Inequality that could result in them not getting a fair chance or an equal chance at life, or indeed the care they need at the end. Only concerted efforts to create a fair and equal Scotland could do this. And until then, Presiding Officer, for me and for many like me across Scotland, it is inconceivable to suggest that the introduction of assisted dying is about choice when many people, so many people, do not have choice in life, nor indeed in death. Thank you, Presiding Officer.
Thank you. Members will note that we've passed the agreed time limit for the debate on this group to finish. I exercise my power under Rule 9.8.4ac to allow debate on this group to continue beyond the limit in order to avoid the debate being unreasonably curtailed. I call Ross Greer.
Thank you, Presiding Officer. I just want to speak briefly in favour of Daniel Johnson's Amendment 2 and the others in relation to the 6-month prognosis limit, not because I think that that is a perfect system, but because there is no perfect way to design this. We are trying to balance harms here. There is no option free of suffering, even if we vote this bill down. To live is to experience suffering to some extent at some point in our lives. We heard a moment ago from Lorna Slater about the desperate situations that some people currently find themselves in, and the far from dignified ways in which their lives currently end. And much as the potential flaws and drawbacks of a 6-month prognosis have already been laid out, I think what we saw at stage 1 was a majority in this Parliament in favour of the principle that people should have more agency over how their life ends, but quite clearly not a majority for the definition currently contained within the bill. I'm sure we've all wrestled with hypotheticals of what kind of people in what situations would or would not be eligible for an assisted death under this. But more than the hypotheticals, we've all had correspondence with, most if not all of us have met with constituents who've put their own situations to us, and we've had to judge whether they would or would not be eligible. The current definition clearly would capture all those who I personally believe should be eligible to make that choice at the end of their life. But it would probably, on balance, risk capturing those who I do not believe, and who I think a majority in this Parliament do not believe should be put at that level of risk. So yes, a 6-month prognosis narrows down the number of those. I'll take the intervention in a moment. It narrows down those who would be eligible, but it narrows it down by balancing those risks. It takes out people who we believe would be at a greater risk of an assisted death in a manner that we would not support. I'll take Kate Forbes' intervention.
I'm very grateful for that, and also for the balanced way in which he's outlined these arguments. How does he respond to just some of those concerns raised by palliative care doctors who express some worry and concern about how it might make them find it harder to do their proper prognosis when they know that it isn't accurate and that it might risk somebody accessing assisted dying far ahead of their natural death, even by years?
Ross Greer.
I take on board the concerns that those palliative care doctors have raised. What I would say that the individuals in that situation for whom they're making that prognosis would be eligible regardless under the definition currently in the bill. If we pass the 6-month prognosis definition, it narrows it down. It removes people who would be at risk, who we would not wish to access that service. So I'm not claiming that it's perfect, but I think it's an improvement on what's currently in the bill. I think a bill without it would pose an unacceptable level of risk. So on that basis, I would urge members to support Amendment 2 and the others related to the 6-month prognosis.
Thank you. I call the Cabinet Secretary.
Presiding Officer, as I set out in Group 1, I will only address amendments in this group where there are technical, legal or legislative competence issues that the Government wishes to highlight. In this group, Amendment 138 does not specify who should produce the palliative care package, nor what is meant by the pathway has been, quote, made available, end quote. The amendment does not detail whether this is a reference to the document itself or the services and support detailed within it being made available. More generally, I would highlight that the Scottish Government's palliative care strategy, Palliative Care Matters for All, sets out an aim that people of all ages with life-shortening conditions and their families and carers receive palliative care, care around dying and bereavement support based on what matters to them. As part of that, we are working to ensure that person-centred future care planning is discussed as early as possible following diagnosis in a person's care journey. And that, where appropriate, this will include planning and making arrangements to help ensure that they receive the palliative care that is right for their circumstances. And I'm happy to give way to Ms Maguire.
Ruth Maguire.
I thank Cabinet Secretary for giving way. He outlined an aim there that everyone receives palliative care, and it's something I'm sure everyone would support. Does the Scottish Government have numbers on how many people are actually receiving?
Cabinet Secretary.
I recognise the challenges that have been set out in some of the debate that has been had around people receiving palliative care, and I would also point out that there is a difference, as Ms Maguire I know will understand, between palliative care, end-of-life care and wider bereavement support. The distinction that I hope can be drawn here is as to whether or not it is an either-or discussion in this bill. And I think what we're deciding upon is the merits of assisted dying, and there is work that we have already set out as a government in respect of our progress being made on palliative care. We recognise that planning ahead can help people to manage or avoid crisis situations, and that it improves people's experiences of urgent or emergency health and social care. We also recognise, however, that people's wishes can often change over time, and so it is important that these plans are regularly updated as part of an ongoing conversation between clinician and patient regarding their care needs. Our work to deliver on the palliative care strategy, including in relation to future care planning, will continue regardless of the outcome of the vote on this bill. On Amendment 139, I understand the sensitivities. We heard many of them in intervention on Mr Ross, and the difficulties of the subject matter at hand. However, I would caution that the absolute restriction being proposed here could raise legal issues regarding its proportionality unless it can be fully justified. On Amendment 140, it introduces provisions which apply where a person has an intellectual disability or developmental or cognitive condition. While the amendment appears to be intended to capture individuals with learning disabilities or other conditions affecting cognition or development, the terminology used does not clearly align with the statutory definition used in the Mental Health Care and Treatment Scotland Act 2003. There is therefore an inconsistency with existing statutory frameworks, which could result in a lack of clarity and may create interpretive uncertainty for clinicians and decision-makers applying the legislation. Likewise, the assessment closely resembles the functional test of decision-making capacity used within the Adults with Incapacity framework, but it does not explicitly link to it, nor does it state whether that framework is intended to apply. This may create uncertainty as to whether the amendment establishes a separate capacity test or the existing incapacity framework is intended to apply. It is also not clear how long the period of reflection and consideration cited in the amendment is intended to last. Finally, Presiding Officer, there is a risk that Amendment 141 conflates eligibility. I'll come to Mr Hepburn in a second. Finally, there is a risk that Amendment 141 conflates eligibility for assisted dying with matters that are currently addressed through existing statutory frameworks. This includes the Adult Support and Protection Scotland Act 2007, which relies on professional judgment, defined thresholds and proportionate intervention rather than automatic exclusion. I give way to Mr Hepburn before concluding.
Jim Hepburn.
I thank the Cabinet Secretary for giving way. It's just picking up on his remarks and also on the very helpful note that the Government has made available online with explanations on the impact of each amendment. It's just to understand what might be felt to be a seeming difference between what the Government has said in 138, and I think he's made a compelling argument in relation to the not supporting 138, but at 143 there's also a reference to the pathway for palliative care Does that have legal definition? Is there such a thing as pathway recognised within law just before we decide whether or not to support these amendments?
Cabinet Secretary.
Presiding Officer, I think it would be fair to say that there are similar concerns to Amendment 143 as there are with 138. And for the remaining amendments in this group, the Scottish Government has no further comment.
Thank you. I call Liam MacArthur.
Thank you. Can I start by reminding the Chamber of my declaration of interest in that I am supported by 3 campaign organisations, Dignity in Dying, Friends at the End and Humanist Society Scotland. As the Chamber will be aware, initially I was not minded to include an expected period that a terminally ill adult had to live in the definition of terminal illness in the bill, for many of the reasons I think Alistair Allen articulated, quoting Marie Curie, and indeed being consistent with previous decisions taken by this Parliament, resting instead on the definition of an advanced progressive terminal illness. However, I've since reflected that including a prognostic timeframe would bring Scotland in line with other assisted dying laws internationally, as well as the bill currently being debated in Westminster and the one recently passed in Jersey. Many of those jurisdictions which have undertaken subsequent reviews of the operation of their legislation have not sought to remove the criterion, suggesting that it can be managed in a way that does not present unreasonable obstacles to patients accessing choice, nor unmanageable decisions for clinicians, including palliative care clinicians. And I would hope that maybe speaks to the interesting exchange that Bob Doris and Maggie Chapman had, and actually some of the concerns that Ross Greer was wrestling with, which I think are entirely valid. Moreover, Patrick Harvey. Yeah.
Patrick Harvey.
I'm grateful. I'll be very brief on this point about prognosis, because I was in a similar position, having not been convinced that we should include a prognosis period, and I voted against that at stage 2. But it does seem clear, since the debate has continued, that there is an expectation across Parliament that something needs to fill this space. Liam MacArthur mentions that other legislation in other jurisdictions has been reviewed. This bill includes the provision for a complete review of the operation of the Act if it's in force. Does he agree with me that in itself we should very clearly expect a review to cover how the prognosis period is acting in practice, how it's being applied in practice, and that review period should give those of us who were sceptical a little bit more comfort and be a bit more relaxed about accepting that what we all recognise is imperfect. Something does need to fill this space.
Liam MacArthur.
I think that's an entirely valid point, and probably speaks to a way in which many other concerns that we'll hear raised over the next 2 or 3 days may be addressed as well. We can draw on the evidence internationally, but in a sense, until we implement legislation of this type in Scotland, we can't be entirely sure of how it will apply in practice. Kate Forbes, yeah.
I don't want to cause Patrick Harvey and Liam MacArthur any fear in saying that I used to agree with them on this point, but just on the accuracy point again, I think Liam MacArthur at stage 2 actually made some very compelling arguments just about the arbitrary nature of it. And I wonder if he distinguishes between a safeguard that makes MSPs feel more reassured, but actually the palliative care doctors are still not reassured. And again, Dr Scott Murray said that accuracy in predicting how long someone has left to live for advanced cancer, accuracy in predicting survival within 33% of the actual time was as low as 20%. Is this a safeguard for MSPs or for the doctors?
Liam MacArthur.
2 things can be true at the same time. I think it is an additional layer of reassurance for MSPs in speaking to what has always been the policy intention of this bill, that is accessed by those at the very end of life. I think to those palliative professionals who have expressed concern, and I, as I say, for the reasons I set out at stage 2, and I think probably at stage 1, I accept how arbitrary this diagnosis or this prognosis can be in certain instances. But I would point again to the experience of clinicians, including palliative care clinicians in many of these jurisdictions that have prognosis periods, that they seem to be able to work with that in a way that, as I say, respects the intention of the legislation, allows access and choice choice where eligibility criteria are met, and does so in a way that seems to be broadly commanding of public confidence. So while acknowledging the challenges that this can bring in some cases, I've considered Amendment 2 very carefully, adds to the eligibility criteria rather than the definition of a terminal illness, which is certainly more appropriate. I think Bob Doris made a very important point in that regard, and I think I would certainly corroborate the fact that he had the more appropriate approach at stage 2. That a terminally ill adult should only be considered eligible for assistance if the coordinating doctor is satisfied that the person has 6 months or less to live. This would be from the point of assessment taking place. I think it's also important the amendment refers to reasonably expected. For obvious reasons, I'm therefore minded to support Amendment 2 and consequentials 316 and 322. Bob Doris's amendment 162 would require assessing doctors to refer a person for assessment by a specialist, not only if there was doubt about whether the person is terminally ill, but also if there was doubt that they may reasonably expect to die within 6 months. Given the difficulties we've already discussed around prognosis, that seems to be a reasonable addition to Mr Johnston's substantive amendment. I noted what he said in relation to his own consequential amendments 317 and 323. I do think that Daniel Johnston's amendments 316 and 322 are more tightly drawn, and I welcome the fact he's not seeking to press those. I do not support Sue Webber's amendments 137, 318, 324 relating to a person only being eligible if they are not pregnant. As would happen now, any end-of-life decision, for example a decision to cease chemotherapy, would undoubtedly require detailed conversations with a terminally ill person who is pregnant. But these will depend on the nature of the person's illness, the stage of their pregnancy and their plans. A blanket prohibition is too blunt for what will likely be extremely rare but very individual and specific circumstances. It's also unclear whether these amendments would compel every applicant to provide a negative pregnancy test. This would mean doctors having to assess every person seeking assistance to ascertain if they were pregnant or not, a shock, no doubt, to your 80-year-old gentleman with advanced stage bowel cancer. This undermines the aims of the bill to provide compassionate, safe, patient-centred care. I don't believe these amendments are necessary or even particularly well-intentioned and would urge Parliament to reject them if they're pressed to a vote. Regarding Douglas Ross's amendments 138 and 139, on 138 I am fully supportive of people who seek an assisted death having access to palliative care and psychological counselling if required. However, I don't agree that a person should be ineligible for an assisted death if they have not been offered and accessed a fully costed palliative care pathway, including symptom management, psychosocial support and specialist palliative care services, or have not been offered and given access to psychological counselling. Doing so would risk adding a barrier to terminally ill adult otherwise being deemed eligible and being able to access assistance. I'll give way to Brian Whittle.
Brian Whittle.
Very grateful for Liam MacArthur giving way. I think in terms of palliative care, I think the issue here is that if we agree that we want to give people choice, it has to be a proper choice, it has to be a real choice. And that choice must include, if they so wish, a basic palliative care package that speaks to their needs. And if they then decide to choose assisted dying, but it has to have that, it has to be a proper choice.
Liam MacArthur.
I would entirely agree with Mr Whittle, and as I'll come on to, I think there are other amendments. I think it's reflected already in the bill to a large extent, but I think other amendments capture the point that Mr Whittle is making, I think, entirely fairly. I note that Section 7(1) of the bill requires the assessing doctors to explain to and discuss with the person being assessed as they consider appropriate any palliative hospice or other care available, including symptom management and psychological support. On Amendment 139, again, adding to the eligibility criteria that a person has not previously been screened or treated for suicidal thoughts or self-harm would mean that a person would be ineligible for assistance in, say, a situation where decades previously they had been not even treated but screened for suicidal thoughts or self-harm, matters which may have no bearing at all on the person seeking assistance. I acknowledge that what Mr Ross is getting at with these amendments, but I'm not inclined to support amendments which limit eligibility in this way, rather than letting such matters be picked up in the already robust assessment process. Eligibility for assisted dying should focus on a person's current capacity to make the decision, and doctors are required to discuss with the person the reasons for requesting an assisted death. This provides medical practitioners and terminally ill adults the opportunity to explore motivations and identify any underlying concerns. I further note the Scottish Government's concerns that an absolute restriction could raise legal issues regarding its proportionality unless it can be fully justified. This applies to Mr Ross's amendments 143, which is related to 138. On the capacity issue, in terms of Emma Roddick's amendments 140 and 141, the bill already contains strong safeguards. As I think Christine Graeme identified under Section 3, a person is only eligible if they have capacity to request assistance, are not suffering from any mental disorder which might affect the making of the request, if they are capable of understanding information and advice, of making, understanding and communicating the decision, and retaining memory of the decision. Further safeguards are built in throughout the process. Assessing doctors, I'll give way to Emma Roddick. Yes.
Emma Roddick.
I'm grateful to the member for taking the intervention, and I appreciate capacity is covered. This amendment is not simply about capacity, and there's a difference between being able to understand information and that information being actively offered to you. Does he appreciate that?
Liam MacArthur.
I certainly do, but I think the safeguards that are there in order to protect those rights, I think I was expecting Ross Greer in his intervention to the debate on this grouping earlier to talk about the advocacy provisions that he added to the bill at stage 2, which I think do provide very welcome further protections and safeguards in that respect. Michael Mara.
I thank the member for giving way. It's slightly taken us back in this group, but I've been listening carefully to what he's said across the variety of different amendments. I do think he has made a pretty fundamental shift between stage 2 and stage 3 to concede the ground around the six-month rule, having previously called this arbitrary, inflexible, and in some cases very difficult to establish with any degree of certainty. And he's covered that direction. But it feels to me that this is a question, the situation he set out at stage 2 is actually probably his view and the view of people who support the bill. That actually that was the case, and that this is ground that's been ceded in order to try and win support. And perhaps he would see that as a legitimate tactic. But does it not talk to the possibility of the slippery slope approach, where people will come back again and try and open up eligibility further, when the very start of this debate we talked about the question that Parliament was asking itself was a closed or an open bill? And this is a question really about how it's been pursued and whether it's going to be opened again in the future.
Liam MacArthur.
I'm not sure this is slippery slope. I think this is Parliament doing what Parliament should be doing, which is scrutinising legislation, engaging with those on both sides of the debate, which I think we've managed to achieve, and taking on board ideas that reflect concerns that are being expressed, I think, genuinely. So I still hold to the view that there are issues around the arbitrariness of a prognosis period, but I also acknowledge, as I've said earlier in my comments, that if you look at the international evidence, even those jurisdictions that have gone through the 5-year review, there appears to be any concerns around the arbitrariness of it appear to have been allayed, such that patients are able to access the choice to which they're entitled, and medics are able to operate within that system. So further safeguards are built in throughout the process. Assessing doctors must refer a person requesting assistance to a specialist if they have any doubts about capacity, and capacity is checked at every stage, including before an approved substance is provided. Amendment 140 may complicate and confuse that process, which is not in the interest either of patients or indeed of clinicians. The same can also, I think, be said of Amendment 141, which would add 14 further conditions to eligibility, any of which would preclude a person being considered eligible. This duplicates issues of capacity and coercion already provided for in the bill, while adding other factors, some of which risk interfering in a person's own autonomous decision-making, something that I know Emma Roddick has a very good track record in fiercely protecting. I support the principle of ensuring that doctors explore a person's reasons for requesting an assisted death, but this amendment risks oversimplifying what is often a complex and deeply personal decision. As I said earlier, people's motivations are rarely singular and may relate to a mix of physical, psychological and existential factors. For a healthcare professional to be able to rule out various influences, as these amendments would require, would be unworkable in practice and risk policing open and honest conversations between doctors and patients. For example, the Scottish Government's campaign to increase awareness and understanding of autism, co-produced with autistic people, recognises that not all autistic people are the same and that many autistic people see autism as integral to their sense of self. To deem somebody ineligible for an assisted death because of an autism spectrum condition is a conflict with that approach. The bill already contains strong safeguards to ensure that a person is eligible, has capacity and is acting voluntarily. So I will not be supporting Amendments 140 and 141, and I would ask Ms Roddick not to press them.
Thank you. And I call Daniel Johnson to wind up and press or withdraw Amendment 2.
Thank you very much, Presiding Officer. And can I again thank members for a very thoughtful discussion in this grouping. And I wasn't intending to cover off every amendment forward, but I do feel myself compelled somewhat to make comment about the discussion regarding Douglas Ross's amendments. And I think the focus and objective of them, I think, is well made. I think many of us in here want to ensure that palliative care options are fully explored. I do have pretty profound concerns, though, with some of the framing of that. And I would just say this, is that I think contemplating mortality, contemplating the end of one's own life, is a pretty fundamental part of the human existence. I think probably most people, and I certainly on a personal level have contemplated the end of my life at certain times. That has not been for any prolonged period of time, but it has certainly occurred. And I don't think that we should be stigmatising people or putting them in a different category because they have made such contemplations. I think it's normal. In fact, I think that's the reason why I'm saying this. I think we need to be a bit more open that many of us will contemplate those situations at points in our life and carry on and actually continue to be happy and content and fulfilled individuals. And I think it's important that we talk about these matters in that way, in a bit more of in an open way. But and that's not too, because I do think some of the points from palliative care are really important. But to my amendments, I have concerns about this one, and I think Ross Greer summed up, I think, the position at stage one perfectly. I think many of us voted for the bill at stage one because we agree with the fundamental principle that people should have a right to choose, especially when they are facing incredibly difficult situation at the end of their lives, facing a condition from which they cannot recover, that they are suffering absolutely intolerably. And should that person be able to have the consideration of ending their life at their own choosing, providing them with one last element in which they have a degree of control when all other control has been removed from them. And I think that is an important principle, but it is one that requires balance, and a balance that certainly I personally have been struggling with. And it's why, I mean, I do believe that simply having a terminal condition that is progressive, that will end your life, cannot be sufficient. That in and of itself cannot be right, because there will be many people who will live for many years, if not decades, that will have such a diagnosis. There will be many people for whom there are good, effective treatment that can allow them to have fulfilled lives. And I believe that we should be drawing conditions around this that exclude those people. Now, I think that the moment may have passed for that second one, but what we can do is ensure that these considerations are only being made at the very end of life. Now, I think Michael Marr was right as well. Is this a bill where we want to seek it to be open and as wide as possible, or do we want it to be tight and focused? And I worry that the legislation as it stands right now falls into the former category rather than the latter. I believe that my amendments, and I would acknowledge Bob Doris's work, and I thank him for his contributions, and indeed concede that perhaps I am mimicking his approach from stage two. But I think by providing provision, saying that this can only really be considered for people at the end of their lives, is really important. Now, we can debate and we can argue about the best way to capture that. I don't think there is a perfect way. And I fully and freely admit that this by setting 6 months, there is a sense in which we are picking a marker that will require judgment, and a judgment that is going to be fallible. But at least it does state that this is only to be considered for those people who are at the very end of their lives, lives which would reasonably be expected to be measured in months rather than years. And I think that is absolutely critically important. And frankly, I think the barest minimum of conditions that I personally could support this bill going forward in any way, shape or form. I understand the concerns around it. But ultimately, I think if we were to pass something that could be undertaken and used by essentially anybody at any stage of their life, simply because they have a terminal condition, we are doing something very irresponsible, quite unlike most other jurisdictions, because the 6-month or time frame is something that the majority of legislation, as far as I could survey, does use. And if we don't pass this, and I understand the reservations, Pam Glancy, but I think the point she made is this, and a fundamental test we should be posing ourselves. Are we passing a legislation that makes ending one's life easier than continuing with it? I believe this amendment, both 2 and then the consequential ones in 316 and 322, are a step towards ensuring that we have a safeguard against that. And I think a critical one, and a one which I think is the barest minimum that we should be considering. And with that, I press Amendment 2 in my name.
Thank you. The question is that Amendment 2 be agreed to. Are we all agreed? Yes. The Parliament is not agreed. There will be a division and members should cast their votes now. The vote is closed. The result of the vote on amendment number 2 in the name of Daniel Johnson is yes 70, no 47. There were 6 abstentions. The amendment is therefore agreed. I call Amendment 137 in the name of Sue Webber, already debated with Amendment 2. Stephen Kerr, to move or not move?
Moved.
Thank you. The question is that Amendment 137 be agreed to. Are we all agreed? Yes. The Parliament is not agreed. There will be a division and members should cast their votes now. The vote is closed. I call Rachel Hamilton for a point of order.
You can see I've got technical issues. I would have voted no.
Thank you, Ms Hamilton. We'll ensure that's recorded. The result of the vote on amendment number 137 in the name of Sue Webber is yes 30, no 76. There were 13 abstentions. The amendment is therefore not agreed. I call Amendment 138 in the name of Douglas Ross, already debated with Amendment 2. Douglas Ross, to move or not move?
Moved.
Thank you. The question is that Amendment 138 be agreed to. Are we all agreed? Yes. The Parliament is not agreed. There will be a division and members should cast their votes now. The vote is closed. The result of the vote on amendment number 138 in the name of Douglas Ross is yes 50, no 68. There were 5 abstentions. The amendment is therefore not agreed. I call Amendment 139 in the name of Douglas Ross, already debated with Amendment 2. Douglas Ross, to move or not move?
Moved.
The question is that Amendment 139 be agreed to. Are we all agreed? Yes. The Parliament is not agreed. There will be a division and members should cast their votes now. The vote is closed. The result of the vote on amendment number 139 in the name of Douglas Ross is yes 31, no 82. There were 8 abstentions. The amendment is therefore not agreed. I call amendment 140 in the name of Emma Roddick, already debated with Amendment 2. Emma Roddick, to move or not move?
Moved.
The question is that Amendment 140 be agreed to. Are we all agreed? Yes. The Parliament is not agreed. There will be a division and members should cast their votes now. The vote is closed. I call Jackie Bailey for a point of order.
I had problems with the app. I would have voted yes.
Thank you, Ms Bailey. We'll ensure that's recorded. The result of the vote on amendment number 140 in the name of Emma Roddick is yes 54, no 64. There were 3 abstentions. The amendment is therefore not agreed. I call Amendment 141 in the name of Emma Roddick, already debated with Amendment 2. Emma Roddick, to move or not move?
Moved.
The question is that Amendment 141 be agreed to. Are we all agreed? The Parliament is not agreed. There will be a division and members should cast their votes now. The vote is closed. The result of the vote on amendment number 141 in the name of Emma Roddick is yes 51, no 65. There were 5 abstentions. The amendment is therefore not agreed. We move to Group 3, participation in carrying out functions of Act. I call amendment 142 in the name of Miles Briggs, grouped with amendments as shown in the groupings. Miles Briggs to move amendment 142 and speak to other amendments in the group.
Thank you very much, Presiding Officer. The proposals for these amendments have come from both the British Medical Association and the Royal College of Nursing. Both are neutral on the principle of introducing legislation on assisted dying, but want to ensure any legislation that may be passed protects the needs of both healthcare professionals, whether they choose to or not to provide assisted dying and their patients. If assisted dying was to be introduced by this bill, it would be a significant change for healthcare professionals, and it's therefore vital that they are given a genuine choice about whether they participate and to what extent. This is why it's so important to have an opt-in system where only those who have positively chosen to opt in to provide the service are able to do so, and it's not something that is expected of all healthcare professionals. At stage 2, Liam MacArthur, the sponsoring member, accepted that the bill should be based on an opt-in model and tabled amendments aimed at bringing that into effect. And an opt-in model has been accepted in other parts of the UK and Crown dependencies, and all current legislative proposals in these jurisdictions are based on that opt-in model. In Jersey and the Isle of Man, it is by doctors and nurses registering their intent to provide the service. An opt-in model has several benefits. It reassures health professionals that it's their choice whether, and if so, to what extent they wish to participate. It protects the health professionals from being expected and or persuaded to participate. It avoids healthcare professionals who do not want to participate. Yes.
Alistair Allen.
I thank the member for giving way, and I appreciate I haven't given him much time to develop his argument, but many people in this chamber will, like me, sympathise with the point he makes around ensuring that professionals have an opt-out. But the question I would have about the amendment he proposes is, are we straying into reserved areas, and how does he answer the question about the bill's competence?
Miles, please.
Yeah, and this is why Amendment 142 has been modelled and drafted on the provisions within the Mental Health Care and Treatment Scotland Act of 2003, which Parliament passed, and that set up a register of approved medical practitioners who can carry out particular roles, demonstrating that that approach is within the competency of the Scottish Parliament, and that's exactly how I've modelled my amendment here. So I do believe it is within the competency of Parliament, and then also offers what we're all trying to see and achieve, which is that opt-in model on the face of this bill. Now, I totally recognise that there is a psychological difference sometimes between assisted dying being something that all health professionals could be expected to participate in unless they use formal processes of opting out, versus it only being expected of those who have chosen to opt in. And while recognition and while recognising the importance of this to health professionals, I think it's welcome. And the bill doesn't currently say explicitly that it is an opt-in system. And we've heard concerns, and I very much heard concerns from the BMA and RCN, that their members are concerned that this needs to be
fully transparent and need these reassurances on the face of this bill. So in addition to providing that... Yes.
Jamie Hepburn.
It's just for clarity, it picks up on Dr Allen's point again. So the member has referred to the 2003 legislation and a comparable register. Can he clarify, just for absolute certainty, there was no interaction at that time between the then Scottish Executive and the UK Government to transfer any form of legislative competence? That was solely legislated for on the basis of devolved competence at that time.
Miles Briggs.
Yes, and that's why I want to make sure that we have used an identical model, which I have in modelling this, and actually at stage 2 tried to use the amendments I brought at stage 2, which since we've seen them not deemed within competency, I have changed and brought forward this amendment. And interested to hear what the Minister has to say in summing up this debate, but I don't understand why, having been identical to the 2003 Act I reference, this would not fall in the competency of creating that opt-in. Does Claire Hockey want to...
Claire Hockey?
Yeah.
I thank Miles Briggs for taking my intervention. I'm just really intrigued by the piece of legislation that he's using, which my understanding is that we created under the Mental Health Act to prove medical practitioners. That was for the purposes of detaining people under the Mental Health Act and extending their detention, and also some other pieces of legislation around about compulsion of treatment. I'm not quite sure how he can use that particular piece of legislation as a model for an opt-out, because that wasn't an opt-out for anyone. That was about conferring powers on psychiatrists.
Miles Briggs.
So it's not an opt-in, what I'm looking for, it's that an opt-out, it's this opt-in model, and that's the only clear piece of legislation which this Parliament has passed to establish a register for healthcare professionals, and that's why I look to do that. And looking towards other options which could have been available. So I was part of the Health Committee, I think the member was as well, which took forward the organ donation bill. So looking at that and looking at how we could get a group of healthcare professionals to undertake that work was also an area I looked at. But this, I think, is the cleanest amendment possible to establish a registry which people will opt into to provide that clarification and reassurance by making sure that an opt-in is actually explicit on the face of this bill for our healthcare professionals to identify and direct patients to a doctor who would fulfil the role of coordinating a registered medical practitioner. And the register would also help, I think, in the long term for health boards to accurately map the staff available locally to provide assisted dying. Is the member trying to come back in?
Claire Hockey.
I thank Mr Briggs for his indulgence in me labouring this point, but I fail to see how having a register of psychiatrists who have undertaken additional training, who are at senior or consultant level, who are then conferred additional powers under the Mental Health Act, how that then he can use that legislation to translate into a register of healthcare professionals who either will or won't participate in assisted dying. It seems to me it runs very counterintuitive.
Miles Briggs.
I don't accept that, because I think the 2003 Mental Health Care and Treatment Scotland Act set up that group, a registered group of approved medical practitioners to carry out a particular role. And I don't see any problem in what I'm proposing actually then providing similar for those who would be taking forward work around assisted dying. And I think that's where, for those medical professionals who are looking to Parliament to provide that clarification, this is an opt-in system, which I think is within the competencies of our Parliament. So I think that's important. To conclude, Deputy Presiding Officer, I urge members to vote for the establishment of this register. I think making an opt-in system explicit on the face of the bill to provide that assurance is very much needed. It's needed by healthcare professionals who will positively choose to participate, and it's needed by patients who will be able to know that they are cared for by those who want to be involved and who are trained and supported appropriately. And I move Amendment 142 in my name.
Thank you, Mr Briggs. I now call my Mara to speak to Amendment 148 and other amendments of the group. Mr Mara.
Thank you, Presiding Officer. The bill was amended by Lee MacArthur at stage 2 to require doctors opposed to assisted dying to either refer a patient to another doctor willing to participate or provide information on how to access assisted dying. My amendment would remove this requirement so that no doctor is forced to facilitate, either directly or indirectly, the ending of a person's life. And it's not difficult to imagine, in fact, I know this to be the case, that this would be highly objectionable, indeed a resigning matter for medical professionals who have dedicated their work in life to preserving life. As was highlighted at stage 2, the requirement to refer is not a neutral act. It may be viewed as a compelled complicity. It makes the doctor an integral link in the chain that it leads to a person taking their own life, and we should do everything we can to protect individual clinician choice in this regard. I know others will argue that the duty to refer is necessary to ensure access and that a comparable duty already exists in the case of abortion. But as Dr Mary Neal, an expert in medical law and ethics, told the Health Committee, when creating a system for the first time, the onus is on those designing it to design that conflict out of it. We must also listen to the clinicians who care most for people at the end of life, those who have dedicated their careers to relieving suffering and supporting patients at their most vulnerable, and who, under this bill, could find themselves being asked to facilitate a request for assisted dying. According to a 2023 survey by the Association of Palliative Medicine for Great Britain and Ireland, the vast majority of palliative care doctors say they would refuse to participate in any part of the assisted dying process if it is legalised. 7 in 10 would consider resigning if their organisation offered it. If such a significant proportion of palliative care doctors feel unable to remain in post under a system that requires even indirect participation, we must all take that extremely seriously. The implications affect not just the professionals, but capacity levels within the NHS, which are already under extreme strain, as Parliament has recognised. Liam MacArthur, in his response last month to the letter from the medical bodies outlining their grave concerns about the bill, said, and I quote, "Choice and protection are at the heart of this bill, and I want to be very clear that means choice and protection for medical professionals as well as for dying people. But if doctors cannot fully opt out of the process, that promise is hollow." Turning to the other amendments in the group, we'll wait to hear from the Government, but a number of well-intentioned amendments in this group will, I believe, be deemed out of scope. Certainly, sir.
Bob Torres.
Apologies for intervening as we're moving on to other amendments. I was wondering, in relation to your substantive amendment, Mr Mara, under the terms of your amendment, if Mr Briggs' amendment was passed, would clinicians under your amendment be able to make those seeking assisted death aware that there is an opt-in register available that they could access?
Always through the floor, Michael Mara.
I think it's a reasonable question in terms of the interaction of the two, and I'm not entirely sure, I have to say, in terms of how the two would operate together. I think it's absolutely clear to me that what we have to do is make sure that people have that choice. And we should protect it as best we can. I hope that gives some clarification. Sorry, so let me try and find my place again. So I will wait to hear from the Government, but a number of well-intentioned amendments in this group will, I believe, be deemed out of scope. These include amendments from Miles Briggs, Fergus Ewing, John Mason, Paul McNeill, Jeremy Balfour, Liam MacArthur's Amendment 133 and Jackie Bailey's Amendments 229 and 308. Liam MacArthur's Amendment 107 entirely removes Section 18, which makes provision for conscientious objection. For those MSPs versed in the legislation, these are well-documented issues around legislative competence and the scope of the bill. I believe that professionals and the public will be astonished to hear that we are considering passing the bill without cast-iron guarantees in place. Every physician I have spoken to would be of that opinion. A Section 104 order from the UK Government would be required to enact the provisions around conscientious objection that we are discussing, and this would be negotiated by officials, not representatives of the public, not ministers, not workforce representatives. Please.
Jamie Hepburn.
Just wonder then if he agrees that it would have been far preferable and far better if the UK Government had agreed a Section 30 order, because I find myself with great sympathy to the arguments that are being deployed thus far in this area, but I mean, clearly we've not heard yet whether or not there is a sense that they fall out with scope, although we've all seen the explanatory note. It is very difficult for those of us who believe these are important areas to be legislated for, to then be told that it might fall out with legislative scope. I think this is very difficult for us.
Michael Murray.
I think the member makes a very good point. I have to say that we find ourselves 3 weeks from the end of the parliamentary term considering this legislation. And I do feel that if we had been looking at this 2 years past, there might have been more scope and time for government to have a more considered conversation about this. So whether that Section 30 might have been a better alternative to 104 in that regard. I think it also points, though, to the limitations of using a private member's bill, in this Parliament, to try and pursue this issue, when actually trying to deal with these issues, I think, really takes civil service to civil service and government to government to try and resolve the issue. Certainly take the First Minister in that regard.
I'm grateful to Mr Murray for giving way. I wonder if Mr Murray would further develop his argument about the uncertainty that is left for Parliament should the Section 104 route be pursued compared to a Section 30 order, because a Section 30 order provides the Parliament with the legislative competence to act and to define its position. The Section 104 order, I wonder if Mr Murray would consider, leaves an uncertainty for this Parliament about its legislative intent being followed.
I think the First Minister makes a fair point, and I will come on to that. I am not going to stand here and advocate for the position that the UK Government has taken in this regard, because frankly the letter that I have from the Under-Secretary of State for Scotland, I think, does not set out the position as to why the Section 30 was declined. What we have the information on that basis is the means by which a Section 104 order will be pursued, which is a different matter entirely. Now, there may very well be a strong case for why a Section 30 was not deemed to be the correct vehicle for the UK Government to pursue this matter. But I don't believe that Parliament has heard it. I don't believe that Parliament, if I can just complete this point and I'll take Mr Whitfield. I don't believe that Parliament has had that set out to them by the UK Government sufficiently. I would be willing to hear it, but it goes to the point, First Minister, that I made in response to Mr Hepburn, that I think that if we were looking at this 2 years in the past, and there was a position where we could have actually pursued some form of negotiated settlement. But I also think it talks to trying to resolve very complex intergovernment relations when it's not a government-to-government process. And it actually illuminates the limitations of using the Members' Bill in this area. Further to that, I think that the letter, frankly, that we have had that's been gone to the Sports Committee is very open to interpretation. So it says there's content in principle to pursue a Section 104. It's important to note the complexity of these matters and the detailed policy and legal work that will be required from both governments. This will require further consideration and analysis by respective officials. The UK Government is not yet in a position to agree to the specific form of the Section 104 order. Again, entirely, I'm sure, reasonable legal means setting out the limitations of the process. But I think as parliamentarians we would all ask whether we think that this is a sufficient means to actually deal with what is a central part of this bill. I've looked at the other areas where Section 104s have been pursued, and they are reasonably technical issues. This is a fundamental issue to this bill. It's whether it's about who can actually have the conscientious objection, whether people can have security in their employment, and it relates to the standards of training that are around these issues. I think it's of utmost importance. I cannot believe that it be dealt with sufficiently in this manner. Please, Mr Whitfield.
I'm very grateful to the member for taking an intervention. Just slightly to take him back rather than the question that's being asked. Does he have concerns about the length of time that this is going to take? Because effectively, one of the challenges that we have about this legislation is if it is passed, when it comes into force, and whether it can even be looked at as to coming into force without this fundamental question being answered with regard to those employed.
I think Mr Whitfield makes a very fair point in terms of the... clearly, I think, given the timetable that we have, this would be under the auspices of a successor Parliament to this one. It's not clear. I think Mr Gray set out some, in his initial statement to Parliament, some issues about the Government wishing to prepare a memorandum of the effect of the Stage 3 amendments that would be passed within days to the UK Government. But the language that's contained within this letter indicates to me that this is no 4-day process. It's not a 3-week process. This is a question about where people will have to give careful consideration to the interrelations. And if I can complete this point, Mr Allen, there's also the situation which we should all be cognizant of, that the UK Parliament is currently in the process of its own assisted dying legislation, and there will be issues, I'm sure, that Parliament or that government or the officials who work for that government would wish to consider around whether that legislation passes, does not, what impact that they believe that might have in differential approaches to employment legislation across the UK and protections that are afforded to individuals. So the timetable that we are looking at, I do not think is within this parliamentary session. Please, Mr Allen.
Alistair Allen.
I thank the member for giving way. And will he agree that it's not only within this chamber that the concerns he's rightly outlined are being expressed, and that members have had in recent days or in the last few weeks a letter from former presidents of the colleges of physicians and surgeons who say this is an issue of huge concern. It seems unconscionable to us that parliamentarians would be committing our profession to such a monumental change in responsibilities without complete clarity on what protection would be offered for those who, for reasons of conscience, would decline to be involved. And that is a direct reference, I would take it, to the 104.
Well, I think it is, and that's certainly how I took the member's quote when I received it. Unconscionable is a strong word, but I think in these circumstances it is correct. So we should not be looking at legislation where the people are not afforded these fundamental protections, both in their employment. And it does have, beyond those individuals, if I complete this point, it does have a fundamental impact on our health service, on our ability to actually provide palliative care, social care and emergency health care across Scotland. And we have to think, given the statistics that I've set out, what that will do to our NHS if we actually remove this cohort of staff who are unwilling to participate if they are not afforded appropriate protections. Please, Mr Graeme.
I'm grateful for Michael Maher taking the intervention. I do have significant sympathy for a lot of the argument that he's laying out. I would be interested, though, in his view on whether it is right that a parliament that has responsibility for health and for criminal justice has found itself in the position where we are struggling to debate this issue. This afternoon we should be focused on the fundamental ethical issues at the core of this debate, and instead we're having a difficult technical debate about constitutional law because the devolved settlement has proven to be inadequate in this regard. Would he agree with that?
I think it's worthy of reflection, and Mr Greer sets out some of the challenges. I've already set out what I think to be some of the limitations of the Members' Bill process in dealing with this. But I actually think that the fundamental ethical questions of this issue were addressed in some around the principle at stage 1. What we have to do at stage 3 in this debate is actually address the issues of whether we have a practical bill that can afford people the choice that so many people in this Parliament want to see, but also afford people protection. So it's actually about the legislation that we have in front of us. And I think that is absolutely critical. Ms Thompson.
Michelle Thompson.
I thank him very much for giving way, and I'm generally listening intently to all the views being expressed, but I'm not clear what specific remedies Mr Mara is suggesting.
Michael Mara.
So my specific remedy is not to pass the bill, I have to say, Michelle Thompson, and that's my view. It's not the only basis that I take the view, but I think at this moment in time it's such a significant hole in the legislation, and I don't think it's been properly explored and explained either to Parliament or to the public, and clearly, given what Dr Allen has set out, to the professionals that are involved. So I think that is, to me, is the principal concern. I think that we've reached there is essentially a significant hole at the centre of the legislation in this regard. Please, Mr Graeme.
I appreciate Mr Mara giving way. I just wish to clarify the Section 104 process, because Mr Mara earlier suggested that it would be only for officials to negotiate and then conclude a Section 104 process. That's not correct. It would still be for ministers in both governments to agree, so that would be part of the negotiation process that ministers
Michael Mara.
I think that's worthwhile clarification, but it is secondary legislation. It would not have the scrutiny, a full scrutiny of Parliament available to it, as we are doing today, and Mr Gray acknowledges that. And on such a fundamental issue, which there are such significant concerns from our medical professionals, I think this is a crucial discussion today as to whether this bill should stand or fall in that regard. Certainly, Mr Kerr.
Because earlier on when I intervened on the Cabinet Secretary, I'm not sure that he was as clear as he could have been about the fact that the 104 requires secondary subordinate legislation, and that is a crucial weakness in the bill that now arises.
Michael Mara.
As I set out to the Cabinet Secretary, I agree with Mr Kerr. I think it's crucial. I do think that this, throughout this process, it has been lengthy. We have given considered and detailed scrutiny to this bill. There's nobody can be faulted in that regard. We've come to a moment where we think there is now, as a result of this, a significant gap. I would say to members who supported the bill at stage 1, for the first time, we've had previous bills in this Parliament, and in actual fact, they have done a service to the Parliament in bringing it to this moment, where we can explore these issues, both the potential and the limitations of the devolution settlement in this area, and then a future Parliament may wish to consider this issue in the round to make sure it can actually deal with this, whether it be on a government-to-government basis or in a more considered way. These issues have not been discussed previously precisely because we did not reach stage 2 and then stage 3 in the process. But this is a huge hole in the legislation, and medical professionals are significantly concerned about it. I shall, Presiding Officer, and I appreciate your forbearance given the amount of interest there is in this area. I'm sure others will touch on it again. So I do think it should give colleagues serious cause for concern that the Parliament faces passing a bill which would not make provision for conscientious objection in this regard. So this amendment has consequences that this bill has too many holes in many of the crucial places. Paul Kane's Amendment 232 makes provision for conscientious objection by organisations, providing a clear statutory protection for care homes and hospices. And I want to put on record that I've heard powerful testimony from many in the care and hospice sector, particularly in faith-based care spaces, about their desire for a statutory opt-out. Those in the Catholic Church are particularly fearful that the passing of this bill could spell the end for care homes run by the Church and through the Church. These facilities provide compassionate, exemplary end-of-life care, and their loss would be felt keenly by the communities that they serve and that find solace in them and within wider society. Again, losing key capacity in a sector that is under really significant strain, and I think that should concern us all. While I believe the intent of Daniel Johnson's amendments in the group are to provide a form of opt-out, in reality I don't think they will achieve that, as staff and organisations will still be required to refer a patient on and facilitate their assisted death. And it's unclear how this will be achieved. As I said before, I am anxious that amendments such as these will force faith-based spaces to close, and they are unable to take any part in assisted dying. This is a sector where there is under-provision. We should all be mindful of that. Amendments from Polly McNeill and Jeremy Balfour in the group, while I believe they will be out of scope, serve to remind us very clearly just how broad the group of indirect health professionals who may be drawn into participating in some way, facilitating assisted dying would be, and I think are therefore very worthwhile of looking at this afternoon. Thank you for your forbearance, Presiding Officer.
Thank you, Mr Murray. I now call Jackie Bailey to speak to Amendment 7 and other amendments in the group. Ms Bailey.
Thank you very much, Presiding Officer. I have 5 amendments in this group, so I hope colleagues will bear with me. I want to first speak to Amendments 7, 8 and 20, and I do so on behalf of the Royal College of Psychiatrists. These amendments would replace the existing reference in Section 7 with a clear requirement for assessments under Section 7.2b to be carried out by psychiatrists drawn from a formal regulated register established by Scottish ministers and set out transparently in regulations. Presiding Officer, this is a necessary and proportionate safeguard because it responds directly to concerns raised by the Royal College of Psychiatrists in Scotland and other clinical experts who have stressed the importance of ensuring that only appropriately qualified and experienced psychiatrists undertake capacity assessments in the context of assisted dying. They note that Scotland already operates a national psychiatric register successfully under the Mental Welfare Commission, demonstrating that this model is familiar, it's workable and it's effective. The new section I'm proposing would oblige ministers to create such a register and would set out the essential elements that must be included, clear eligibility criteria, a responsible body for maintaining the register and a transparent process for applications, entry and removal. Let me be absolutely clear about why this matters. First, the amendment will ensure consistency and quality. The assessment of capacity in this highly sensitive and ethically complex area must only be undertaken by clinicians with appropriate specialist training and experience, and the amendment makes explicit that only psychiatrists on the specialist register of the General Medical Council or those with equivalent qualifications or experience can be considered eligible. Second, this amendment strengthens oversight and governance. Expert bodies have warned of the risks that can arise internationally when a small number of clinicians undertake large volumes of assessments without adequate oversight. So a formal register provides a mechanism to ensure that minimum standards are upheld and that Scotland avoids these pitfalls. Third, a register improves fairness and transparency. It helps ensure that the second opinions are allocated equitably and prevents the possibility of what is sometimes described as doctor shopping. This protects both the individual seeking assessment and the integrity of the process. And fourthly, it supports robust data collection and evaluation, which will be essential for the annual and 5-year reviews required by the bill. Without this amendment, gathering consistent, high-quality national data on psychiatric assessments may be extremely difficult or indeed impossible. Amendment 8 is consequential to 7, and it replaces general reference to psychiatry with references to the new register of psychiatrists. Presiding Officer, these amendments do not alter the principle of the bill. They do not place any barrier in the way of a person who meets the necessary criteria. What they do is ensure that Parliament embeds into law a safeguard that clinicians themselves have told us is important for patient safety, for public confidence and for the integrity of psychiatric practice in Scotland. And let me address what I suspect are the concerns of both the Scottish Government and some members. Firstly, on competence, we already operate a register successfully under the Mental Welfare Commission. We're not changing the way in which the GMC operates their register. That would be constitutionally inappropriate. So I don't believe that there are competence issues, because this is about maintaining a register that we are already doing, and actually Claire Hockey, I think, outlined exactly why this would be competent in her earlier interventions. Secondly, on deliverability, the Mental Welfare Commission already operates a register successfully, and there's no issues, therefore, with deliverability in my view. If the Parliament intends to legislate for assisted dying, then we must ensure that we legislate responsibly, with appropriate checks, safeguards and oversight. The amendments provide exactly that, and I therefore urge members to support Amendments 7 and 8 and Amendment 20, which is consequential to Amendment 8 and introduces an affirmative procedure. Can I move on now, briefly, to Amendments 229 and 308, which I move on behalf of CHAS, Children's Hospice Association Scotland. And these amendments recognise that institutions, as well as individuals, may have legitimate ethical grounds for not participating in assisted dying. That protection is needed because it ensures the bill respects conscientious objection at organisational level while still protecting individuals' access to other legalised assisted dying services. These amendments basically give care services and independent healthcare providers, including hospices, the opportunity to opt out of providing assisted dying where there are reasonable grounds, including where staff exercise conscientious objection. Scotland has over 10,000 registered independent care services, and not all will be suitable or appropriate settings for assisted dying. These services already determine which healthcare interventions they provide, and they are required through regulation to set this out clearly within their organisational aims and objectives to ensure there is transparency for patients, families and professionals. So this amendment would mean these care services and independent healthcare providers wouldn't be penalised for choosing not to provide assisted dying or allowing it to take place on their premises. It also guarantees that patients and families using these services can still access assisted dying through an alternative provider, ensuring no loss of choice for the individual. It protects the ethical integrity of care services and independent healthcare providers, including hospices and specialist providers like CHAS. And it maintains, finally, a rights-based balance through respecting organisational values while ensuring individual access. So I would equally urge members to support Amendment 229 and 308. Thank you, President.
Thank you, Ms Bailey. I now call Polly McNeill to speak to Amendment 226 and other members of the group. Ms McNeill.
Amendment 226 strengthens the conscientious objection provisions in Section 18, provisions which are absolutely essential if this Parliament is to legislate responsible in such a sensible area. Specifically, the amendment in Section 18, page 12, line 20, leaves out subsection 1 and inserts no individual in any role or capacity, including medical practitioners, nurses, allied professions, pharmacists, administrative staff, receptionists, delivery personnel, students and trainees. So similar arguments to Michael Mara and Jackie Bailey. I mean, given it is probably the single biggest issue about the operation of this bill, it does require intense scrutiny. And it seems to me, given the significance of an assisted dying bill and that people will have conscientious objections to it, it seems it's the most important thing to get right. As the bill currently stands, it says that an individual is not under any duty to participate directly in anything authorised by this Act. So my amendment adds the words directly or indirectly, but it makes it clear that there are a range of roles that could fall within the scope of the bill. Because when we talk about conscientious objection, we must be honest about what participation could actually look like in practice. It's not only doctors and nurses who may find themselves involved. It could be pharmacists who are asked to dispense substances. It could be a delivery driver. It could be a receptionist arranging appointments or administrative staff. So I think for belt and braces purposes, I think it's important to include those members of staff who may be involved in a process should the bill pass. For some people, any involvement in the ending of life, however indirect, raises profound and moral, ethical and religious concerns. So if we are serious about protecting the conscience of those individuals who may wish to step back from the process, then we must make sure that we cover everyone. So that this amendment would close a loophole in relation to that. And as some have argued, amendments like this may risk making the bill harder to implement. But it seems to me that there must be a cast iron right of staff, clinical staff and non-clinical staff, not to participate. And there's a serious concern actually listening to this debate that we're at stage 3 and we're arguing over whether or not this is competent or not. Maybe lessons do have to be learned about the operation of devolution and reserve matters, but nonetheless this is a significant bill and it gives me cause for concern that it has not yet been resolved. As the bill sponsor has said, it suggests that it would be dealt with at a later stage under the 104 order. But for me, that's not satisfactory. I think it's important to put it in this bill. I do think it is competent. There's a good argument that it is, particularly when we talk about non-clinical staff. We're not talking about regulations here. We're talking about the operation of our NHS. And I'm not comfortable with the suggestion that there would be a gap between the royal assent of a bill and a gap in between. I mean, where does that leave those who wish to... I mean, it's just absolutely crazy to me that we'd be considering that there would be a gap of any sort when we pass legislation in this place, once it reaches royal assent, unless specific provisions within the sections of the bill that it wouldn't come into force, it comes into force. And it wouldn't. It is a serious flaw in the bill that, as I have on record, I'll not be voting for anyway, but you've always got to consider that it may pass, and so you'd want it to be the best legislation that it possibly could. For those reasons, I will be supporting other related amendments, and I urge anyone who believes that this is an important aspect of the bill to put it in the bill. I believe it's competent, and that way the intention of this Parliament is crystal clear that we'd want this cast iron guarantee within the bill for clinical and non-clinical staff to be there from the minute of royal assent and not have to wait. And I hope that Amendment 226 is accepted on that basis. Thank you.
Thank you, Ms McNeill. I now call Jeremy Balfour to speak to Amendment 227 and other amendments in the group. Mr Balfour.
Thank you, Presiding Officer. Clearly, we are at slight disadvantage in debating these amendments because we don't know how the Scottish Government are going to respond and what advice the Cabinet Secretary is going to give. But my Amendment 227 makes the conscientious objection clause clearer, and I think, like others, seeks to close potential loopholes by which staff are asked to indirectly participate in the process of assisted dying provisions. It adds to 1A2 subsections, which means examples of this type of participation. For example, the requirement to refer direct or signpost a person to another individual, or organisations to facilitate assisted dying. This amendment would ensure that can't be the case. We need to work, and I think hopefully everyone in the Chamber agrees, but we need to work with the principle that conscientious objection is built in to any future system of assisted dying. It is not an optional add-on or top-up, and it may cause some inconvenience, but we need to protect individuals around it. It simply does not work without it, because it won't have the confidence of the people of Scotland. We cannot have a situation where, for example, because of inconvenience, could cause for this person not to fulfil a request, a junior healthcare staff member having to facilitate an action that would lead to someone having assisted death. Nurses and doctors who have just qualified from university could be asked to do so in one of the first jobs they do in their career, even if against their own conscience. And this cannot be acceptable. Now, I am deeply concerned about the process that we're involved in this afternoon in regard to these whole list of amendments. They've been, I think, explained well by others. But my understanding, and perhaps the Cabinet Secretary, when he speaks, can clarify this, that although both ministers, both governments will be involved in the process of producing things, that it would not come back to this Parliament. So once we pass this... Mr.
Graeme.
For giving way. I can confirm that the Section 104 process does not set out a role for Parliament. However, I would, of course, be happy to keep Parliament updated should the bill pass and should the 104 process be required in order to allow for colleagues to have that consideration and to put scrutiny on whether it's myself or any future ministers of that 104 process.
Jeremy Balfour.
I'm very grateful to the Cabinet Secretary for his intervention, but what he's just confirmed is that if we pass this bill and it becomes an act, it goes away to both governments to discuss, and we can be consulted on, we can look at, but we have no veto. So there could be a situation where we end up with people having to do things or institutions having to do things that we as a Parliament do not want, but are being told that we have to have it by the UK and by the Scottish Government. Mr Doris.
Bob Doris.
Balfour, I'm listening very carefully to your argument, and much of that is very powerful. Would Mr Balfour give consideration to how a future Scottish Government or UK Government would know the will of this Parliament in relation to these protections that are outlined in the amendments before us here this evening, if we don't vote on them and take a view on them within this legislation? Is this not the opportunity for Parliament to come together and say the protection that we think there should be, and to stay silent on it by voting them down means the Scottish and UK governments would not take an informed view of what the will of this Parliament, which is passing this primary legislation, would actually be?
Jeremy Balfour.
If I understood Mr Doris right, and my worry about this is that, for example, if in a moment the Cabinet Secretary tells me that Amendment 227 is incompetent, and if this Parliament then voted for it, it would make, if it was passed, the Act incompetent, and it would have to go to the Supreme Court. That doesn't seem to me a particularly good way to deal with this. And I'll let Mr McMillan in a moment. What I think should have happened, and because of the time pressures of this Parliament coming to an end in 2.5 weeks' time, is that this should have been sorted out by both governments before this came, so that we knew exactly what we were voting for in regard to it. And I think that would have been the way forward, because at that point, whether I agree with the 104 or not, I would know exactly what protections other people are getting. I don't have that assurance, whether I get back to this place or not. I'll take Mr McMillan and then Mr McCarthy.
I thank Jeremy Balfour for taking an intervention. I'm sure Mr Balfour would agree with me that the Section 104 process, as we have discussed regularly in the Delegated Powers and Law Reform Committee, we have been told consistently that that would only start at the end after Stage 3 has been completed, not before Stage 3 has been completed. So with what we are discussing today, and the fact that the Section 104 has already started as per the Cabinet Secretary's letter of the 5th of March, does that not then indicate that either that something is being changed in terms of that process, or does it mean that this has actually been expedited for some other reason?
Jeremy Balfour.
Yes, I mean, I absolutely agree with Mr Macmillan on both those points. And again, perhaps the Cabinet Secretary, when he speaks, can tell us why this has happened so quickly. Because, like yourself, I've spent the last number of years on a DPLR, and this is very unusual for this to happen. I'll come to you in a moment, if that's okay. So I do think, and I think it would have been possible for both governments, if there had been a will there, to have drawn something, not necessarily tying everything up, but giving us the general principles behind this. Because I do not know whether the UK government want to give these opt-outs or not. We've had no indication in any of the correspondence of that. And I think we are being asked to take a massive leap in the dark for doing that. I said to Mr Greer, First Amendment.
I'm very grateful. I would say to the exchange between Mr Macmillan and Mr Balfour on the Section 104, I share the frustrations at the level of uncertainty that we're facing in the debate this afternoon. There was absolutely nothing stopping the UK Government from producing a draft Section 104. Mr Macmillan is correct. They wouldn't have been able to table a Section 104 until this Parliament had actually passed the bill. There was nothing stopping them tabling a draft or at least offering this Parliament clarity. They didn't do that. But I just wanted to pick up on what Mr Balfour said about us lacking a veto. Surely on that point, the commencement regulations are our veto, particularly if Amendment 133 is passed. If the bill is passed by Parliament, no system of assisted dying could actually begin until we had agreed through the commencement regulations that, for example, conscientious objection, no detriment, training requirements, etc., had all been covered. Do we not have that veto through the commencement regulations?
Jeremy Balfour.
I think I absolutely agree with Mr Greer about the point he made initially about the UK government could have given us something in draft. I suppose my point is we are where we are. We are in reality of politics, and we don't have that. And so we're not going to get that unless they come up with it in the next week, which I don't think we will. So I have to see where we are in reality. It's the timing issue again. We are being asked to make decisions without the information before us. Mr Mason.
Briefly, Mr Macmillan, Mr Balfour has been very generous with his time, but he will be needing to conclude shortly. Mr Macmillan.
Sure. Thank you, Presiding Officer. Just on the point about... Oh, sorry. I thought the Presiding Officer said me, sorry.
I'm sorry, I thought...
He did say Mr Mason.
Oh, I'm terribly sorry, I didn't hear that. I heard, I don't know, I saw
That's
Mr
okay.
Macmillan.
Well, it was just to answer his question.
Mr Mason.
Thank you. To answer his question as to why this is happening, I don't know if he'd agree with me that I think this is happening because Westminster wants to keep us in our place. And Westminster... As they did with gender recognition, they want to keep a veto over anything we do.
Exactly. Jeremy Balfour.
Funny enough, I don't agree with Mr Mason. I agree with lots of what Mr Mason believes in, but I don't want to make this, and I don't think we should be making this a constitutional argument. I think what we should be doing is saying what is the best for the people of Scotland. And without the information before us, I don't believe, unless the Cabinet Secretary, and I will conclude with this, Deputy, unless he says all these amendments are competent and we can vote for them now, then I don't believe we should be leaving it to both governments to make choices that we ultimately have no say in. Thank you, Deputy.
Thank you, Mr Balfour. I now call Douglas Ross to speak to Amendment 228 in the name of Fergus Ewing and other members in the group.
Thank you very much, Presiding Officer. I'm speaking to these amendments on behalf of Fergus Ewing, who cannot be in Parliament today. Amendments 228 and 230 in Fergus Ewing's name are vital because they strengthen Section 18 to protect the right of conscientious objection for medical staff and others involved in healthcare. They make it explicit that no one can be coerced, pressured or threatened into participating in assisted dying. whether through employment consequences, contractual threats or undue influence from colleagues, supervisors or external bodies. What is deeply concerning is that the sponsor of this bill, Liam MacArthur, seeks to remove this section entirely, effectively stripping away any critical safeguard. Worse still, they propose that the rules on conscientious objection be determined not by this Parliament, but by United Kingdom civil servants, without any scrutiny from the Scottish Parliament. This is more than just a technical matter on employment rights. It is a fundamental attack on the authority of the Scottish Parliament itself, and it shifts power from elected representatives to the hands of officials who are not directly accountable. I do remind members that I am speaking on behalf of Fergus Ewing, who would want me to reiterate this point, that for anyone who believes in the principle of Scottish self-government and for anyone who supports Scottish independence, this should be unacceptable. I reiterate my point again. That will be the only time I get applause from those benches in the middle, I am sure. But seriously, Presiding Officer, we have seen from correspondence and engagement with medical professionals that clarity and certainty around conscientious objections are not optional, they are essential. Staff must have absolute confidence that they can refuse to participate in assisted dying without fear of reprisal or coercion. These amendments make that crystal clear. This Parliament must send a strong message. It will not allow any staff member, volunteer or practitioner to be coerced into participating in a process they conscientiously object to. To do otherwise would undermine both individual rights and the democratic authority of this chamber. These amendments are not about theoretical protections, they are about protecting people, preserving accountability and defending the sovereignty of the Scottish Parliament. Removing them would be a step backwards for both the Scottish Parliament, Scottish democracy and the ethical treatment of our healthcare staff, which is why I am happy to speak to Amendments 228 and 230 in the name of Fergus Ewing.
Thank you, Mr Ross. I now call Liam MacArthur to speak to Amendment 107 and other amendments of the group. Mr MacArthur.
Thank you, Presiding Officer. The Scottish Government set out its view in the memorandum to the Health Committee on September 2024 that there are provisions within the bill that may be outside the legislative competence of this Parliament. This includes the provisions in Section 18 which they have indicated may relate to the H1 Employment Reservation of the Scotland Act 1998. As members are aware, Section 18, as amended at Stage 2, essentially provides that an individual is not under any duty to participate directly in anything authorised by this Act. It includes a series of provisions aimed at ensuring that an individual or organisation must not be subject to any detriment for not participating or, as the case may be, for participating in anything authorised by the Act. Because of the legislative competence issues I've referred to, however, Amendment 107 removes Section 18 from the bill to ensure that all aspects of the bill are within the competence of the Scottish Parliament when it comes to the final vote. I'm aware of the concerns around the removal of this provision from the bill, as we've heard articulated this evening. I fully agree that the protection of health professionals and others who have objections to being directly involved in the assisted dying process, for whatever reason, is of the utmost importance. So too the employment protections for these professionals as set out at Stage 2. However, equally, I wish to ensure that all provisions of this bill are within the legislative competence of this Parliament, otherwise they cannot have the legal effect that Parliament intends. The safest route is a constitutionally precautionary one. Both the Scottish and UK governments have agreed that the best way to achieve that protection, those protections currently provided through my Section 18 provision is through an order at Westminster under the Section 104 of the Scotland Act. I refer to correspondence from both the Cabinet Secretary for Health to the convener of the Health Committee and from the Parliamentary Under-Secretary of State for Scotland to the Chair of the Scottish Affairs Committee, confirming that. In relation to some of the points, I'll take an intervention in a second, Ms McNeill. In relation to that point, I would also quote from that letter from the Cabinet Secretary. In relation to Section 18, We wrote to the UK Government on 10th February 2026 requesting an in-principle commitment to a Section 104 order and received a response on 3rd March 2026. This response indicated that the UK Government is content in principle to take forward such an order. And then in relation to the training, qualifications and experience provisions, Mr Gray states, having given the careful consideration, our view is that the route of seeking to make provision in a Section 104 order, perhaps to give Scottish ministers power to make directions about such matters, is the appropriate one here also. And I'd say that simply, I think, in response to the intervention from the First Minister earlier on in terms of not having received the response they got. I think this has illustrated the way in which Scottish and UK governments working together can work for the betterment of this Parliament. I'll take an intervention from Ms McNeill.
Thank you very much. Trying to understand then how the member would see this working, so forgive me if I'm sure you're familiar with it anyway. The commencement section 32, where it says this section 14A, B, 22A, 28, 20, etc. It comes into force on the day after royal assent, and the next bit says the other provisions of this Act come into force on such days as Scottish ministers may by regulations appoint. So I'm just trying to understand, was it designed this way or written this way so that it would work in tandem with what you said in relation to the 104 order which Neil Gray is talking about? I think it would be helpful to write on how does it piece together. Is it the normal way a Commencement Act would be written? I don't think. I'm right in saying that. Thank you.
Lee McArthur.
Thank you. I think in response to that, I would say yes, there are commencement provisions in the bill as it stands. As Ross Greer indicated, I think, in intervention to Jeremy Balfour earlier on in the debate on this grouping, I have an amendment in this grouping 133 that would ensure that any commencement of the provisions of this Act could not take place unless and until the Section 104 order has been passed. And I think the 104 order we are talking about here, embedding no duty, no detriment, training, qualifications and experience requirements is entirely in keeping with standard practice within medicine, and therefore we're not even looking for anything that deviates from that at all. So the expectation that either the UK Government and Scottish Government, who I think have operated in good faith throughout this process, would somehow divert off into a different course of action after the Parliament has decided to support this bill, I think is not backed by any evidence. I'll take an intervention. Martin Whitfield.
It's great for the member to take an intervention, and actually his amendment 133 is more specific than that, in that if the 104 does not deal with the question of conscientious objection, does not deal with the opting out, actually this bill can't come into force. So if I could reiterate my question that I placed to Michael Mara, does he envisage or has he any understanding of the period of time that we're looking at where this bill will be passed, potentially or not by this place, but how long before it would come into force? Because I think that's a question that's being asked outside of this.
Liam McCarthy.
I think in terms of the implementation of the Act, I mean, it's not just in relation to these provisions, important as they certainly are. I mean, there are other aspects of this legislation that will need to be taken forward through secondary legislation and guidance, and unless and until those are in place, I think medics quite rightly would have a lack of confidence in what is being what is being implemented. So I think there are a range of factors, systems, processes, training, etc., that will need to be in place before this such a process can be implemented in practice. That's what the public would expect, that's what patients would expect, and that's what medical professionals would expect. And Section 104 orders, and I think this was something that Stuart McMillan was alluding to, I mean, they are regularly used to make consequential modifications to reserved law to acts of this Parliament. A recent example would be the right of celebrants not to participate in ceremonies under the Equal Marriage Act, passed unanimously by this Parliament. Sorry, Stuart McMillan.
Stuart McMillan.
Thank you. Thank Liam McCarthy for taking intervention. I'll refer back to the Delegated Powers and Law Reform Committee once again, because earlier on in this session, 2 SLC bills came through the Parliament, and Section 104 orders were required for movable transactions and the Trust and Succession Bill. The point that was put to our committee consistently was it would take 18 months for a Section 104 order to go through the full process in Westminster before anything would then come out at the end. So obviously the question that Martin Whitfield just asked regarding that length of time, does Liam MacArthur, do you consider that 18 months' time is what you'd be looking at, or would you imagine it would be, would Liam MacArthur imagine it would actually be expedited?
Liam MacArthur.
I think it's not necessarily a question I feel equipped to answer, other than to say that if you look at the way in which both the Scottish and UK governments have approached this issue, recognise the neutrality of both. There was not an opportunity to take forward these measures, these discussions around Section 30 and Section 104 orders until the Parliament had stated its will on the principles of the bill. As soon as we did that in May last year, both governments, I think, have worked at pace to put in place arrangements that allow the reserved elements of this to be dealt with appropriately and fittingly. In a second, Mr McMillan. I think where we go from here, as I say, it's not something I can judge. I think in terms of the implementation period for this bill, if you look at other jurisdictions, certainly 18 months, 2 years is not unusual for the implementation process. Some have taken longer. Very, very few have taken less time. And therefore, I think the public would expect this to be expedited in an appropriate fashion. But I think there's cause for some optimism that the track record of both governments over the last certainly 6 months or so in taking forward these provisions would give, as I say, cause for optimism that approach will continue to be taken going forward. Mr McMillan.
Jamie Hepburn.
I recognise he is strictly correct that this isn't an unusual process in terms of the implementation of acts of this place, and he cited other examples, but he must, I presume, recognise, given the substantial nature of what we're legislating for, at least recognise and understand the great unease with which this is putting many of us in here, because there is no clarity. I mean, I recognise, I don't doubt there's been good faith interaction between both administrations, but the simple matter of fact is we do not know what we contain within that Section 104 order, and that is a very frustrating area for us to be in as a Parliament, I think.
Liam MacArthur.
Look, I can acknowledge the frustration to some extent. I would share that frustration, but I think there are sensitivities enough in this issue, in the issue around assisted dying, without using it to kind of stretch the parameters of the constitutional settlement. I have always taken the view. In a second. I've always been clear that in terms of taking forward my bill, I would seek to maintain it within the competence of this Parliament. That was the decision of the presiding officer in allowing the bill to be introduced in the first instance. And as I said, I think until the point at which the Scottish Parliament took a view on the general principles, the elements that fell within legislative competence that I was told at the start of this process would take 18 months, as Stuart McMillan just alluded to, in order to resolve, have been expedited in short order. Arrangements have been put in place to ensure the will of this Parliament is reflected, taken forward in that 104 order. What we're talking about is a no duty and no detriment, training, experience and qualification provisions that are reflected in the way that other legislation relating to health and care professions operate at present. It is very clear the content that needs to be in that 104 order. I have no doubt whatsoever that the Health Secretary and Scottish Government, after the next election, will be committed to taking forward that process in the same way in which it's been taken forward to date. So yes, I understand the frustrations, but as I say, in order for the will of this Parliament to be reflected, this bill, if it's passed, will come under legal challenge. There is no doubt. We've seen opponents of this legislation already fundraising and organising to challenge the legislation that is already passed in the Isle of Man and in Jersey. I think it's safe to assume the same will happen should Parliament pass this legislation. So what we need to ensure is that what we put in place is robustly safeguarded, but is also defensible in the light of any legal challenge. I'll take a brief intervention.
Jeremy Balfour.
Jeremy Balfour.
I'm grateful to the member for taking it. I wonder if I could bring him back to a particular point of my amendment. I brought a very similar amendment at stage 2, which he and the committee said no to. So that was to allow Secretary, other people who are involved in the process to also opt out, and that was rejected. Is he now of the view that anyone who has an objection, whether it's a secretary or other people, pharmacists, should be allowed, or is he still of a view that it should only apply to doctors and nurses?
Liam MacArthur.
I still believe it ought to be those that are directly involved in the process. I also believe that it should be an individual conscientious objection rather than an institutional one, and I'll touch on that in a second. I will make a little bit more progress, if I may. In this case, the intention is that both governments would supplement my bill in order to make provision considered necessary within the identified reservations. I note the strong commitments given by both the UK and Scottish governments that such protections set out in my bill, as amended at stage 2, will be reinstated through the Scotland Act order process. I recognise that we are in territory here where recent experience may colour the perspective of colleagues depending on where they sit in this chamber. However, I would point to the fact that both Scottish and UK governments, as I said, have already shown a commitment to respecting the will of the Parliament and to making any act workable and defensible to legal challenge on legislative competence grounds. They've worked at pace and promoted a Section 30 order which has been passed here and at Westminster to transfer competence to specify substances and devices for the purposes of lawful assistance. Similarly, they've agreed a way forward through Section 104 order process in addressing issues relating to training qualifications and the regulation of professional bodies. I have confidence in this mechanism, which is used routinely and where I am not aware of any instance in which an order agreed by both governments has not subsequently been taken forward by the UK government. This is why I have decided to make way for this process to take place through removal of the provisions to be taken forward through the Section 104 order route. I urge members to vote for those and similar amendments in my name, so that the necessary protections members wish to see in place for health professionals can be provided. Can I also refer members to the Amendment 133 in this group? It was suggested by the BMA and it would ensure that if passed, the bill could not be substantively commenced unless and until appropriate protections for medical professionals are guaranteed. It is worth also noting that the substantive provisions of my bill are commenced by regulations, I think as Pauline McNeill was alluding to. As such, Scottish ministers will already be required to be satisfied that all necessary arrangements are in place before commencement. However, in light of concerns around the fact that these protections will only be reinstated after the passing of my bill, concerns, as I say, I fully appreciate, I wanted to go further, and Amendment 133 should provide further reassurance to members of this Parliament, as well as practitioners and their representatives, that they will not be left without protection. I strongly urge members to vote for these amendments in my name, without which, as mentioned, the Scotland Act order process cannot take place. I'll take a brief intervention. Martin Whitfield.
Martin Whitfield.
I'm very grateful for the brief intervention, and indeed to your Amendment 133 to give reassurance to those who are concerned about the extent of it. It does talk about individuals and then including health professionals, so it is potentially more broad than has perhaps been indicated in the debate this afternoon.
Liam MacArthur.
Grateful to Mr Whitfield for that very welcome point. I strongly urge members to vote for those amendments in my name, as I say, without which the Scotland Act order process cannot take place. On that basis, I can't support and urge members not to support Pauline McNeill's Amendment 226, Jeremy Balfour's Amendment 227, Fergus Ewing's Amendment 228, which seeks to amend Section 18, or Daniel Johnson's Amendment 17, which seeks to establish an opt-out for organisations, to which I remain firmly opposed for the reasons I set out at stage 2. This bill is about choice for individual patients as well as for medical professionals. That choice cannot be reflected in an organisational or institutional opt-out. For the same reason, I can't support John Mason's Amendment 231 and Paula Kane's Amendment 232 on the same issue, and Jackie Bailey's Amendment 229, which also addresses that issue as well as other reasons by which a person may not participate. Likewise, for these and other reasons, I don't support Fergus Ewing's Amendment 230. Amendment 142 from Miles Briggs adds a new section to require ministers to establish and maintain a register of health professionals who can carry out functions under the bill. These professionals would only be included in the register if they had opted to assist eligible terminally ill adults to end their own life, have obtained any qualification and experience that is required under the bill, and are willing to carry out that role. For reasons outlined above in connection with the removal of Section 18, along with the forthcoming debate on training-related amendments, an issue which I expect will also be covered in the Section 104 order, I can't support these amendments and urge members not to do so. Such matters should be left to the Section 104 order process, and amending the face of the bill in this way risks legal challenge should the bill be passed. That said, I hope that Miles Briggs can be reassured that once the Section 104 order is made, and with the commitments that have been made by the Scottish and UK governments, that ahead of commencement the Scottish Government would engage with the health sector on matters such as the best way to ensure effective protection for medical professionals. It's likely that this would include consideration of registers such as that reflected in this amendment and other amendments lodged at stage 3. Perhaps the Cabinet Secretary may draw on this in his comments. It also applies to Jackie Bailey's amendments 7, 8 and 20, which deal with the provision by regulations for a register of psychiatrists eligible to undertake assessments for the purposes of Section 7.2b. I'm aware that Jackie Bailey has worked closely with the Royal College of Psychiatrists on these amendments. Indeed, in my own discussions with the Royal College, I acknowledge the potential benefits of such a register. However, as well as the legislative competence issues, I note the Scottish Government in its commentary also flagged issues around potential misalignment with existing professional regulatory frameworks. That said, it may well be that any such issues could be ironed out prior to commencement, so too with the issues arising in the context of Miles Briggs' amendment. For now, however, I can't support amendments 7, 8 and 20 in Jackie Bailey's name or 142 in Miles Briggs's. Michael Mara's amendment 148 is concerned with Section 4A of the bill on the duty to direct registered medical professionals unable to or unwilling to act. It seeks to allow doctors not to signpost on a position that is out of step with current practice in other areas of medicine. I fully support the right of any registered medical practitioner not to participate directly for whatever reason in this process. However, this right should not create an absolute barrier to access to assistance and support for the terminally ill adult, which would be the effect of this amendment, enabling the dying person to continue to seek legal assistance under this Act by referring, directing or signposting to another practitioner who may be willing, or directing them to information about assisted dying, appropriately and effectively balances and protects the rights of all involved. Very briefly, Michael Mara.
Michael Mara.
Does he recognise on that basis that if he refuses this amendment, that there will be a fewer number of people working in our palliative care sector?
Liam MacArthur.
I don't accept this at all. It's not something we've seen in any other jurisdiction where concerns were raised in advance of the legislation being passed. The expression of the strength of that feeling, I understand, is measured in the threats to leave the sector. I find it difficult to see a situation where practitioners who've been committed to a sector and the delivery of palliative care all their lives will walk away from a profession on the basis of a choice being available within which they do not need to actively participate. No. I also note that the Scottish Government's concerns on legislative competence, and for all those reasons I ask Mr Mara not to press Amendment 148 and urge Parliament not to support them if he does.
Thank you. And I call Daniel Johnson to speak to Amendment 17 and other amendments in the group.
Thank you very much, Presiding Officer. We are dealing with profound moral issues, issues of conscience. Therefore, individual opt-outs and indeed, I think, organisational opt-outs are absolutely fundamental. I'm not going to repeat many of the arguments that we've heard so far in this grouping around individual opt-outs, but I think organisational opt-outs are equally important, because I don't think there is as hard a distinction as is being set out by Liam MacArthur. And I think in particular when we think about hospices, we are not talking about large, impersonal institutions. By their very nature, they are small, intimate and personal. And I think it is up to each hospice and indeed as an organisation to think about how including assisted dying might impact on their practice, influence the people working within that organisation and indeed the patients within the hospice, and I acknowledge that not all hospice patients will be, but many are, how it might impact them. I'm happy to give way to Ruth Maguire.
Ruth Maguire.
Thank you. Just briefly, I wonder if he would accept the point that whilst
folk working in hospices have dedicated themselves to a career. This proposition is quite a different thing for them, and I think that needs to be acknowledged. Not for everybody, but for many people working in palliative care. This is almost the opposite of what they're doing at the moment.
Daniel Johnson.
I think Ruth Maguire makes the point excellently. For many people, they will be able to incorporate this in their practice. It won't be, and I think to say this is sort of binary, I think would be wrong. But there will be many who are deeply troubled by this. And what is more, working within a small environment with a small number of patients, with a small number of colleagues, again would be troubled by this. And I think those organisations themselves therefore need to reflect that. Now, I did bring forward a similar amendment at stage 2, and this is different, because I do also think that the considerations for organisations differ to those of individuals. In that I think that it is deeply problematic to obligate individuals to do anything, including signposting, and I agree with Michael Marr's amendments. But I think for some of the reasons that were alluded to by Liam MacArthur, I think if we are going to provide an opt-out for organisations, I think it's important that we provide some ability for those individuals to be signposted to other organisations or services that might be able to help them if they choose to avail themselves of the provisions of this bill. I think particularly, I think it is reasonable to... I'll give way just in a moment, if I could just complete the point. That people may find themselves in hospice, having not contemplated using the provisions of this legislation, and they may change their mind. Now, while I believe that the organisations have a right to opt out because of the wider implication, I think there is then an obligation to try and provide them with the ability. It would be not fair to exclude those individuals from using this legislation simply because of the hospice that they chose or found themselves in because of particular circumstances when those circumstances have changed. And I'm happy to give way.
Patrick Harvey.
I'm grateful. I wonder if Daniel Johnson would reflect on one of the other objections to the idea of an organisational opt-out. He said that this should really be about the patients. If Parliament decides that we should pass legislation that allows a degree of choice to access assisted dying in these circumstances, the implication of an organisational opt-out is that somebody reaching the final stages of a terminal illness, often with highly complex care, would effectively be told that they have to move to another location in very difficult circumstances in order to exercise the choice that Parliament would have decided they have a right to exercise. Surely that's the unintended consequence of an organisational opt-out.
Daniel Johnson.
Look, what I do accept is that there are some very finely balanced judgments here, because while I acknowledge the points that have been made, that it might mean that, although I don't think necessarily it does, I don't think it prevents an organisation necessarily providing access to, although I won't take care about that. More importantly, there is a flip side to the situation that Mr Harvey sets out, which is that by obligating organisations to take part, you are necessitating them to you essentially put both their professionals and indeed other patients in a context that they may be being confronted with a practice that they have fundamental moral objections to. That might mean those people avoid those institutions. That might therefore in turn mean that those organisations find it difficult to continue or operate in a way that they are comfortable with. For some organisations, especially those with a religious foundation, it may mean that they feel that they can't continue to operate at all. And I think we have to acknowledge there's a great number of hospices that do have a religious foundation, albeit one that might be in the past, but some of that is very much present. Happy to give way to the First Minister.
Kate Forbes.
The member would agree with me that the one core element of choice is, of course, a well-resourced, well-provisioned service with staff. And I know that Liam MacArthur had suggested that nobody will leave, and yet we know that a survey by the Association of Palliative Medicine found that 40% of palliative care doctors would leave on account of the fundamental shift in the service. And of course, choice is strengthened by hospices being available. And has he heard from any who have said to him that they will indeed close if they are forced to provide the service?
Daniel Johnson.
I have to say I've not heard from hospices themselves indicating that, but I certainly have heard from practitioners who have indicated in that regard. And I would just conclude this. My amendment seeks to strike a balance, to enable those organisations to opt out, to carry on in a way, but also to uphold a degree of responsibility to those in their care who may choose to use the possibilities that this bill seeks to enact. Therefore, this strikes a balance in comparison to the other organisational opt-outs, which are more categorical and don't strike that balance. And I do believe that the considerations for an organisation are different to an individual in that regard. And I'll leave my remarks there. Thank you, Presiding Officer.
Thank you. I now call John Mason to speak to Amendment 231 and other amendments in the group.
Thanks very much, Presiding Officer. And really just to concentrate my own amendment, but touching on some of the others, there's clearly been quite a few amendments around this whole area of opting out and conscience and all the rest of it. And mine, like Daniel Johnson's, purely focuses on organisations, which would introduce a new section to the bill for the purpose of an organisational constitutional objection. It's surely completely wrong that organisations should be compelled to participate in the provisions of this bill when they are providing a service for a very different reason, for example, a care home. Every organisation has values, and for faith-based organisations, these values are potentially incompatible with the introduction of assisted dying. We cannot find ourselves in a situation, if this bill should pass, whereby organisations are forced to participate by the state in the ending of life against their principles and wishes. Or presumably their only other option, as has been mentioned, would be to close down. And we are not in a position to lose hospices at this time, or care homes for that matter. Both sectors need to be expanded. If we pass this bill without this amendment, the state could be actively forcing participation in assisted dying by organisations who desire nothing to do with it. For example, are we going to force the likes of the Salvation Army, whose poverty alleviation work is so widely appreciated, to take part in assisted dying against their wishes and conscience? I'm conscious that a similar amendment was rejected previously because it was felt that... Sorry, Ross Greer wants to give way, yes.
Ross Greer.
I'm very grateful to Mr Mason for taking the intervention, because I started off when this debate started broadly in favour of an organisational opt-out, but the more I thought about what that would mean in practice, the more I realised it would result in people ending their lives in the most undignified of way in the car parks of hospices that they might have went into with no intention of seeking an assisted death, but changed their mind once they got there. And on balance, I would prefer that the individual had that right. Mr Mason's argument is that the organisation would be compelled to participate. Given the protections that we've discussed in relation to individual practitioners never being forced to participate, surely it's a question of whether the organisation should have to facilitate that, allow outside medics in. And on that basis, the parallel that I think of is if a faith-based organisation ran a hospice but was sincerely of the view that blood transfusions were unacceptable, I don't think it would be acceptable for them to deny paramedics access, for example, to give someone a blood transfusion. Surely this is an argument about access. It's not about compelling the organisation to participate. It's about allowing access to medical professionals so the individual patient has the right to make that choice.
John Mason.
Yeah, I mean, I think that's a pretty extreme case, and I'm not aware of any medical facility in this country that does not allow access for blood transfusions or similar. So I think there's a fundamental difference there. And I think it's all very well saying, and Daniel Johnson had the same argument, that such organisations, hospices and care homes should be able to refer people to others where they want. But that in itself goes against the ethos of these care homes and hospices. Because if their aim is to protect life, not necessarily to extend life indefinitely, but to protect life as much as they can, even just encouraging or allowing somebody to come in and talk and encourage perhaps assisted dying is fundamentally against their ethos. So I just don't think, Mr Johnson said that he was striking a balance, but I don't think he has. There's something fundamental. If the ethos of your organisation is to protect life, then encouraging or allowing people in to go do the opposite has got a real problem. I think Mr Briggs is coming in.
For taking this intervention, I think one of the aspects of this, and everyone's talking about hospice, is not just the hospice. Most people are at home. And I think one of the key things is that's where the vast majority of people want to die and are telling us that's their wishes. Under his amendment, would that therefore be that he wouldn't expect people to then be supported at home
by these organisations as well, or just within the hospice boundaries? I'm not quite sure from his amendment what he's actually trying to achieve, and if that's the case, the capacity that would remove for people being cared for at home would be vast.
John Mason.
Well, if it's a religiously based hospice, which is providing a service both within its own premises, and I think most of them actually provide a larger service or greater service outside, then I think the two very much go together. And I cannot imagine people who are opposed to assisted dying in a hospice then going out and helping people take part outside the hospice. So, yes, okay.
Lorna Slater.
I'm rising to say that I object very strongly to the members using the words encourage. There is no encouraging here. There is allowing people to understand their options so they can make an informed choice. I would ask the member not to use that word, please.
John Mason.
Yeah, I think that's a fundamental point. It's quite a good one. I don't know if the member has seen the Japanese film Plan 75, which was extremely good and raised some of these issues. But this is back to the question of drift, that when we allow this to start with, then shortly afterwards it becomes encouraging. So the two do go together, and that's one of my fundamental objections to this bill, that it will lead to encouragement by whoever. So, colleagues, just to sum up, really, I hope you will vote for my amendment, or at least one of the other amendments that covers similar ground. Thank you.
Thank you. I call Paul O'Kane to speak to Amendment 232 and other amendments in the group.
Thank you very much, Presiding Officer. And my amendments follow in the vein of other amendments around organisational opt-out. And I would accord with much of what has been said already in the debate around both individual opt-out, which I know we have covered and will cover, for medical professionals, not least doctors, but also I think those organisational opt-outs, which are important in particular for those organisations which hold a certain ethos, and usually that is a faith-based ethos. Now, I followed this debate at stage 2, in which Stuart McMillan had brought particular amendments, I think co-designed with the Salvation Army, and the Salvation Army was referenced again this evening. I do think the debate in stage 2 and some of the services that the Salvation Army run are not perhaps the best examples of trying to understand fundamentally what it is we're talking about and the need for an organisational opt-out. And that's not to do a disservice to the excellent work that they do. But I think what would be really useful in the debate this evening and throughout the debate is if we deal with really clear examples of where there will be a significant challenge and problem, rather than trying to deal, I think, in broad concepts, which lead us, I think, to comments like I heard from Mr Greer about people being left to die in car parks. I really don't think that's helpful. And I think what we need to do is focus on what actually happens in practice just now and where the potential pitfalls would be. There's an example, I think, that we can look at quite clearly, which is religious orders of the Roman Catholic Church who deliver social care. Now, that is something that the Church has done for centuries, and it's something that has happened in Scotland in various ways for well over 160 years, if I use the example of the Little Sisters of the Poor. The Little Sisters of the Poor have care homes in my region, in Greenock. They have a presence in the city of Glasgow. They have had a presence in places like Dundee and Edinburgh since about 1863. And what they do is they provide care within the charism of their religious order. So the entire delivery of their care is in line with the vows that they have taken as religious sisters. And you can't decouple the two things, because the administration and the running of their care homes is done by religious sisters. The registered manager, indeed, of Holy Rosary Care Home in Greenock is a religious sister. So it's not like these two things are entirely separate and set apart. They are interwoven and they are interlinked. And therefore, the significant challenge of having to either offer through health and social care frameworks assisted dying, or even having to advertise or undertake any of the discussions that may be required through the Health and Social Care Partnership will be a direct conflict with the charism and the ethos of the organisation, and indeed the vows to which those sisters have committed themselves. So I think that is clearly a challenge where we would require an opt-out for an organisation. And in saying that, I think what is also clear is that we have to ensure that within that we are very clear at the outset of somebody choosing a care home or choosing a hospice facility that they know what the ethos and what the direction and what the view will be around assisted dying within that facility. I think we're missing that point somewhat within this when we say somebody would have to leave and find another facility within a very short space of time. I don't think that would be true if we were all very clear about who was opting out and who was opting in. Yes, I'll take Mr MacArthur.
Liam MacArthur.
I'm very grateful to Paul O'Kane, and I've been listening with interest and some sympathy for some of the points that he's making. I think that the point that was made earlier, though, is that individuals' view on whether or not they would seek to access this choice may change over time, and there are those that could find themselves entirely willing to sign up to whatever the restrictions were in the home or the hospice they were going into, but in due course, if their position changed, there would not be the flexibility to respect that, and how in those circumstances you would manage those situations, often certainly in a hospice community where there will be a variety of views amongst the wider community.
Paul O'Kane.
Well, of course, I do recognise that can be the case, and I don't think it would be unusual then for there to be a considered approach to that, to be a compassionate approach to that, to ensure that consideration can be made about an alternative provision that would be appropriate. And I'll just finish this point and then I will give way to Mr Mara. But I think principally within that, when somebody inquires about that or asks about that in the setting that I'm talking about, for example, the care homes of the Little Sisters of the Poor, the sisters themselves are then placed in a position of having to decide what is right by the law and what is right in order to give that person the best support possible when they cannot in good conscience refer them to or reflect the wishes on assisted dying. Mr Mara.
Michael Mara.
With Mr O'Kane, I recognise that actually what Mr MacArthur and Mr Greer have said already is frankly a fallacy, because these institutions just wouldn't exist. They would close. The Catholic Church would not operate these care homes in the circumstances if they do not have an institutional opt-out. So they will close, they will remove the facilities that are available to communities across Scotland as a result.
Paul O'Kane.
Mr Mara is very helpfully moving me on just to that point in the interest of time, which is there is serious concern within the Catholic Church in Scotland that these organisations would cease to exist. As I said in my opening remarks, the Little Sisters of the Poor have cared for people in this country since 1863. Over 160 years of work in this country, which may be at risk because of the way that the legislation may be drafted. And I think also part of the reality within that is because their funding is, of course, largely dependent on the provision of social care through acts of this Parliament, which then gives them the funding that is required. If it were to be removed, that would make them financially unviable, even if they chose to continue in some form. It has been referred to by colleagues with other examples of where assisted dying legislation has been passed and religious groups have found it hard to operate. I'll take Mr Doris.
Bob Doris.
I thank Paul O'Kane for giving way. I've got sympathy for his amendment. I want to distinguish it, I think, from the mention from Mr Mara and Mr Balfour with a similar policy intent. They both have got this right, have explicit... they're very clear that you don't have to signpost to others. I've got issues with that. Mr King, yours is silent in relation to that. So could we expect, if an organisation under your amendment doesn't involve itself in assisted dying, they would compassionately signpost somehow, or at least make those vulnerable people aware of where they could seek assisted dying?
Always through the chair, Paul O'Kane.
I mean, I do recognise that my amendment is perhaps broader than others in some ways and perhaps not specific in the ways that Mr Doris outlines, but my entire sense of the ethos and charism of these organisations is that they would compassionately signpost. And whether you can legislate for that or not, I think is for the wider debate here this evening in terms of the competing amendments. But that certainly would be my view, knowing the organisations as I do. I am conscious, presiding officer, of time, but I think rather than trying to debate these issues in a sort of broad academic context or in a vacuum. We do actually have to look at where there has been delivery of services, both in terms of older people, those with a disability, those at end of life, those who are particularly vulnerable, which has existed in Scotland for many, many years, as I've said, and the impact that this legislation would have upon them, both in terms of practical application of their services, whether they would be able to continue to deliver their services, whether they would continue to fund, or whether, as has been pointed out by many colleagues, they would be able to exist at all. And I think it would be to the detriment of this country if we did not have that rich variety of care that is offered, that allows people to choose a setting that is right for them, in line with their belief and the way that they want to live, very often the latter stages of their life, and indeed have their death. So I'm very grateful.
Ross Greer.
Thank you. I want to speak in support of Amendments 107 and 133 from Liam MacArthur. I'm speaking to these now, particularly speaking to Amendment 133 now, because I have amendments to that amendment, but they're heard in a later group. It's not that I lack support for the substance and the intended outcome of other amendments in the group, but because of the concerns around legislative competence with a lot of them, which I will come back to. We've heard the view from the member in charge in the Scottish Government that we need to remove the protections for those not participating and then rely on a Section 104 order or the like to reinsert them. I do support the approach taken in Amendment 133, which makes commencement of the bill effectively conditional on the UK Government reinserting these protections, and I welcome that 133 refers to both no duty and no detriment. So for those watching at home with concerns, this does effectively mean that the bill cannot come into force, the system cannot begin without these protections being put in place. I was working on a similar amendment, so I'm grateful to Liam MacArthur for engaging and reflecting my feedback in drafting, particularly given the feedback that I'd received directly from so many GPs in my region. This position would sit the bill within the confines of the Scotland Act. I still don't think we're in a satisfactory situation, though. We are effectively debating a bill with a gap in it, and we're being asked to trust that that gap will be filled by the UK Government. I don't intend on bringing our usual constitutional politics into this, but it does seem obvious to me that if this Parliament and Government are making arrangements and making a decision on whether to introduce an assisted dying system or not, it should be this Parliament and Government who decide the specifics of those arrangements. Yes.
Kate Forbes.
I agree with what Ross Greer says there in terms of the democratic deficit here, where we are, as Daniel Johnson said, dealing with very profound moral issues. We will be passing the bill, but then we are leaving it to our workforce, our doctors and our nurses, to actually implement it and make the very challenging conversations with patients. And so there is that deficit between us passing it and then somebody else being responsible for bringing in the protections for the workforce. And does he feel that big chasm in the gap of responsibilities?
Ross Greer.
I'm grateful for that intervention, because I do feel acutely aware of that gap, although I do think, and I'll come on to this and how 133 and 133A and B interact, how I think we can bridge that somewhat. But I do want to just briefly talk about how we got to this point, though. So the Cabinet Secretary's letter to the Health, Social Care and Sport Committee last Thursday said that the Scottish Government had received the in-principle commitment to a Section 104 order from the UK Government on the 3rd of March. Now, that was after the Stage 3 lodging deadline. He referenced in that a letter from the UK Government confirming this would go to Westminster's Scottish Affairs Committee in the coming days. Now, Presiding Officer, last night I had to write to yourself, the Cabinet Secretary, the Member in Charge, the Non-Government Bills Unit, saying that we as a Parliament cannot be expected to make an informed decision on a fundamental issue like this based on second-hand information, much as I wasn't calling into question what the Cabinet Secretary provided us with. At that point, the UK Government still had not provided that letter to the Scottish Affairs Committee. That letter was published this morning. It's been quoted a number of times already in this debate. I just want to read one line of it. It said, "This in-principle agreement is in relation to employment protections and professional qualifications and experience." End quote. The details on that are to be confirmed later. On the duty to participate, the letter from the UK Government does at least provide reassurance that there will be both that no duty and no detriment provisions for those who opt out. I am frustrated, though, that the competence issues in relation to poison control and conscientious objection were well aired well ahead of time, certainly well ahead of the Stage 3 lodging deadline. But the apparent need to remove all training, qualification and experience requirements came at the very last minute, too late for many members to alter their amendments in this group to be compatible with that new reality. So I would ask the Cabinet Secretary to clarify in particular the point that Miles Briggs and Jackie Daly made in relation to the 2003 Mental Health Act. My understanding, and I will not claim that my research on this is perfect, but my understanding is that that Act did require a Section 104 order, but not for the register that is being used as a precedent in this case. So that suggests that the UK Government has in the past agreed that this Parliament has the power to set up equivalent professional registers, and I would be keen to hear from the Scottish Government why they believe, or if they can relay from the UK Government, the current UK Government, why they believe that that is not within devolved competency. Now, we'll come to the wider questions around training, qualification and experience in Group 5, but I do want to briefly cover how Amendments 107 and 133 in this group interact with my 133A and B in that group. As I mentioned to the Cabinet Secretary at the start of this debate, the UK Government's letter refers to both qualifications and experience and training, qualification and experience interchangeably. And I would like to ask the Cabinet Secretary ahead of Group 5 if at that point he could clarify why the Scottish Government believes that training is out with competence given this mismatch in the wording that is being used. I support 107 without enthusiasm, but I do believe it's necessary. I think we should be deciding this bill, our final decision on this bill should be on the basis of the ethical question concerned, not questions of legislative competence. But that is a hard balance to strike. The more that we take out to ensure legislative competence, the more detail about the operation of the system and its safeguards we put beyond this bill and leave unanswered for now. There are some mitigations against that. As I said, I worked with the member in charge to ensure that 133 specifies in advance that this Section 104 order covers both the option not to participate and no detriment if that is the case. And I would ask members who are concerned about what Amendment 107 removes to support it on the basis of both 133 and, once we get to them, either 133A or 133B. They are alternative options. With 133, the bill will be legislatively competent. No assisted dying system will commence without professionals having the option to opt out and being protected from any detriment if they do so. And critically, should 133 and then either 133A or B pass, it will not commence until training, qualification and experience requirements are set out for the professionals who choose to be involved. And if that combination of amendments does not pass, I will certainly reflect very carefully before I vote at the final stage on this. But I would ask members at this point to support 107 and 133. Yes.
Martin Whitfield.
Grateful for Ross Gray taking the intervention, and I agree in a large part with his thesis about the amendments. I posed the question to others, and I posed the question to the member: how long does he envisage, or has he any idea, before this bill actually, if it does pass here, come into effect and people see the results of it? Because I think there's a disjoint between the expectation of what might happen next Tuesday and when it will come in.
Ross Greer.
Briefly before I close, Presiding Officer, I do think that's a fair question. I do not know the answer to that question. I don't think anyone in this Parliament truthfully knows the answer to that question. What gives me comfort in that regard, though, is that before the system can commence, this Parliament will have to approve commencement regulations. And if we agree to this combination of amendments, 107, 133, and then either 133A or B, it cannot commence without all these protections: the no detriment protection, the no duty to participate, and minimum standards of training, qualification and experience. I can't say when that will happen. I think it is completely unsatisfactory that the current devolved settlement leaves us in this situation. But regardless, at whatever point, whether it's in the first year of the next Parliament, the last year, or even in a Parliament beyond that, I don't know. All I know is at that point, Parliament will have the final say. It will have the power of veto through the commencement regulations. Thank you.
I call the Cabinet Secretary.
Presiding Officer, the Scottish Government has some significant concerns with amendments in this group insofar as they relate to reserved matters or novel issues within our legal system. I will come to those, but I will start with Mr MacArthur's Amendment 107, which seeks to remove Section 18 from the bill. I very much understand the sensitivities of this amendment, and I too have received correspondence and representation from medical professionals deeply concerned about what the removal of this section would mean for their ability to object to participation in an assisted death. I want to make clear to members and to those who have raised concerns that the removal of these provisions does not mean that this matter cannot or will not be addressed. As we have said before, it is the Scottish Government's view that Section 18 may relate to the H1 employment reservation. As such, this section should be removed from the bill because it is our view that it may be out with the legislative competence of this Parliament. The Scottish Government has been engaging constructively with the UK Government on this matter, and it is our intent to seek to resolve these matters should the bill pass via a Section 104 order. The UK Government has given in principle agreement to take such a Section 104 order forward to make consequential provision for individuals and practitioners to opt out of participating in assisted dying and providing appropriate employment protections. Should the bill pass, the Scottish Government will continue to engage closely with the UK Government on the form that the Section 104 order will take. I appreciate, and we have heard it, that for many members, I'll come to Mr Hepburn in a second, I appreciate that for many members and medical stakeholders it would have been a strong preference that these matters be addressed ahead of the final vote on the bill, just as the matters around the approved substance and medical devices for use in assisted death have been enabled by the Section 30 order. Mr Hepburn and others have understandably made this point. The Scottish Government discussed with the UK Government whether all issues identified could have been addressed in the Section 30 order. However, the UK Government's view is that in order to respect the distinction between reserved and devolved matters, anything that could be dealt with by Section 104 order should be dealt with in that way, with changes to legislative competence, i.e. a Section 30 order, being kept to a minimum. And on that, I give way to Mr Hepburn.
Jamie Hepburn.
I won't make the point again about the Section 30 process, but can the Cabinet Secretary set out how, or if the UK Government has itself set out, how any divergence of opinion between the Scottish Government seeking to implement the will of this Parliament and their interpretation of matters will be resolved?
Cabinet Secretary.
That is a fair question from Mr Hepburn. That will be subject to negotiation, there may well be differences of opinion, but it will be subject to negotiation. But I give the commitment that I gave earlier in debate that I would seek to give, if I were the Health Secretary or the responsible Minister, seek to keep Parliament as informed as I can. I will give way to Mr McMillan first.
Stuart McMillan.
Thank you, President Officer. I thank the Cabinet Secretary for taking the intervention. Can the Cabinet Secretary provide some information with regards to why the process for this bill is different as compared to the previous bills that the Delegated Powers and Law Reform Committee actually looked at? Bills that were non-contentious, very technical, but we were informed that we're going to take up to 18 months to go through the process, whereas this one seems to be short-circuited.
Cabinet Secretary.
If I understand Mr McMillan's question correctly, he is asking about how the Section 30 order has been able to be resolved quicker than other processes. That is down to the good faith negotiations that Mr MacArthur rightly referred to, and the ability of us to get to an agreed position. I think I was to give way next to Ms Hockey and then Mr Balfour.
Claire Hockey.
Thank the Cabinet Secretary for letting me intervene, and I'll put on record my register of interest, which I hadn't done earlier. Cabinet Secretary, can you understand why, given what we're being asked to vote on without this legislative protection for health staff, how nervous a lot of staff and indeed their representatives would be should this bill pass?
Cabinet Secretary.
Presiding Officer, yes, of course I do. I share that. And I understand it completely. We are in a position where we need to look to provide, should the Parliament's will be to pass this legislation, to provide the necessary protections, but also I am compelled to inform Parliament, given the Government's neutral position, but also our obligation to protect the statute book, to ensure that we're pointing out areas of legislative competence, legal deficiency or other technical issues. So I recognise the challenge that there will be. I pass no comment upon those, except to say that should we not pass the Amendment 107, for instance, or we accept some of the amendments that I will come to, we will potentially fall foul of the Supreme Court in this matter. I give way to Mr Balfour and then Ms Nicholl, and then I'll need to make progress.
Chairman Balfour.
I'm grateful to the Cabinet Secretary. I wonder if the Cabinet Secretary could help me out. There's obviously a clear difference among some members in regard to how far we should go. Should religious institutions be allowed to opt out? Should people who aren't medical professionals, secretaries, such as my amendment, have? Now, my understanding is that we won't vote on these amendments, because if we were voted them, they would make the bill incompetent. So how will he or his successor after the election know what this Parliament wants to be opt-out? Because we are not being allowed the decision to tell you how we want you to act. And I'm worried that it'll be you or your successor will be left in a very difficult place for that.
Always through the Chair. Cabinet Secretary.
Presiding Officer, I will come to that point in a second, because I heard Mr Doris's point in this regard. I'll give way to Ms Nicholl, and then I'll make progress to cover the amendments.
Audrey Nicholl.
I thank the Cabinet Secretary for giving way, and I'm sure the Cabinet Secretary is aware of a joint statement signed by 7 medical groups in Scotland, including some of the Royal Colleges, and they said, and I quote, "A Section 104 order by its nature receives limited parliamentary scrutiny," which we've been discussing this afternoon, "and matters central to professional regulation, employment protections and the rights of staff should not be left to a later process in which detailed debate and accountability are significantly constrained." So does the Cabinet Secretary recognise that the solution proposed of our Section 104 order is causing real anxiety to medical organisations?
Cabinet Secretary.
Again, I absolutely recognise the perspective that Ms Nicholl has put on the record. I cannot make any comment upon that. The Government is neutral on the bill. All I can do is set out where there are issues of legislative competence, or where there are technical issues or further ramifications that I and Government feels that the Parliament should be aware of while it is coming to a determination. And on that, turning to amendments that I wish to comment on. Amendments 226, 227, 228 in this group seek to amend Section 18. As I've already outlined, Section 18 should be removed from this bill entirely. I heard Mr Doris's point about Parliament, and indeed Mr Balfour's point about Parliament expressing a view, but if amendments potentially outside of this Parliament's competence are accepted, it risks the bill being referred to the Supreme Court. Presiding Officer, the legislative competence of the bill... I'm sorry to Mr Doris, I do need to make progress. I have tried to be as generous as I can. The Presiding Officer, the legislative competence of the bill, as introduced, was first raised by me in a memorandum in September 2024. Following the Stage 1 vote, as I have said, the Scottish Government has sought to remedy that. However, there are amendments in this group and in others later on that would also bring the bill further out with legislative competence. And as I've said, whilst it is not a requirement that amendments to bills must be within legislative competence, this Parliament does have a responsibility to consider such issues when considering legislation. So, Presiding Officer, the Scottish Government's view is that Amendments 7, 8 and 20 may raise issues of legislative competence in view of the G2 reservation regarding regulation of the health profession. Very briefly, Ms Bailey.
Jackie Bailey.
I genuinely say to you there's no problem with competence, because there's already a register of psychiatrists operated by the Mental Welfare Commission. When the legislation went through this Parliament, there was no need to have a Section 104 agreement then, and Amendments 7 and 8 are entirely in keeping with that approach.
Always through the Chair, colleagues. Cabinet Secretary.
Thank you, President Officer. I will come to that point. Mr Greer had asked for a clarification of this, as did Mr Briggs. I will come to that shortly, because this has been discussed with UK colleagues as well as our own considerations. So I will come to that. Continuing on 7, 8 and 20, it is not clear how establishing a statutory register of psychiatrists for the purposes of assisted dying assessments might align with the existing professional regulatory frameworks. There are also potential deliverability challenges in establishing and maintaining what would appear to be intended to operate as an opt-in register for psychiatrists. Similarly, for Amendment 142, the Scottish Government's view is that this amendment may raise issues of legislative competence in view of the G2 reservation. Again, I heard Mr Briggs' point around the mental health legislation from 2003, and indeed Mr Greer's and Ms Bailey has just put that on the record as well. I can clarify that we have engaged with the UK Government. We have reached our position following those discussions, and we have considered other examples of legislation as part of that process, and amendments lodged at stage 3, and we must be clear that those issues must be considered on their own merits and on their own terms. That is as much clarity as I can provide in terms of how the government has arrived at the position that we have. I'll give Mr MacArthur.
Liam MacArthur.
Just on the issue of legislative competence and following on from the contribution that Ross Greer made in articulating the importance of Amendment 133 and giving this Parliament, our future Parliament, a say over anything before it is implemented, can he confirm the Scottish Government's view is that 133 is certainly within competence?
Cabinet Secretary.
I can confirm to Mr MacArthur that, as he will hear in the remainder of my contribution on this group, as I have no comment to make on 133, that should help colleagues recognise that we do not have a concern either about legislative competence or otherwise around 133. Presiding Officer, Amendment 148 provides that a registered medical professional has no duty to participate or facilitate the provision of assistance and should not suffer any adverse employment consequences as a result. And Amendment 230 provides that any individual or organisation must not be subject to direct or indirect pressure to participate, including threats to employment. It is the Government's view that these amendments may raise issues of legislative competence relating to the H1 reservation of employment. Amendments 231 and 232 seek to provide for some form of institutional conscientious objection. It is not clear how an institution might demonstrate what their conscience position is, given conscientious objection is for individuals about personal beliefs. So this would be novel in our legal system. Finally, I turn to Amendment 229, which the Scottish Government considers may raise issues of legislative competence relating to the H1 reservation of employment. From a technical perspective, the person referred to in subsection 3 is not linked to those mentioned in subsection 2. That means, unlike in subsection 1, subsection 3 does not say a person mentioned in subsection 2 or words to that effect. This would therefore appear to have wider application, including to natural persons, which could encompass employees and their protections. For the remaining amendments in this group, Presiding Officer, the Scottish Government has no comment.
Thank you. And I call on Miles Briggs to wind up and press or withdraw Amendment 142.
Thank you, Presiding Officer. And I think this debate's really demonstrated the heart of what many of us are balancing up, and that it's not just those individuals who want access to have an assisted death, but actually those who work in this field. And during the time I was consulting on my own bill around a right to palliative care, one of the best parts of that job was meeting those who work in our palliative care sector, the passion they bring to the job, but also the delicacy around the families they will obviously always bring as well. But fundamentally, it is about trying to make sure that the person who is dying, that their wishes are fulfilled. But for so many of these individuals who have expressed this to me and expressed it to every single member of this chamber, they will not want to be involved in some of this work if this bill passes. And I want to make sure that this bill includes that voice, as other members who brought forward these amendments. I think fundamentally it has to include that. And with that in mind, I move Amendment 142 in my name.
Thank you. The question is that Amendment 142 be agreed to. Are we all agreed? The Parliament is not agreed. There will be a division. Members should cast their votes now. The vote is closed. The result of the vote on amendment number 142 in the name of Miles Briggs is yes 37, no 79. There were 5 abstentions. The amendment is therefore not agreed. I call amendment 143 in the name of Douglas Ross, already debated with amendment 2. Douglas Ross, to move or not move?
Not moved.
Thank you. At this point, I will call a suspension for a comfort break of some 20 minutes, and I would ask colleagues to be back in the chamber just after 7:15. Thank you.
Thank you. We will now resume, and we will turn to Group 4 on coercion, pressure and undue influence of terminally ill adults. I call Amendment 144 in the name of Michael Mara, grouped with amendments as shown in the groupings. I draw members to the procedural information relating to these amendments as set out in the groupings, and I call on Michael Mara to move Amendment 144 and to speak to other members of the group. Mr Mara.
Thank you, Presiding Officer. I move the amendment in my name. The amendments in this group are principally aimed at the prevention of circumstances where vulnerable individuals are coerced into giving up their own lives. I believe that this has become a growing concern among members, backed by testimony and evidence from external sources in the passage of this bill. And I do believe this is a vulnerability that's inherent in the opening up of state-facilitated death. It is this area of risk that has led me to my opposition of the bill, having entered Parliament in 2021 undecided on the issue. I have come to the conclusion that in a society as unequal as ours, as discriminatory as ours and as sexist as ours, that coercion is a risk beyond effective mitigation. A Scot can be persuaded they are a burden by one individual in their own home, or persuaded by all 5.5 million of us across their own country. The feeling of being a burden financially, practically, emotionally on those they love or for the community they live in may bring people to the lonely conclusion that their best choice is ending their life. Those pressures clearly fall more heavily on the poor, the disabled and the vulnerable. The amendments in the group seek to give protections against something which can be so insidious that it is extremely difficult to either detect or to prove. And I fear that where some of the amendments, the past parliamentarians and the wider public would have a false sense of security, which the words in this legislation would fail to provide in any real sense. Please, Mr Mason.
John Mason.
Giving way. I mean, does he think that if somebody had been coerced, however subtly, into saying that they wanted to finish their own life, would they not also make a declaration that it was voluntary?
Michael Mara.
I think that there's a distinct possibility, Mr Mason. I'll come on to my own amendment directly. In short, I am less convinced of it than at the time that I lodged it. So I do feel that Mr Mason's contention is consistent with more and more of the evidence that I have heard and seen. Defining coercion and internal pressure is difficult enough. Proving it is another matter entirely. But by no means does it suggest that it does not exist. And just last week, I hosted Dr Annie Donaldson in Parliament. She's an expert in domestic abuse and coercive control with decades of experience here in Scotland. Dr Donaldson has caused me to reconsider my own view of the possibility of improvements, and including my own amendment. The self-declaration contained in my Amendment 144 is, in her view, practically redundant as a safeguard on the basis that Mr Mason sets out. A person, normally a woman, experiencing coercive control will very rarely perceive it as such, and so they would not make a declaration. Even if they do perceive it, they may not feel empowered or able to make that declaration. These are dynamics overwhelmingly between abusive men and vulnerable women. We do know something of the scale of that abuse. Domestic abuse has increased by 44% in Scotland in the last 2 years. On the 2nd of March, Lee Milne of Dundee was found guilty of killing Kimberly Milne through systemic continued abuse. She jumped to her death. His hand did not push her, but he was her killer. And I passed the purple ribbons on a bridge in Dundee daily that have been left there by those who mourn for her and share some of the pain that she felt. Dr Donaldson told MSPs last week that her sure conclusion that assisted dying could open a new route to manipulative, misogynistic, abusive men to end the lives of the women that they abuse. Dr Donaldson sees no means by which this can be mitigated. Victims do not disclose abuse readily. It takes time with trained, experienced professionals to identify it. And even then, very often, it is not actually escaped. Bob Doris's amendments appear to be aimed at highlighting internal coercion. Unfortunately, I believe that the evidence I have seen renders these amendments functionally redundant, as internal coercion and indirect pressures are virtually impossible to identify, much less prove. I will be supporting Amendment 27 as it is at least inserts a further protection by requiring the medical practitioner carrying out the initial assessment to at least raise the issue of indirect pressures with the person who has made a first declaration. Similarly, I recognise that Brian Whittle's amendments are aimed at strengthening protections against coercion, but again, the chances of an independent assessor being able to accurately assess whether or not a person is being coerced are incredibly slim. I fear that these amendments risk making the bill look safer while making no real difference to protections from abuse or coercion. I believe Paul O'Kane's amendments are also very well intentioned, but given the difficulties in detecting, proving and training professionals to detect coercion, I will not be supporting them, with the exception of Amendment 319, which strengthens safeguards by ensuring the registered medical practitioner's statement covers the full set of safeguards listed in Section 7 of the bill. Jeremy Balfour's amendments require a registered medical practitioner to record in writing that the person's request to end their life comes solely as a result of a terminal illness and not due to disability, mental distress, financial pressure and so on. This is a noble attempt at increasing transparency and accountability, although again I am concerned it will not provide a real effective safeguard to vulnerable individuals. I will listen carefully to Ruth Maguire's justification of her amendment, which I welcome the intent behind, given the suggested process to determine that the decision is taken free from coercion. But again, I remain sceptical that any medical professional could ever confidently make such an assessment. Members will get the gist of my views in these areas. Further in this group, I am deeply concerned by Liam MacArthur's Amendment 50, which reduces the custodial sentence for coercing or pressuring someone into assisted dying from 2 years to 12 months. I cannot think of what possible justification there is for this. What possible justification? I will listen to whatever justification is given and reflect on this in closing. Surely we cannot countenance sending a signal to abusers that this is not a very, very incredibly serious crime for which they will face grave consequences. Liam MacArthur's Amendment 51 increases the fine which can be levied for coercion. It's unclear how these two amendments are meant to interact. Would Parliament not be sending a clear signal to the legal profession that a fine was the more appropriate punishment for such a terrible crime? Well, if so, that is entirely the wrong message to send. I will listen to the justification and the debate with interest, Presiding Officer, and I do move the amendment in my name.
Thank you, Mr Mara. I now call Paul O'Kane to speak to Amendment 151 and other amendments in the group. Mr O'Kane.
Thank you very much, Deputy Presiding Officer. And I would reflect on much of what my colleague Michael Mara has outlined in terms of the challenge in this bill around coercion and the need to try and deal with coercion at this late stage in the process, because it is for many colleagues across the chamber a significant hole within the bill that coercion and the potential for coercion has not been appropriately addressed throughout the process. The amendments that I have brought in this regard seeks to strengthen safeguards to ensure that declarations under the bill are genuinely voluntary. Indeed, requiring that practitioners be satisfied that a declaration has been made without coercion or undue influence, because currently the bill does not specify how coercion should be identified, nor does it ensure that practitioners have training to access relevant expertise in coercion, which I will come to in subsequent amendments in the next group. So my amendment requires practitioners to take all reasonable steps to detect coercion, pressure or undue influence, including private assessment, consideration of social and caregiving circumstances, and, where appropriate, consultation with safeguarding experts. It also requires that practitioners receive training on identifying coercion, undue influence and coercive control, including in context of dependency arising from illness, disability, age or social care need. Those are the ways in which I have sought to construct an amendment that is reasonable and that can command support. However, I do recognise what has been said by my colleague Michael Mara about how difficult it will be to identify coercion, how pressurising that could be for GPs to have to take that forward. Indeed, for much of my life before becoming an MSP, I worked with people who have a learning disability, And I would recognise many of the things that Mr Mara referred to in terms of the experience of women around coercive control with those that I worked with, who were very often very vulnerable, who didn't have a strong family network, who had lived perhaps much of their life in an institutional setting before this Parliament sought to move people into the community and try to give them a life that had choice and control. But many of those people had become vulnerable through the institutionalising of the way that they lived their lives. And many of them were very vulnerable and wouldn't be able to identify to somebody if they were being coerced into doing something. And for me, that sits at the heart of this bill, is whether or not we can provide adequate safeguards for those in our community and in our society who are the most vulnerable, that we can equip at least that, those medical professionals that will carry out an assessment and will deal with these issues to be able to do that in the most direct way possible. And that would be, of course, in private, in a one-to-one setting, and being adequately trained to do so. I would put on record at this point the interaction I've had with the social work profession on many of these issues that are contained within this group. I declare an interest, of course, as someone who is married to a registered social worker. But it is clear that the social work profession are rejecting this bill not because of the issue at hand, where they have a neutral position, because social workers will take different views on whether to support assisted dying or not. But fundamentally what they have pointed out is the concern that we appear to be forgetting about the important role that social work processes play in identifying coercion, coercive control, abuse, and all of the issues that I have outlined this evening. And having met with both Social Work Scotland and SASWA, they are clear that they are very concerned about the lack of regard that has been given in the bill to existing adult support and protection processes, or indeed to try and create new processes. And I acknowledge the amendments of Brian Whittle and others in this space of trying to sustain and provide for those social work processes to be followed. So I think we do have to take very clear cognizance that this bill may not be able to square the circle that has been posed to us tonight about coercion, about ensuring that it has robust enough safeguards to protect those vulnerable in society. And I think if social work professionals, who very often are tasked with the most difficult decisions in our society about children and young people, about older people, about people who have a disability, who are experts in their field, who have trained, who know their communities, who know these people, who know about all of the risks that exist in that space and how to identify them. If they are saying that they don't have confidence in this bill, then we have to really sit up and take notice. And I'll take Audrey Nicholl.
I thank the member for giving way, and I completely agree with his observations regarding existing legislation, including the Adult Support and Protection Act, and also other legislation such as the Adults with Incapacity legislation. I wonder if the members had a chance to think about how those acts and pieces of legislation interact, and particularly professionals working within the provisions of those acts would work together and how they would be able to collaborate and work cross-sector, if you like, in this capacity and regard to what we're discussing.
Ms Nicholl makes a very important point and a very good point, and she recognises the multidisciplinary nature of how we approach these things in Scotland at the moment. So where there is adult protection investigations, where there are child protection investigations, that is governed by a multidisciplinary approach, which would involve social work and health, police, education, those who have a relevant interest in that person. What was clear to me in the discussions I've had with the social work representative bodies is that this bill does not envisage the same process for someone who is engaging in an assisted death, particularly for those people who would be vulnerable at end of life. I'm willing to take Mr MacArthur on that.
Liam MacArthur.
Can I thank Paul Kane for taking the intervention? Well, will he recognise that amendments introduced at stage 2 do ensure now that coordinating medical professionals, indeed independent medical professionals, can consult social work, social care and other relevant professionals seeking an input where that's appropriate? Having that as mandated in each and every instance, though, would seem to be disproportionate and completely out of step with approaches that we take to similar pieces of legislation relating to social work.
Paul Kane.
I recognise what Mr MacArthur says about how the bill was amended at stage 2, but it doesn't get away from the point that the social work representative bodies still at this stage are making the point that they can't support the bill because they are concerned that it doesn't do enough in terms of what are the automatic triggers where someone is particularly vulnerable and maybe subject already to adult protection processes, to have that further layer of that multidisciplinary investigation round about them. I mean, as I say, I'm having had those conversations with the social work representative bodies, there remains a clear concern that that hasn't been addressed in the bill, and that actually could call into question long-standing professional procedures for social workers and indeed their own professional integrity. And I think the danger very often of saying to GPs that they can request that input and that advice leads to perhaps a role for independent social workers, which I think I think many people in the social work profession would want to try and avoid going down that road and rather try to keep it within our existing systems, which Ms Nicholl was raising in her intervention. So I appreciate there will be further contributions on these issues, not least there are amendments in the name of Fulton McGregor, which I know deal with much of this. But I think it is important to put it on the record this evening as we begin the debate on these amendments and to ensure that if we cannot answer the questions that have been posed to us by professionals in social work, or indeed, I mean, I was just about to sum up, but I will take Mr Greer.
Thank you. Just very briefly, I have a lot of sympathy with Paul Kane's 151 and the consequences that come from it in particular. I just wanted to ask him briefly about 172A. The provision to conduct at least one assessment meeting with the person alone and in private. In practice, how would he envisage that taking place where people have particular communication needs, such as BSL users, for example? I understand his intention behind it. I'm trying to understand how that could practically take place, where there are some individuals who it's hard to envisage any circumstance where they wouldn't require another individual to be with them to advocate on their behalf or communicate for them or with them.
Paul Kane.
That is a very fair point that Mr Greer raises, and I think my intention in bringing the amendment was that it would follow, I suppose, the processes that are in place in terms of the issues how we already deal with those issues within a healthcare space in particular, and people can access interpretation, they can obviously access advocacy and support as is appropriate and they are comfortable with in terms of the discussions they are having. I think clearly what happens is those people are independent usually. Of course, the other point that goes back to the point about social work is that a multidisciplinary team will act in the interest of the individual in terms of ensuring that their rights are upheld and that they have that independent support if they require it when they go to see their GP or whoever it is in whatever context. Mr Greer's point, though, I think does come back perhaps to the issue I was making in my peroration there, which is if we can't square the circle and we can't actually work out how we would be able to do that and verify that someone hasn't been coerced and that they have made independent decisions, then it becomes very, very difficult to see how this bill can progress and how it can be supported without those valuable safeguards. Conscious that I've taken up quite a bit of time and I'm very grateful, Presiding Officer.
Thank you, Mr Kane. I now call Bob Doris to speak to Amendment 24 and other amendments in the group. Mr Doris.
Thank you, Presiding Officer. Whilst I have many amendments in this group, I want to focus on amendments 27, 160 and 33. I will not wish to see those three amendments lost in amongst the various other amendments, which I will come to later. Amendment 27 requires an assessing doctor to inquire about and take account of indirect pressures and whether such pressures are unduly limiting someone's ability to choose freely. This is surely fundamental to striking a balance within assisted dying legislation, notwithstanding the challenges in doing so that Mr Mara has outlined during his contribution. We know that all sorts of factors may affect a person's ability to decide freely to seek an assisted death. For example, feeling a burden, financial pressures, or a major failure of service, be those in housing, social care, palliative care, or indeed in other ways. These can all exert indirect pressures. Palliative care practitioners in Scotland regularly support people who are expressing a wish to die due to indirect pressures. These people often go on to enjoy valuable time when these indirect pressures are explored, understood and addressed. Indeed, such people often say later they are glad that they did not end their life. Currently, the bill does not suggest or require that the assessing doctor identify or consider such indirect pressures. The bill focuses exclusively on coercion as something done by another person. I think that's a weakness. I should also point out at this stage, Presiding Officer, I, like others, will not be supporting this at the end of the Stage 3 process, but I think I've got a responsibility to strengthen the bill and make it as robust as possible. And these amendments are cast very much in that light. I suspect many of us know from experience, be that personal experience with family and friends, or indeed through our constituency casework, the impact that financial distress can cause, the challenges that inadequate care packages place on a person or their family. I think Pam Duncan-Glancy gave reference to that earlier. The profound impact that a lack of access to appropriate symptom management or palliative care can have on a person's lived experience and the perception of their quality of life. I very much hope MSPs will agree that it is reasonable for the registered medical practitioner to inquire and to take account of such indirect pressures. If you do, please support Amendment 27. Yes.
Thank you, Presiding Officer. So I have a lot of sympathy for Amendment 27, what Bob Doris is laying out. My only slight concern, obviously, is the meaning of indirect pressure. In a society, we all come under pressure from each other all the time in all sorts of different ways. I wonder if he agrees with me that what he's proposing would work particularly well in combination with what Paul O'Kane proposes in 151, because it uses the phrase undue influence before talking about these kind of pressures, particularly that word undue, that we're talking about influence that is somehow insidious or negative in nature, not just the pressure we all feel from our interactions with the rest of society on a daily basis.
Bob Doris.
I thank Ross Greer for that intervention. I think that's very helpful in giving absolute clarity to what the policy intent is here, as hopefully will my other amendments I'm about to speak to, which reinforces some of that. So we'll now move on to Amendment 160, which simply gives some examples of relevant indirect pressures. These are a person's belief about themselves, society's expectations, the significant absence of health and social care services to meet a person's needs. And Amendment 33 requires a registered medical professional to have regard for any relevant professional guidance on decision-making, including the impact of indirect pressures and other factors affecting free choice. Together, these three amendments, 27, 160 and 33, indeed, yes.
Lawrence Littler.
That include pressure not to seek an assisted death. If the member was, say if a patient was asking for an assisted death, but their family members were pressuring them strongly not to do it, what to do then? Because I think all the assumptions is that somehow doctors and family members are pressing their loved ones to end their lives. Encouraging was the word that Mr Mason used. What if the pressure's in the other direction?
Well, Doris.
I thank Lorna Slater for that intervention. I should point out that indirect pressures, direct pressures, societal pressures, pressures from family members happen in all and any circumstances. But the proposal in front of us is to fundamentally change the law, and it's right to build in those protections. And I very much, Lorna Slater, will agree with that and support my amendments 27, 160 and 33, given the passionate comments Lorna Slater has made about such protections. Indeed.
Fiona Mackay.
Thank the member for taking the intervention. I wonder how the member would respond to the fact that international evidence in other jurisdictions show there is no evidence of coercion, absolutely none. And Lorna Slater's point is absolutely correct. Yeah. The evidence is often the other way around, that people are being talked out of assisted dying. A clinician in California has written to us and said, you know, I've never, in the many hundreds of cases I've been part of, seen anything resembling family or friends attempting to coerce a dying person into receiving an assisted death. And I just wonder how you would respond to the fact you seem so certain that there's coercion. There's no international evidence of it.
Always through the chair, Bob Doris.
I thank Rona Mackay for that intervention. What I'm certain about, Rona Mackay, is that when we have such a substantive change to legislation, we should build in safeguards in case there may be coercion. I can't imagine a world we live in where we should just assume that there won't be coercion or indirect pressures, therefore we won't ascertain whether they do or do not exist, which is why I think Amendment 27, 160 and 33, I'll say the numbers again, are really important for operability and safeguards within this legislation.
Briefly, Mr Carson.
I thank you for taking the intervention. I had no intention in talking this debate, but I think the idea that coercion doesn't exist is very naive, and I'll give you an example. I'll remember the day I die, sitting along with my mother and a consultant, and as she was waiting to get her treatment for cancer, and the consultant very flippantly said, "I presume it'll be DNR." In a way that suggested to my mother, as he was the expert, that he was recommending that she would sign up to do not resuscitate. That was the first she heard of it, and that was coercion, because he gave her the opinion that it was his suggestion that she should sign up for do not resuscitate. And that's the reason I can't support this bill, because it will happen, and it will happen regularly.
Bob Doris.
Finlay Carson for the intervention. I think the Finlay Carson position, the Rory Mackay's position, can both be encompassed by support in Amendment 27, 160 and 33, because they are the scaffolding to make sure that we put in safeguards as far as we can in a proportionate way in this legislation. And if coercion doesn't exist, as Rory Mackay suggests, then let's put in the safeguards anyway. And if it does exist, then let's make sure we absolutely get them in. I think both interventions highlight the need to support all three amendments. Finally, I have a swathe of amendments in this group which seek to amend references to coercion. The repeated mentions in the bill of coerced or pressurised by any other person. However, there is concern that coercion in other forums, such as we've discussed, and this links back to indirect pressures, may not be fully recognised using the current terminology. Therefore, amendments, I'll just list through them, I won't speak to each individual one, you'll be relieved to hear, Presiding Officer, 24, 25, 35, 36, 41, 76, 77, 80, 82 and 84. They all simply, each time coerced or pressurised by any other person is mentioned in the bill, deletes by any other person to reflect that not all pressures arise from other people. I believe these are worthwhile amendments, but I would again remind members the key substantive ones. I was just finishing off, Mr.
Very briefly, Mr. Harvey, and then please conclude, Mr. Doris.
I'm grateful. It was just a question on the group of amendments that removed by any other person. I understand why, if we were talking about the concept of pressure, people may feel pressure from a range of different sources or circumstances in their lives. But the legislation at the moment talks about being pressured or coerced. Surely the use of those words implies intentionality, and if not by a person, then by whom?
Bob Doris.
Mr. Harvey, I appreciate the intervention. I think we've actually discussed that in quite great detail under indirect pressures within speaking to my earlier amendments. I think that case has been made. I just think it adds something to the bill to move by any other person. Nothing is lost, and I think it's beneficial. But more importantly, Mr. Harvey, I think the core of my amendments here are 27, 160 and 33, which I think are important safeguards. As deficient as they may be, as Mr. Mara pointed out, it's important we put something in to offer some form of protection.
Thank you, Mr. Doris. I now call Brian Whittle to speak to Amendment 174 and other amendments of the group. Mr. Whittle.
Thank you very much, Deputy Presiding Officer. I know we're nearly 5 hours in, but it's my first opportunity to say to my friend and colleague Graeme MacArthur, I really appreciate the way in which he's taken this bill through Parliament and the way in which he's interacted with all of his colleagues and MSPs, and where that we all took legislation through this Parliament in that light. I think the place would be a better place indeed. And I'd also like to thank my colleagues in the Health and Sport Committee for the way in which we have managed to work together. And I think what we're talking about today, coercion, is something that we have the advanced knowledge has, given that we have rehearsed this particular issue in committee, both in developing a report and at stage 2. I was listening to Michael Mara and to Paul Kane there around the issues of GPs and their potential to spot coercion. I think GPs already are trained to spot coercion, as are social workers. And it just occurs to me that one of the things out the back of this particular bill is that whatever happens, whether it passes or not, it does shine a light in many other aspects of healthcare. And I think one of the things that worries me around the coercion, it might be that GPs are already trained to spot coercion, but it used to be that the GP-patient relationship was enduring, and they knew each other well. I think that's becoming increasingly, increasingly rare. I think the same can be said for social work. One of the things that, in fact, it was, Lorna Slater raised the point around coercion in terms of which way it's not all about coercion to take part. There is also coercion not to take part. And I think that that's where my amendments sit. My concern was that an individual who potentially has a moral or a personal reason to oppose a decision of a person who has made an assisted dying declaration could use that system, of the court system or the police system, to delay a process through a protracted investigation resulting from the allegation of coercion. What the amendments do, 174, 187, 189, 198 and 209, creates a mechanism for review, and independent of medical professionals, for use in case where people who are close to the patient, be that family, named friends or carers, suspect coercion. The reason I picked this 10-day, it's modelled on an independent assessment, a similar model for organ donation. 182 reports, which are referred to in the medical profession or police where appropriate. 305 gives ministers the flexible powers to bring forward in the model. And it will only be triggered, these would only be triggered when those close to the patient express that concern. I think the 10-day reporting time is an effort. It's not to prolong the suffering of a person wishing to access assisted dying. I have to say I did ask both the member responsible for the bill and the Scottish Government to make suggestions on how to address my concerns in this area at stage 2, and I'm yet to have those concerns alleviated. I would point out that in later amendments I will be discussing advanced directives. I think that is a direct link into how we potentially could tackle the issue of coercion at that point when we get into that. But I would ask that you consider the amendments I put forward, 174, 187, 189, 198, 209, 182 and 305. And what I'm trying to do is tighten up the rules around coercion. Deputy Presiding Officer.
Thank you, Mr Whittle. I now call Jeremy Balfour to speak to Amendment 177 and other amendments of the group. Mr Balfour.
Thank you, Deputy Presiding Officer. I want to speak to Amendments 177 and 180 in my name. At their core, these amendments seek to reinforce a principle that I believe most members across this chamber would agree is fundamental, that any request for assisted dying under the provisions of this bill must arise solely as a consequence of a person's terminal illness and not for any other reason. The bill has consistently been presented to Parliament and to the public as legislation that is limited in its scope. We've heard even amendments today to limit that more. It's been described as applying only to competent adults who are terminally ill and whose suffering arises from that condition. If that is indeed the intention of the bill, then I believe it is entirely reasonable for the legislation to say so, and say so explicitly. If it says it on the tin, then that's what's in the tin. And this is what these amendments seek to do. They ensure that a request for assisted dying must be made solely as a result of the individual's terminal illness itself, rather than a consequence of the pressures or circumstances that may arise at the end of their life. We know that for the final stages of life can be extraordinarily hard for many people. Individuals who are terminally ill may experience not only physical suffering, but a range of emotional, social and practical pressures. They may fear becoming a burden to those they love. They may worry about the emotional strain placed on family members. They may feel isolated or dependent in ways that they have never experienced before. They might even feel that their continued care places demands on an already stretched services or resources. Interestingly, about 2.5 years ago, my father had terminal cancer, and he never required any practical help throughout his life. And one of his biggest fears, one of his biggest things he kept talking about is, am I being a burden to the carers? Am I being a burden to my late mother? Now, these feelings are profoundly human. They deserve compassion, care and support. But they should never become reasons why someone feels that their life ought to end sooner. If this Parliament chooses to legislate in an area as grave as a sister dying, then we have a duty to ensure that the safeguards are not only well-intentioned, but are robust and beyond doubt. I'm picking up the point, if there is no problem with this, if no one's going to be forced into this or pressured into this, then these amendments can lie there quite dormant. But they are there as a protection. And my concern is that without the clarification that my amendments provide, the legislation risks leaving people unclear, motivation unclear, behind the request for assisted dying. In a matter of such profound consequence, we cannot be unclear. We need to say it directly. These amendments therefore seek to ensure the eligibility under the bill is tied directly and especially to the experience of terminal illness itself. They reinforce the boundary that supporters of the bill have said exists. It simply says what the member bringing forward this bill has said over and over again, as have others. Presiding Officer, the decision we have been asked to consider through this bill is one of the most serious that any Parliament can take. It is the most serious decision I have made in my 10 years here in this chamber. It concerns matters of life, death and protection. Members across the chamber will have come to their own conclusions on the broader question of assisted dying. And I respect, even if I disagree with colleagues that have come to a different view than me. However, regardless of where we stand on the principle of the bill, I believe we should have a shared, common, committed understanding that any legislation we pass is tightly drawn as possible. Amendments 177 and 180, I'll do that, and the wording I think is important, and thus I encourage members to support these amendments in my name. Thank you.
Thank you, Mr Balfour. As we are nearing the agreed time limit under Rule 9.8.4a, open brackets, small c, close brackets, I consider it necessary to allow the debate on this group to continue beyond the limit in order to avoid the debate being unreasonably curtailed. I now call Ruth Maguire to speak to Amendment 93 and other amendments of the group. Ms Maguire.
Thank you, Presiding Officer. Consent, choice, free will and autonomy, these are principles which should exist in all our lives, but they're not experienced equally by all, and they're not something that the estimated 1 in 3 Scottish women living with domestic abuse and coercive control are likely to recognise in their lives at all. The amendments in this group see that reality and take seriously the real danger of coercion. My Amendment 93 is an attempt to strengthen safeguarding at the point of the second declaration. It recognises that coercion may be direct, indirect or internal and requires each to be actively considered. I just want to acknowledge what Michael Mara said and be honest with Chamber. I'm not entirely convinced we can legislate to protect people against coercion, but like everyone in this group, these are my attempts. The first point I wish to make is about safeguarding. Hearing something described as containing safeguards, containing robust safeguards, can go a long way to providing reassurance. But when the stakes are as high as they are in this bill, it warrants further interrogation. Any so-called safeguards, are statements about what should happen in an ideal world to protect people from harm. But I think we'd all acknowledge the real world stresses and pressures of clinical practice that face our medics. Members will understand the impact of a terminal illness diagnosis, and the family dynamics all around that are not always ideal. This Parliament brought forward groundbreaking domestic abuse legislation and is well versed in the complexities around coercion and patterns of behaviour that make it so. And given that, everyone in this chamber should understand 3 things very clearly. Just how far from operating in an ideal world a woman being coercively controlled by her partner is. The challenge in gathering evidence of coercion even for experts, and therefore just how limited any safeguards put in place can be for these women. Now, we know women being abused by their partners are at serious risk of being killed and of dying by suicide as a result of domestic abuse. Michael Mara mentioned Kimberly Milne from Dundee. We also know that domestic abuse does not end with a diagnosis of illness or with disability or with older age. Those intending to vote for this bill should be very, very clear about what level of risk they're willing to accept to meet the aim of legislating to allow some to end their life early. I'm not confident that we can prevent coercion even if all the amendments in this section pass. And that's not about putting it in the too difficult pile. There's nothing that we should ever put in the too difficult pile. But sometimes there are things that should be in the too dangerous pile. I strongly agree with experts Dr Annie Donaldson and Isabel Kerr. The truth is that for some women, the danger that this legislation becomes another lethal tool to be wielded by an abusive partner is real. The deadly consequences for those women would be final, and that's not a risk that I'd be willing to take, Presiding Officer.
Thank you, Ms Maguire. I now call Liam MacArthur to speak to Amendment 50 and other amendments of the group. Mr MacArthur.
Thank you, Presiding Officer. Michael Mara's Amendment 144 seems in the first part to broadly replicate what is already set out in Schedule 1 of the bill as introduced by Section 4 regarding first declarations. In terms of the second part, relating to a person indicating that making the declaration is not influenced by unmet palliative care, social care, housing, financial or caregiving needs, I'm not convinced that adds anything meaningful to the process already required. As a person's decision to seek assistance is voluntary and free from coercion must be ascertained by the assessing doctors through detailed conversations in the assessment stages. The assessing doctors cannot grant eligibility to continue the application under the bill unless they are satisfied of these factors. Making a statement to this effect in the first declaration is not necessary and adds no benefit of safety. Understanding of these issues requires detailed conversation and exploration with a trained professional, for which the bill and regulations will provide through the assessing doctors and, where appropriate, other medical and relevant professionals. Requiring a statement detailing what might be influencing a person's decision is also not useful and risks policing later open and honest conversations between doctor and patient. As I've said in previous groups, people's motivations and choices at the end of life are complex and multifaceted. A list of concerns that a person is apparently not allowed to have may dissuade them honestly sharing and addressing their concerns. If they feel there's a risk, it may make them ineligible for an assisted death. And I'll take an intervention.
Very grateful, Liam MacArthur, for giving way. Would he accept, though, that the doctor-patient relationship over the last sort of few decades has changed significantly, and what you're talking about there is that doctor-patient relationship that has evolved over time? The doctor knows the patient. It's much rarer these days, so it will be much harder for that doctor to assess coercion.
Liam MacArthur.
I understand the concern that Brian Whittle is raising. I think because of the processes that are put in place here, there are safeguards that would require, where there is felt to be an inadequate understanding of the broader context that the individual patient has, to be explored further. And in a sense, this process puts in place safeguards that I think are not there at present, where the vulnerabilities of individuals are not picked up. Regarding Mr Mara's Amendment 181, Stage 1 evidence brought out clearly that doctors are well trained and capable of making capacity and coercion assessments. The process already requires 2 doctors to make these assessments independently of each other and with reference to the relevant medical experts and other professionals, if and where appropriate. Only if both doctors are satisfied that all criteria are met can a person move to a second declaration. Introducing another layer in the form of a panel of experts at that stage would simply add another hurdle for the sake of it, rather than because it provides a safeguard to addressing a risk. Paula Kane's Amendments 151, 152, 158, 172, 175, 178, 315 and 320. Briefly, Michael Mara.
Michael Mara.
I appreciate the member giving way. Does he not recognise, or what would he say to Dr Annie Donaldson, given her evidence given to MSPs in the last week, that actually you require an ongoing relationship with an individual to best understand whether they have been the victim of coercion or abuse, and that a 20-minute conversation, perhaps even conducted, I think, as the bill is drafted, online via a Zoom call, is not a sufficient means of understanding that individual and determining whether they are facing the circumstances described.
Liam MacArthur.
What I would say is that the protections that are in place at the moment are largely non-existent in terms of individuals accessing particular treatments. And I think from the example that Michael Mara himself quoted, we're seeing the consequences of that. What this puts in place is a process that's robustly safeguarded, which access to other individuals beyond the coordinating medical professional or independent medical professional, drawing on the expertise of social work, social care and other relevant medical experts to fully assess both the terminal illness, the capacity and whether or not there is any signs of pressure or coercion. Turning to Paula Kane's amendments, they seek to replace the assessment made by the assessing doctors and relevant statements in relation to coercion and pressure with a wider provision seeking to assess that the terminally ill adult has not made the declaration as a result of undue influence, whether explicit or implicit, including pressure arising from dependency, family or caring responsibilities, financial circumstances, care arrangements or a perceived burden on others. Again, I don't believe such amendments are necessary as was clearly evidenced during stage 1. Medical professionals have an understanding, awareness and experience of detecting coercion. Guidance and training already exists in this area and will be updated as appropriate should this bill be passed. The bill as drafted provides clarity that the safeguard is intended to protect individuals from pressure and coercion. These amendments risk creating uncertainty by replacing the word coercion with explicit or implicit undue influence, which is hard to define and to apply consistently. As was debated at length at stage 2, there are also risks from seeking to put on the face of the bill ever more detail about what constitutes coercion, rather than ensure that such assessments are always made in line with the relevant, up-to-date guidance. Confusion and inconsistency will only increase risk and reduce safeguards, something I know from my conversations with Mr Kane he would wish to avoid. With regard to amendments 24, 25, 27, 33, 35, 36, 41, 76, 77, 80, 82, 84 and 160, all lodged by Bob Doris, it's important that the bill provides appropriate and proportionate safeguards, whilst also allowing those who wish to have assistance to be able to access it in a reasonable time frame and appropriate framework. It's fundamental that a terminally ill adult makes the choice about requesting assistance themselves without coercion or pressure by another person. The bill is expressly premised on the act being voluntary for the person seeking assisted dying. Both doctors and the professional providing the substance at later stages in the process must, amongst other things, be satisfied that the person is making the decision of their own free, settled will without being coerced or being pressured, not forced or be subject to psychological and/or moral pressure. The bill further contains a specific offence of coercion, which is punishable to a person. This is intentional and aligns with the bill's construction that coercion is an act done by one person to another, consistent with established principles of the Scots law. Of course, this would not... I'll take an intervention from Audrey Nicholl.
Audrey Nicholl.
Thank the member for giving way. Just flagging the recent commentary by the Royal College of General Practitioners that have said that assessing coercion is really beyond the capacity of its members, and saying they don't believe that this work can or should be incorporated into an already very busy and stressful professional role. So does Mr MacArthur recognise that whether or not we require training on the issue of coercion and identifying it, it's really just not seen as feasible by some in the medical profession?
Liam MacArthur.
I would certainly acknowledge those concerns, and they've been expressed to me directly by the Royal College and others. The way in which this is rolled out, I think, is going to look, and I've said this before, look different in different parts of the country, and how it's resourced, again, it will need to be a matter taken forward by the Scottish Government on the back of the Parliament introducing or passing this bill. How it's accommodated, ensuring that there is sufficient time to allow the assessments to be carried out, ensuring that where appropriate input from experts, whether they be medical experts, social work or others, is allowed for. I think all of those are integral to making sure that these safeguards work as intended. For these reasons, and as I said at stage 2, I'm very wary about widening coercion and pressure from some form of illegitimate influence being brought to bear by another person to being done by the person themselves, by societal expectations, the health and social care system, as opposed to individuals within that system or the state. I'll take an intervention from Bob Doris.
Bob Doris.
I thank Liam MacArthur for giving way. I thank him in part for commenting on amendments in my name, but Mr MacArthur, you kind of lump together my amendments 27, 116 and 33 with all the other amendments, specifically in relation to coerced by any other person. I did draw a distinction between them. 27 in particular, but 116 and 33 enables, just supports that conversation between the coordinating medical practitioner to discuss what indirect pressures may or may not be impacting on the individual. Surely that's a positive thing, given the exchange we've had in Parliament this evening.
Liam MacArthur.
I thank Bob Doris for that intervention. I lumped them together. We'll break them apart later on in my remarks, but I certainly acknowledge the point he's making. I'm concerned that defining coercion and pressure in such a way does risk introducing new definitions of legal terms, creating confusion and making the detection of coercion or pressure and the prosecution of the offences under the bill more difficult. From stage 2 in the conversations that Bob Doris and I have had over many months, I do certainly understand the intent driving behind these amendments and accept that there are various factors that may express a person's vulnerable status and situation, which would potentially, I think, make them prone to influence and could affect their decision-making. However, I believe that retaining the need for coercion or pressure to be an act done by another person, supported by the offences in the bill, and the ability for other health, social care and social work professionals to input into the assessment process is the best way to proceed. I'm therefore not persuaded to support these amendments, but I'm prepared to accept those relating to the removal of references to by any other person, which are amendments 24, 25, 35, 36, 41, 76, 77, 80, 82 and 84, and likewise Amendment 33. In terms of Amendments 27 and 160, these do seem to me to go further than is necessary, helpful and desirable in terms of seeking to define indirect pressure. But again, it will be for Parliament to decide whether or not it wishes to support them. And as I say, Bob Doris has set out the arguments for them, I think, very clearly. Turning to Brian Whittle's amendments 174, 305, 182, 187, 189 and 209, as I said at stage 2, given that the assessing doctors will already be assessing for risk of coercion, I question whether a further assessment by an independent assessor is necessary. I'd be concerned that this may create undue delays and prolong the suffering of the person seeking an assisted death, particularly given that a period of 10 working days may pass following the assessment before the report is produced. I note also the Scottish Government's view at stage 2 that introducing independent assessors may present significant deliverability challenges, and I'll take an intervention.
Brian Whittle.
Once again, to Liam MacArthur. The concern here, these amendments were brought out of a thought. The issue we have here is that if we don't pass my amendments, you will be able to scupper. You'll be able to scupper somebody accessing assisted dying just by suggesting there may be coercion, where it would be upon the police then to have to make an investigation, which would stop the whole process of assisted dying. If we don't have a process to handle that within a period of time, it puts the whole issue into a deal of peril here. So we have to accept that, and has been said by medical professionals before, for those who maybe potentially have decided not to take any more medical help or medical treatment towards the end of life, where people have wanted to go against that, relatives want to go against that. If we don't put these amendments through, we risk that very same thing happening to those who are trying to access assisted dying.
Liam MacArthur.
I accept the argument that Brian Whittle is making. It's a discussion we've had both at stage 2 and in the months intervening. I don't accept that the process at the moment doesn't provide a way of dealing with the concerns that he's raised. As I say, I don't ignore them at all, but I don't believe that introducing an assessor would be a proportionate way in addressing those concerns, and as such I'm not inclined to support them. Very, very briefly.
I am very conscious that obviously members at large have concerns about coercion, which is why there's so many very different amendments in this area. And I know that the member has shifted on the question of, for example, the 6-month prognosis because of the pressure from colleagues. And I wonder whether there's any ground he's willing to concede here just on the whole question of coercion.
Liam MacArthur.
Well, I think in terms of the bill itself, I've accepted a number of amendments that will tighten up the safeguards that are related to coercion as well as other interests in relation to capacity. So I think the bill is heavily safeguarded in that respect. I think there is more that can and will be done, not just through secondary legislation, but through the guidance. I think the point that was being made, I think, by Ruth Maguire and by Michael Mann is actually the understanding of coercive controlling behaviour is more recent and it is developing, and therefore that will need to be reflected in training, not just in this instance, but more widely within the health as well as the judicial sector. With regards to Jeremy Balfour's amendments 177 and 180, the bill already requires the assessing doctors to state that they are satisfied that the person seeking an assisted death is a terminally ill adult that has made their declaration voluntarily without pressure or coercion. The bill also provides for steps to be taken should the assessing doctor consider that the person is not terminally ill or if they have doubts as to the person's capacity. Amendments 177 and 180, I believe, therefore, are unnecessary. The reasons and motivations set out in these amendments are also subjective, numerous and varied. The bill already contains strong safeguards to ensure that a person is eligible, has capacity and is acting on a voluntary basis. A thorough, detailed and honest conversation undertaken by 2 separate clinicians exploring the person's concerns and motivations will go hand in hand with a discussion of other care options, will help to establish eligibility for an assisted death in a far more person-centred way than this amendment would allow. Likewise, on Ruth Maguire's Amendment 93, I question the purpose of a further assessment. The coordinating registered medical professional and authorised health professional must be satisfied at the time that the substance is provided that the adult is requesting provision of that assistance voluntarily and has not been coerced or pressured by any other person into doing so. This amendment introduces an overly prescriptive assessment that duplicates safeguards already contained in this bill. Yes, certainly.
Ruth Maguire.
Arthur giving way. Rona Mackay mentioned that there had been no coercion detected anywhere else in the world. Why does Liam MacArthur think that is? Does he think that women are safe everywhere, or is there perhaps something lacking in doctors' training in terms of spotting it? How would he address that?
Liam MacArthur.
I think I would reflect that what Rona Mackay was saying is certainly the case, and the evidence that we see that there is, in all the reporting in all the jurisdictions I'm aware of, that issue of coercion has not been raised. Now, our understanding of coercive controlling behaviour may mean that the way in which medical professionals are engaging in the process, the interactions that they have with the patients will develop over time. And that is far more of a safeguard than is in place at the moment, where those conversations simply aren't happening. So it's not that I don't accept that there is a risk. The prevalence of this is potentially more extensive than we understand even at the moment. But what I'm saying is that the process we have in place through this bill is putting in place protections that simply don't exist at the moment. As I say, the bill also contains subjective concepts such as an indirect coercion and dependency, which risks creating uncertainty for healthcare professionals, as well as being difficult to apply consistently. I'll take one more brief intervention from Paul O'Kane.
Paul O'Kane.
I am very grateful to the member for taking the intervention, but I mean the point on coercion. If he's not willing to accept, the point that the GPs, struggle to spot it potentially, I mean, does he accept the points that I raised around social workers being highly trained professionals who identify coercion, patterns of coercion, systematic abuse? And does he understand how serious it is when the Scottish Association of Social Workers and Social Work Scotland say, and I quote, "Scotland's most vulnerable people cannot be an afterthought in a bill designed to serve them"?
Liam MacArthur.
I certainly do accept the point, as I think I indicated in the intervention, which is why the bill at stage 2 was amended to ensure that social work and social care was far better and clearly reflected in the referral pathways that were set out in the bill. I think an indication of the journey I have been on with this bill is that that is reflected in the bill in a way that wasn't at the outset. I think it's very clearly the case, not just with coercion, but also in relation to capacity. I think social work professionals also make a fairly legitimate case that in terms of understanding the range of options that are available to an individual to ensure that the choice that they're making is an informed one, are likely to come from the expertise that social work professionals have. But I still don't believe that having a mandated referral in each and every instance to social work is a proportionate way of addressing the risk that I absolutely accept does exist. Safeguards should remain robust, but should allow clinicians to exercise clinical judgment rather than prescribing highly detailed assessment processes in legislation. Finally, my own amendments in this group 50 and 51 are intended to ensure consistency with the general approach to summary penalties and to reflect standard drafting practice. Section 21(2)(a) sets out the penalties applicable on summary conviction for offences under that section. Amendment 50 substitutes a reference to 2 years with 12 months, and Amendment 51 substitutes a reference to level 5 on the standard scale with the statutory maximum, updating the description of the maximum fine that may be imposed on summary conviction. To be clear, and to Mr Mara's earlier point, these amendments are intended to ensure consistency with the Scottish Sentencing Council's guidelines and approach to maximum and minimum sentencing for summary offences. I would also note that the provisions on indictment remain the same, carrying a sentence of up to 14 years in prison and an unlimited fine. Thank you.
Thank you. I call Pam Duncan-Glancy.
Thank you, Presiding Officer. The National Council on Disability reported that social and family pressure has influenced some disabled people to consider assisted death, often rooted in perceptions of being a burden. And the bill states that the person must declare they have not been coerced. Changes at stage 2 required inquiries of professionals on this issue, as we've just heard from my colleague Liam MacArthur. But I worry that these, and many brought forward today, are not and will not be enough. And I'd like to put on the record my association with the comments that have been made so far, in particular by Ruth Maguire. As we've heard from colleagues, social workers and others who make determinations on people's lives regularly have raised concerns around the societal and institutional pressures, including pervasive narratives around being a burden, the cost of care, or the emotional and financial toll on families, and how these can shape a person's decision in ways that are profound and deeply difficult to detect. I'm happy to take the intervention.
Paul O'Kane.
I'm grateful to Pam Duncan-Glancy for giving way. And she referenced the Stage 2 amendments and the role of social workers, which obviously I've been commenting on along with colleagues. Does she recognise that, again, Social Work Scotland and the Scottish Association of Social Workers have said that the provisions that were implemented at Stage 2 are not sufficient and will not go to where they need to be in terms of this issue of coercion?
Pam Duncan-Glancy.
I thank the member for that intervention. I was about to say that the social workers have contacted us ahead of today's debate to say that they are worried deeply about the bill as it stands, including specifically the amendments that came through at Stage 2. Presiding Officer, I and colleagues around the chamber, including my colleague Paul O'Kane, I'm sure, believe we must listen to them. These are people who are often asked to protect people. Asking them to do that against legally ending someone's life is a big ask, and we should listen to them when they raise concerns. Despite being a group of people who have contact with the state more often than many, disabled people, especially disabled women, are still more likely to experience domestic violence and abuse than others. In fact, they're twice as likely to experience abuse than non-disabled women. They're also more likely to experience abuse from an adult family member compared to non-disabled people. And 1 in 10 domestic violence abuse cases are perpetrated by someone with a caring responsibility. Despite being some of the most regulated people in society, and I say this not flippantly but as an example, it's difficult for a disabled person to even get on a train without having to give their full name and their phone number to check whether they've booked assistance. This is a group of people who have a lot of contact with a lot of professionals in their lives, yet still abuse and coercion goes undetected. And this speaks to the heart of what members across the chamber, and in particular my colleague Paul O'Kane, has spoken of earlier on in relation to social workers' concerns on the bill. But there's also another angle of risk too, because it is also the case that when structural inequalities and dependency are present, as they often are in the case of people at the end of their life, or indeed for some throughout their life, no safeguards can fight the tide of internalised coercion or ableism. That kind of coercion is subtle, but it is deeply internalised and extremely difficult to detect. There are many amendments around coercion, financial abuse, encouragement to choose assisted suicide, etc., that seek to try and remove the possibility of improper motives influencing the process. But the reality is that disabled people's experience is so deeply oppressed that removing them by amending one bill is unrealistic. It would take sweeping change across all areas of public policy and all areas of life to protect disabled people from the internalised everyday ableism that they experience. The subtlety of pressure disabled people face, the subtlety of pressure that people who live with dependency, who live differently from others, stems from cultural attitudes, and we know that when it comes to people experiencing ill health or disabled people or people who have lost function in some way, these attitudes are not yet what we would all hope them to be. I see it every day. It's hard to believe that your way of life is acceptable when so many people tell you that it is not, that changes to make something accessible to you are too expensive, or that there isn't enough care funds to go around, so you should have lower expectations of the life that you want to live, or that surely a woman in your condition won't want a family. These are the very real beliefs that many disabled people face every single day. We saw this at its extreme in the pandemic, when many groups of people's lives were considered of less value and DNR orders placed on them without their consent. So scared of the value that society placed on our lives, my husband and I wrote to each other during the pandemic to say that we wanted to be resuscitated. Presiding Officer, these fears are real. Even in a highly regulated environment, as I've said, disabled people's experience of coercion and abuse goes undetected. We can't detect it now, and will be unlikely to detect it after this bill. Perhaps because of this, if you are told every day that your life is of less value, you do learn to believe it. When everything in this world says that you don't belong, you learn to believe it. You internalise it. And many people internalise the negative attitudes that people have towards them. For many reasons, people mask these feelings of inadequacy and shame that they have come to believe. It can be impossible to detect, and people often don't tell you about it. Some people don't even detect it in themselves until they see other people are living well, like they live. Presiding Officer, there are many people in Scotland who have no choice or autonomy in their own life. For some disabled people, they don't get to choose who enters their home to care for them, who helps them take their clothes on and off, or what they have for their dinner. In the absence of choice in all other aspects of life that could make assisted dying attractive. Indeed, it could be the only choice some people have. Presiding Officer, the everyday ableism, the constant barriers to life that accumulate and can make life intolerable, can encourage, indeed coerce, people to ending their life. We've seen it in other jurisdictions. We have to protect against that. But simply asking someone to say that they're exercising choice and autonomy isn't protecting against it, nor is asking a professional to make that judgment. Not only is this difficult, as we've heard across the chamber today, but many don't have the skills or indeed the time to do it. It's also a lot to ask of health professionals to have the necessary understanding of the deep-seated inequality that every single person faces and the everyday ableism that they have, to the extent necessary to be assured the person is acting with autonomy in a bill and in a decision like this. Presiding Officer, taken together, the amendments in this group reflect a genuine effort to strengthen safeguards against coercion, and I recognise that. But they cannot resolve the deeper challenge that when societal pressures, unmet care needs and personal vulnerability intersect, it becomes extremely difficult to be certain that a decision has been made entirely free from influence. And for that reason, I remain deeply concerned that no set of procedural safeguards can fully eliminate the risk of coercion in legislation of this kind. Thank you, Presiding Officer.
Thank you. I call Edward Mountain.
Thank you very much, Presiding Officer. And this is the first time and one of the few times I am going to speak in this debate. But I'd like to start off by saying how much I think this debate has shown the Parliament in a good light, in that we've all been able to talk across the issues between us all. And I thank the member for bringing the bill for making that possible. Presiding Officer, my concern about coercion is one of the fundamental reasons why I struggle with this bill. My question is, how do you identify coercion? It's fundamental. And then how do you prevent it? I think Brian Whittle was entirely right, Presiding Officer, in what he said earlier. How do you identify coercion where you don't have the relationship between doctors and patients, that relationship that we used to have, where the doctor knew so much about what was going on in their family or their other patients' families? And how do you prevent coercion? Well, I don't know. Because as we heard from Michael Morrow and Ruth Maguire very powerfully, coercion can be very subtle and often undetectable. And it goes on often by suggestion and repetition without anyone really knowing what's going on, apart from the person who's inflicting it on somebody else. And then, of course, there's the coercion that you put on yourself. Be under no illusion, Presiding Officer, if you get an unfavourable diagnosis, one of the things that you will think about is whether it might be easier to end your life rather than putting through your family through everything that you might be going through. And it's not everyone who has a supportive family around them that can break through those shackles and not coerce themselves into doing something that they often will regret. And I've heard of people across the Highlands who are coerced by the fact that there is a lack of palliative care in the area where they live. In fact, I heard the other day of somebody who would have contemplated, if this bill passes, ending their life rather than going to Inverness, 2.5 hours away from their family, where they might get palliative care because they couldn't get it locally, and they couldn't bear to be separated from their family. And it's that lack of palliative care, in my mind, which is coupled with this, which makes coercion so difficult. We know in Scotland, Presiding Officer, that 14,000 people a year are probably not getting the palliative care they need. Why? Because there aren't enough palliative care provision in Scotland, and there's a lack of funding, a huge lack of funding. Now, I'd also say that a lot of people could then consider, if they can't get palliative care through the state, what about the cost of care and doing it themselves? Well, not everyone has the ability, Presiding Officer, to fund their own care. They often think that if they can fund their own care, why would they do that if they know where they're going? Would it not be better to give what little resources they have left to their children and their partners? Now, I'm not sure any of the amendments that have been brought forward by Paula Kane, Michael Mara, Bob Doris, Brian Whittle, Jeremy Balfour, Ruth Maguire will actually make me less concerned about coercion. I fear they won't. But I do wish them success, because I absolutely believe that anything we can do to make sure coercion is not something that will be a feature of this bill, we should try to do in this Parliament. And I particularly want to single out amendments 177 and 180, which I believe should be specially considered to make sure that they go through. And, Presiding Officer, I just say at the end, and I don't want to make a big thing of this, but one amendment, Amendment 50, gives me a huge amount of concern. What we're talking about is reducing the penalty for a summary conviction for coercion. How can that be right, Presiding Officer, if many of us fear that coercion is one of the main problems with this bill? Presiding Officer.
Thank you. I call Christine Graeme.
Thank you very much, Presiding Officer. Cards on table, I support this bill, but I want it to be as robust as possible. I fully accept there are people in the Chamber, members in the Chamber, no matter what we do to this bill, they will not support it, and I respect that. Whether it's for religious reasons or disabilities or whatever, yes, I accept that. But I want to address this issue of coercion and undue influence, which really is part of a trio to go with capacity. As I said, in capacity, these are well-established concepts and values in Scots law, and there are many examples of what these constitute, which will come before the courts. So when you're doing legislation You must make clear that the terms you're using have a background to them, have a foundation in case law, should it be required. So what I am going to say now will reference the bill, where I think it does, so far as I'm concerned, address undue influence and coercion. So I will not be supporting 144, but I'm very sympathetic to the amendments by Bob Doris, 25, 27 and 33. Now, I just say broadly because they deal with the practitioner making inquiry and even having guidance as to whether or not they feel that they're looking at someone who is suffering from undue influence or coercion. And that's very important, professional training. So I look at section 4, the first declaration that is made. And in section 4, subsection 2A, it says the first declaration must be in the form set out in Schedule 1. If you go to Schedule 1, it says at number 2, I beg your pardon, at 3, I make this declaration voluntarily and in particular, I have not been coerced or pressured by any other person into making it. Now, that wouldn't be enough on its own. And then when you look at the other sections, you look at section 6, the medical practitioner's assessment. The coordinating registered medical practitioner must, mandatory, as soon as reasonably practical, do several things. And one is at subsection 2C, I beg your pardon, if having carried out that assessment, the coordinating registered medical practitioner is satisfied as to the matters mentioned in another section, which I'll come to, that practitioner must refer the person to another registered medical practitioner, the independent registered medical practitioner, to carry out the assessment mentioned. Below that, in another subsection, section 6, subsection C, it says, made the declaration voluntarily and has not been coerced or pressured by any other person into making it. But it's not just there. It's in section 8. Medical practitioners' statements. Section 8(1)(c), made the declaration voluntarily and has not been coerced or pressured by any other person into making it. And then at 8(2)(c), made the declaration voluntarily and has not been coerced or pressured by any other person into making it. And then you go on to the schedules, and without labouring it too much, Schedule 1, I've referenced, Schedule 2, paragraph 2. To my best of my knowledge, they are making the request to be lawfully provided with assistance to end their own life voluntarily, and in particular have not been coerced or pressured by any other person into making it. And further in the bill, over leaf at paragraph 2, the independent registered medical practitioner's statement, to the best of my knowledge, they are making the request to be lawfully provided with assistance to end their own life voluntarily and in particular have not been coerced or pressured by any other person into making it. And I'll just finish with this final bit, which is made by the second declaration by the person. 3, I make this declaration voluntarily and in particular I have not been coerced or pressured by any other person into making it. There's a whole lot of hurdles. Yes, certainly.
Bob Doris.
I thank Christine Graeme for giving way and don't want to incur her wrath. I have to be nice with some of my amendments in this group, but all the matters that Christine Graeme has put on the record are not additional layers of protection. They're simply repetition of something that recurs throughout the bill, because you have to keep repeating what's in the bill from the start to finish. Basically, there's 2 assessments, there's 2 declarations, and they're signed off. That's it. Now, that might be sufficient for some people in this place, but not for myself. But I know I would not want to inadvertently mislead Parliament that there's layer upon layer upon layer of protections, because there's not. It's repetition that the member's reading out.
Christine Graeme.
They're not simply repetitions, they're undertakings by medical practitioners as well as the applicant that to the best of their knowledge, they have done this voluntarily. 2 medical practitioners, independent of each other, have made these statements. Now, I think your particular amendments are useful. I'll certainly consider voting for them, thinking of voting for them, because they require guidance and training for the practitioners. But really, I think in here sometimes we're doing a great disservice to medical practitioners who we think somehow are just going to willy-nilly go through with somebody coming in front of them. If they have a bit of concern, I'm sure most GPs have that kind of knowledge, then they will hesitate. And they will test it, and they may very well then make inquiry of what is in front of them. So that you're asking a lot. If a medical practitioner were to do it in some casual, superficial manner, sooner he or she would be up for the BMA, let alone anything else. So I think that's pretty rigorous for me. But I understand that this will not persuade people in here who have been against this from the beginning, and that's fine. But if you are wavering because you feel somehow this will make vulnerable people more vulnerable, I can assure you I would not vote for it if I thought that. I'm voting for it because I think, to the best of my testing of the legislation and the amendments so far, and there may be others, this is fairly robust. It's robust stuff, and it's laying the onus on the practitioner to get it right. Thank you.
Always through the chair, colleagues, I call Michael Matheson.
Thank you, Presiding Officer. I'm grateful to those members who have brought forward amendments in this particular section, which I think is one of the key risks associated with this piece of legislation. During the course of the Stage 1 debate, the assertion was made when we were debating the issue of coercion that, as we've heard here tonight, that there is no evidence in other international jurisdictions where they have introduced legislation of this nature that coercion takes place. Now, I, for one, I respect the views of members who hold that view, but I, for one, simply do not believe that to be the case. The issue of coercion is a wider societal issue and has been for a long, long time. And I also think, given that it is one of the most significant risks which are associated with this legislation, that it is wrong and actually, in fact, dangerous to give the impression that coercion does not take place in areas such as assisted suicide because there is no evidence from other international jurisdictions. Now, I know from the discussion that I had with Dr Anna Donaldson, who is an expert in this field, that anyone who would assert that coercion doesn't take place has to be subject to some level of scrutiny over the quality of that evidence base that's been made to make that, or evaluated in order to make that assertion. And I'm not convinced that that is the case. And I want to give some reasons as to why I don't think that is the case. When we were framing the 2018 Domestic Abuse Bill, and for the first time in legislation, providing provision for coercive and controlling behaviour, one of the real challenges was being able to actually define that type of offence. And in the end, the decision we made was to go for a course of behaviour that would occur over a period of time. Now, critical to be able to make that offence work effectively is to have the right skill set and professional group able to undertake the assessment in order to identify that course of behaviour over a period of time. And the evidence shows that key to identifying coercive controlling behaviour in domestic abuse is very often it's a relationship that is built up with specialised police officers and social workers over a period of time, working with the individual to identify the coercion that's taking place. And the reason I say that is because there is very strong evidence that very often individuals who are being coerced aren't even aware that they are being coerced and controlled at that time. Which is why I think the point that Paul Kane was making about the importance of skill sets is absolutely critical here. Which is why, when we introduced the 2018 Act, there was an extensive training programme across a whole range of agencies in order to develop the specialist skills that were necessary in order to help to underpin the legislation and the new offence that we had created.
And I say, with all due respect to Christine Graeme and with no disrespect to medical colleagues, is that it is very evident, I think, that general practitioners who I think hold a whole range of different skill sets, but I would say, in fairness to them, they are not experts in identifying coercive and controlling behaviour over the course of the short period of dealing with a declaration. That requires specialist skills and it needs to be undertaken over a period of time. And the third point I want to make here in relation to this is that coercive and controlling behaviour takes place for vulnerable members of our society in our communities on a day-in, day-out basis. And it materialises through adult protection cases that social work colleagues deal with on a day-in, day-out basis. Key to that, in some cases, is physical abuse. Sometimes it is coercive and controlling behaviour for financial purposes and a whole range of other factors. The reality is that type of behaviour will also impact on this legislation should it be enacted. There is no way that you can suggest that that type of coercive and controlling behaviour will not happen in some way for assisted dying in the way in which it happens just now under adult protection legislation on a day-in, day-out basis for some of the most vulnerable members of our society, which I'm happy to give way to. Yes.
Rona Mackay. Thank the member for taking the intervention. I totally appreciate that coercion exists in domestic abuse cases and in other cases, but when we're talking about assisted dying, I go back to the point you said you didn't believe the international evidence. That being the case, do you believe that there has been no prosecutions for coercion in other jurisdictions? Not one.
Well, always through the chair, Michael Matheson.
So I don't. Given that coercive and controlling behaviour impacts on a whole range of aspects of our society, including vulnerable individuals, I, for one, don't believe that it will not impact on vulnerable individuals when it comes to making decisions around assisted dying. Now, I can't speak for the academics that made reference to what's happened in other jurisdictions. There will be issues around. If I could just finish this point around the evidence that they've got from other jurisdictions. There will be issues around training, the way in which the knowledge of individuals, also the very fact that some of the individuals will be dead by the time that they actually might want to do case reviews, so the evidence may no longer be present at that particular point. There's issues around definition of coercion as well. So there's a whole variety of things, but I simply do not accept, and I actually think it's quite dangerous to try to create the impression that coercion is not a potential risk factor, significant risk factor, when it comes to assisted dying matters. I'm happy to give way to Lorna Slater.
Lorna Slater.
I'm very grateful to the member, and I absolutely hear the concerns of members across the chamber for safeguarding, particularly for very vulnerable individuals in our society. That is something we absolutely all share. But I wonder if the member has looked at evidence from around the world that shows that most people in other jurisdictions who choose assisted dying are affluent, well-educated, able-bodied people. And that practitioners are often in those jurisdictions reluctant to approve people who come from deprived backgrounds, who are disabled, or who come from vulnerable backgrounds, which makes me worry that we're setting up a system where only privileged people are able to escape suffering at end of life. And we're actually restricting the ability of people to make choices because we think we know better and can make choices for them.
Michael Matheson. I think there are issues around potential inequalities associated with this legislation, and there is the inequality which is created by individuals who are not able to access the palliative care that they would like to have because it may not be available to them. But if they have the financial means, they may be able to actually purchase that for themselves. That happens in our society at the present time. So there is issues of inequality in how aspects of care services are provided, and I think that some of that will play through with this legislation as well, in decisions that people will make because of the inequality of finance in some of the decisions that people will be able to make, and therefore resulting in them making decisions that they may want to end their life because they can't get the services or access to the services that they believe that they require. Can I turn also to the issue? I'll take Christine Graeme and then I'll take Brian Whittle. Christine Graeme.
Thank you. A substantial argument, as usual, from you, Mr Matheson, and I agree with everything you've said about coercion as undertaken, especially in abusive domestic cases. You know, long track record with you, and justice issues in the Parliament. I'm suggesting to you that if we go down the road of training, because it will be only in a certain number of cases, it won't be in every case, that doesn't make it good. But if we have training and guidance for the medical profession, would that assist you in persuading you that there could be sufficient there that medical practitioners would have the nous, the awareness of the subtleties of coercion to allow this to proceed?
Michael Matheson.
Brian Whittle's intervention. I'll try and deal with both of them at a time.
Brian Whittle.
Very grateful for Mr Matheson to take my intervention. I'm listening to the debate here, and given that that we on the Health and Sport Committee had the benefit of taking evidence from around the world, I am concerned that some members are selective in some of the evidence that they're gathering here, because certainly there was no suggestion from any evidence we took, as far as I can see, that there was no coercion whatsoever in this particular area. So I'm just a wee bit concerned that we're looking at it from our own perspective rather than looking at the whole of the evidence facts.
Michael Matheson.
I'm grateful for Mr Whittle's intervention in that, given he's been a member of the Health Committee in considering some of these issues. On the point that was being made by Christine Graeme, I think training is one aspect of it. The reality is that I don't actually believe that the declaration phase, in the way in which it's framed in the legislation, provides sufficient time and opportunity to actually be able to deal with these issues thoroughly. And I think it is unreasonable to expect two independent general practitioners with a period of training to then be able to substantiate sufficiently that there's no coercive and controlling behaviour influencing the individual that they are considering in this particular instance. Because, as I mentioned, under the 2018 Act, we framed the legislation specifically in such a way in order to demonstrate that you need to establish that type of pattern of behaviour, and that takes time and effort in order to do so. I'll give way to Russell Finlay.
Russell Finlay.
Talk about the evidence or lack thereof of coercion internationally, and that's what this debate's about. But let's look closer to home, because in my past life as a journalist, you didn't need to look too far to see examples of trusted legal professionals targeting and exploiting elderly, vulnerable clients. And these ugly cases were frequent. I just looked up a few just there. 1999, a solicitor taking £100,000 from elderly clients. One in 2021, stealing cash from another elderly client in Edinburgh. Another being struck off for overcharging elderly clients in Aberdeen. And yet another in 2023, targeting someone with dementia and making off with their money. So I think the point I'm trying to make, and I wonder if Michael Matheson agrees with me, is whether these very real examples of crimes in which elderly people have been targeted by trusted professionals at the most vulnerable time in later life, there's a real chance that if this legislation goes ahead, we'll see similar crimes such as these.
Michael Matheson.
I do think the member makes a valid point, because I don't think we can underestimate the scope of coercive and controlling behaviour in different parts of our society. And as I referenced, it happens on a day-in, day-out basis, with social work staff dealing with it through adult protection legislation on an ongoing basis. Presiding Officer, the final point I want to turn to is in relation to the changes in the penalties which has been taken forward in the amendment by Liam MacArthur. I note the point that he made, that he is changing the two-year custodial sentence to 1 year, and also increasing the fine to a higher rate in order to be consistent with the Scottish Sentencing Council. Can I just point out to the member is that the Scottish Sentencing Council issues guidelines. It is for the sheriff or the judge to determine in the individual case what they see as being appropriate when issuing the sentence. Those guidelines could change in a couple of years' time. The problem is that you have brought forward an amendment that actually puts those guidelines on the face of the bill. And if at some point the Scottish Senate Council choose to increase the provisions they already have in it, this bill will then have to be amended, which is why I don't think they should be amended. The guidelines can be applied without anything being put on the face of the bill, and that's how the Scottish Senate Council was established in which to do so, and I'm happy to give way to Mr MacArthur.
Liam MacArthur.
Listen, and I'd also commend him on the way he set out his argument, and where I may disagree with him, that is another matter, but I think he's set out the case in terms of coercion, I think, very well. In terms of the sentencing guidance, I should confirm that this was an amendment brought forward in consultation with the Scottish Government, identifying what they felt was an anomaly within the bill. I take the point he makes in terms of guidance being updated. I think, as with other aspects of this legislation, it will need to be kept in line with the rest of the statute book. But as I say, I think this is an amendment that was brought forward in consultation with the Scottish Government to ensure that anomalies within the bill were addressed.
Michael Matheson.
I'm grateful for that clarity. Government doesn't always get it right, of course, but I do think I can say that from the back benches these days. So But I would say that I don't think we should lower the threshold, because I think it sends out the wrong signal. The sentencing guidelines are there, which can be used by the bench when determining a case, and I think we should allow our sheriffs and judges in which to do so without the need to revert back to amending the legislation. In closing, Presiding Officer, so I'll give way briefly to Mr Fraser.
Murdo Fraser.
For giving way. Just on that sentencing point, I wonder would just reflect, firstly, that there is a presumption against sentences of a year or less, and secondly, that even if there were a sentence of a year, under the current automatic early release, someone sentenced to a year in prison would only serve 15 weeks in prison. Would you agree with me that is little deterrent for coercion?
Michael Matheson.
I do think, although I should declare the fact that I was the Justice Secretary that brought forward and introduced the presumption against sentence of less in a year. However, I do agree, I do think that we should leave the sentencing guidelines to stand as they are without necessarily putting them on the face of the bill for the reasons that I've already set out. In closing, Presiding Officer, can I say that I do believe that one of the significant risks associated with this bill is the issue of coercion. And can I respectfully say to those who have brought forward amendments, for which I am grateful, I don't believe that you can legislate to prevent coercion. You can legislate to help to identify it and then seek to convict people for it, as we did in a domestic abuse bill. But the reality is coercion will take place, and we need to make sure we've got robust law in place to deal with it as and when it is identified.
Thank you. I call the Cabinet Secretary.
Presiding Officer, I can make no comment on the merits or otherwise of the case being made by colleagues in setting out some of the amendments in this section as per previous. They are clearly rooted in deep conviction. I can only set out the technical legislative competence or deliverability concerns government has, and it is then for colleagues to decide how they choose to vote. Presiding Officer, amendments 24, 25, 35, 36, 41, 76, 77, 80, 82 and 84 potentially introduce greater subjectivity and inconsistency into assessments, as, from a technical perspective, removing the references to pressure, quote, by any other person in the bill risks widening the concept of coercion in a way that may reduce legal clarity, making it more difficult for practitioners to determine the threshold at which indirect pressures amount to a lack of voluntariness. Amendments 27 and 33 would place new and explicit duties on registered medical practitioners and on Scottish ministers to identify, consider and provide guidance on indirect pressures. Whilst professional guidance already supports clinicians to assess capacity and voluntariness, the points made by Graeme, Embedding these requirements in statute could increase the complexity and length of assessments, with potential implications for training, consistency of practice and practitioner confidence. It would also require careful development of guidance to avoid creating expectations that all forms of indirect pressure can be identified or mitigated in a uniform way. I happily give way to Mr Doris.
Bob Doris.
Secretary, for giving way, can I just say in relation to my amendments would require the careful development of guidance in relation to this? Absolutely. Of course it should. And that's why you should also pass the amendment. That's absolutely clear. In relation to Amendment 27 leading to lack of consistency in practice, Amendment 27, just to remind the Chamber, encourages a conversation between the medical practitioner and the person applying for an assisted death about the possibility of indirect pressures. So that's what Amendment 27 does. Of course, Cabinet Secretary, if we don't have that conversation, then you'll get absolute consistency, won't we? Because if you're not asking for it, then consistently we're not asking for it. Of course we have to ask for these things, and maybe I should reflect on that, Cabinet Secretary.
Cabinet Secretary.
Presiding Officer, I say again to Mr Doris, as I said to all colleagues at the start of this group, I can only set out the issues or concerns that government has with certain amendments. I don't in any way pass comment on the merits of the arguments that are being made by colleagues in setting out their amendments. I understand them, and I can, again in Mr Doris' sense, understand where they come from and a deep-rooted conviction. All I say is that what has to be weighed up by colleagues is the case that is being made by colleagues in setting these out, and some of the considerations the government wishes to put on the record around deliverability, technical and legislative competence issues. Amendments 50 and 51 would ensure consistency with the general approach to summary penalties. Mr MacArthur has already set out the fact that we have cooperated on these amendments. Amendment 93, I will give way to Mr Balfour.
Jeremy Balfour.
I wonder if the Cabinet Secretary could just give a wee bit more information around this. Mr MacArthur said that he had done this because of the government's understanding. We had a fairly clear statement a few moments ago saying that this shouldn't be linked to the bill. So can the government at least give us some idea why they feel the statutory time limit should be reduced and why it should be on the face of the bill?
Cabinet Secretary.
Mr Balfour for his intervention. As I say, this would ensure consistency with the general approach to summary penalties. It's to require legal consistency. Amendment 93 would significantly expand the requirements placed on the coordinating registered medical practitioner at the point when a second declaration is made, by directing in detail the nature of the assessment to be carried out, the specific forms of coercion to be considered, the steps to be taken where concerns are identified and the matters that must be recorded in the adult's medical records. While the bill already requires the practitioner to be satisfied that declarations are made voluntarily, this amendment goes further by setting out a structured and highly specified assessment framework in primary legislation. This may reduce flexibility for professional judgment and could have implications for deliverability, including increased time and resource demands associated with assessments, record keeping and training. In relation to Amendments 151, 152, 158, 175, 178, 315 and 320, the extent to which the amended provisions link to the offence of coercion or pressure in Section 21 of the bill is not clear. Amendment 172 would introduce significantly more prescriptive requirements in relation to assessment, training and procedure. This could have practical implications for delivery, including a substantial increase in the time required to carry out assessments and ultimately an increased financial burden. In relation to Amendment 174, it is not clear who an independent assessor might be, but it is noted that Amendment 182 inserts provision into Section 8, medical practitioners' statements. On that basis, if the Scottish Minister's duty is to make regulations setting out qualifications and experience is in relation to medical practitioners, then this may raise issues of legislative competence in a similar way to other provisions of that nature in this bill that we have already debated. More broadly, Amendment 174 and related amendments 182, 187, 189, 193, 209 and 305 also raise deliverability challenges. Introducing a new statutory role of an independent assessor may require the establishment of qualification standards, regulatory oversight and sufficient workforce capacity, which could be challenging to implement consistently across Scotland. The trigger for referral, based on concerns expressed by third parties, lacks a clear threshold and could add delay and uncertainty within the process. There are also questions about how an independent assessor's conclusions would interact with existing clinical judgments and safeguarding duties, and about the proportionality of mandatory referral to Police Scotland. Taken together, these amendments could add procedural complexity and delay. The effect of Amendments 177 and 180 is that the assistance under Section 15 could only be provided where the coordinating registered medical practitioner and the independent registered medical practitioner are both satisfied that the adult is seeking the assistance solely due to their terminal illness and for no other reason. Whilst I fully appreciate the intent behind these amendments, it is possible that including such provision in the bill could actually have the effect of people feeling that they cannot be open or honest about their reasons for seeking an assisted death, for fear that doing so could lead to their request being denied. This may prevent open conversations from taking place about the alternatives and the support that is available to the person to help them with any other issues that may be factoring into their decision. And it could also have implications on the ability of the assessing registered medical practitioner to determine if the person is acting voluntarily. On Amendment 181, setting up a panel or multiple panels would likely be to have major financial implications. For the remaining amendments in this group, Presiding Officer, the Scottish Government has no comment.
Thank you, Cabinet Secretary. And I call on Michael Mara to wind up and to press or withdraw Amendment 144.
Thank you, Presiding Officer. Can I begin with thanking members for their contribution to the debate and start my closing comments with Amendment 50. Frankly, I don't think we heard really any proper defence of the substance of the change of reducing penalty for 2 years to 15 weeks for coercing from someone to take their own life. We heard arguments about consistency with sentencing guidelines. Frankly, if these are the guidelines, Minister, they are an ass and they should not be applied in this area. There's been no substantive defence, and I would hope that members would reject the amendment on this basis. But I do feel it speaks a little bit to the tone of some of the approach that's been taken. Yes, certainly.
I'm very grateful.
Daniel Johnson.
I'm very grateful to Michael Mara for giving way. I wonder actually if it's worse than he suggested. I think in suggesting that somehow the Sentencing Council has primacy over this place regarding penalties is to get the precedent round the wrong way. Sure, it is for Parliament to legislate, Parliament to say what penalties should be, and the Sentencing Council is merely to guide thereafter.
Michael Mara.
Mr Johnson makes a very good point, and I think actually it covers where I was just coming to. That actually I think that reverting to this issue of sentencing guidelines actually diminishes the scale of the change that we're talking about. Actually, and that we have to get the penalties right when we're talking about an instance of life or death. It's absolutely right that we consider that on its own and on its merits. And I do not believe that reducing on the face of the bill that penalty from 2 years to 15 weeks is appropriate, and that Parliament should make a strong view of that. But I do think it speaks to my sense that there is perhaps in the way that parts of this bill has been dealt with and discussed, even in this group, is that it's not a profound change. It is a profound change, and the consequences are very significant. And in Paul O'Kane's point relating to social work, I think tells the story itself. The engagement he has had with social work organisations, I would declare an interest as well, is also married to a social worker. But the way that that was addressed by, I think, the member in charge of the bill, by Liam MacArthur, to say that when Paul O'Kane was talking about the lack of coherence with current social work framework, which are actually based on the idea of protecting life, and that Liam MacArthur said that this would be disproportionate. I think that gets it the wrong way round, perhaps as Daniel Johnson describes. Then, in actual fact, we have to think about what is proportionate to the scale of the change that we are proposing in this. And I think it's absolutely reasonable to take on board the frameworks that social workers exist and operate within at the moment, and we should take very seriously the objections that they have made. Ruth Maguire, please.
Ruth Maguire.
Thank Michael Mara for giving way. Going backwards a little to that sentencing, does he agree with me that our constituents, whether for or against the principles of the bill, would expect that penalty to reflect the seriousness of what's happening and that someone's life is being ended against their will?
Michael Mara.
I fully agree with this. I think that anybody seeing these proceedings right now would be astonished that not just the member in charge, but the government is feeling for the basis of a tidying up exercise and coherence when we're making such a profound change that they would seek to reduce that sentence on that basis. Yes, certainly.
Thank you. I actually agree with Michael Mara on this point, and I will be voting against Amendment 50, but on the point he makes about the people watching at home, does he agree with me? It is important that we're very clear here. We're only talking about summary conviction. Conviction on indictment in this case would carry a maximum sentence of up to 14 years, and it is important to reassure our constituents that that would remain the case.
Michael Mara.
So I do think that is important, and the member in charge, Liam MacArthur, put that on the record earlier in his contribution, so I think it's welcome that Mr Greer reiterates in that regard, but I don't think it diminishes the core point which we are discussing in this regard. So I do think, and I was coming on to this issue about making sure that we give regard to the social work status, and I think that Paul O'Kane made that case very well. But I think Ruth Maguire put the core of this debate about coercion right when she said this is about consent, choice, free will and autonomy. And the real question is who has it? Who has it in this question? We're talking about giving some of those rights to some people within the country. And we've discussed already the limits that we would set on that in terms of eligibility for it. But there's a question in this about who is able to exercise their choice, their free will and their autonomy, and whether they actually are able to give their consent freely. And that is the core of the argument I think that we've been having for the last hour or so regarding coercion. Paul O'Kane identified this as the significant hole in the bill. And I would say that actually that he's absolutely correct in that regard. Bob Doris talked about having to ensure that there was a scaffolding in place to make sure that we addressed these issues. I think a good way of putting it. And I do believe there's been a growing consensus, or a growing concern is perhaps a better way of putting it, among MSPs about this issue of coercion since stage one and in fact before. And I believe that in Parliament, if it doesn't put in place restrictions in this area, would be at odds with the public. You read in the Herald today that twice as many Scots agree that the MSPs should reject any law that would increase risk. 3 times as many Scots agree that safeguarding would not be able to detect domestic abuse in assisted dying. And 68% of Scots fear that victims of domestic abuse will be pressured into ending their own lives. I think those are a snapshot of what people outside of this building, people across Scotland, feel about the risks. And I think that when we balance those risks, as Ruth Maguire set out, these are the considerations that the public have. Please, Finlay Carson.
Finlay Carson.
I appreciate the member giving away. It's just to give me the opportunity to present a quote which sums it up for me, and it's from Michael Mara's previous colleague, Joanne Lamont, who tweeted, "I did not always think this way, but I have concluded that if my freedom of choice at the end of my life is at the expense of those who are vulnerable to coercion, that is not a cost that I can accept. Coercion is often invisible, but all the more devastating for being hidden."
Michael Mara.
Well, I think it's always good to hear from Joanne Lamont, in my experience, a wise woman, and I think a fine point that emphasises, I think, where the vast majority of the public are on this issue. They do perceive risks in what we are doing, and that we have to make sure that we can best guard against them. Rona Mackay made a couple of interventions saying that there was no evidence of coercion. I'll come to the member in a moment. That there was no evidence of coercion. I would say that in Victoria and Australia, the training on coercion amounts to around about 5 minutes, coercion identification. It's a 2-minute video and a 2-minute PowerPoint. So maybe there's a minute in between. That's the level of training to identify coercion. So when we say that there's no coercion identified in these circumstances, little wonder, and we have to look to the practices that are adopted when we draw on these different issues of evidence.
Liam MacArthur.
I'm grateful to Mara for giving way. I mean, what he's just said doesn't necessarily reflect the evidence that the Health Committee heard from representatives involved in the assisted dying process in Victoria. But would he at least accept that the protections that are there at the moment for those who find themselves subject to coercion, whether it's coercion into unpleasant, horrible, protracted deaths or coercion into medical treatment that may not be appropriate, the protections aren't there, and at least through this bill there's a system set out in very graphic detail by Christine Graeme earlier for putting in protections that don't exist, and with training requirements that go alongside that to reflect the clearer understanding of coercive controlling behaviour. I think those protections would only be enhanced.
Michael Mara.
I would say to the member, I think it's a false equivalence. The basis that some people receive care that they feel is inappropriate and that it doesn't suit their needs. That is a situation that we should address and we can address through the NHS. But if he says that we don't, well, I mean, I think that kind of comes to the heart of some of the problem with the bill, frankly. But if we're not addressing appropriate palliative care, he said in the Stage 1 debate that palliative care had to be a viable alternative to assisted dying, and now he's saying that it's not a viable alternative because people are receiving care that is inappropriate. I would leave that point there. It is perhaps a debating point. But I would say to Mr MacArthur, what we're introducing here is a law that actually creates the state's ability to be involved in the taking of somebody's life or to allow them to take their own life. And that is the substantive difference. That is what we're dealing with. We're to draw an equivalence with the provision of other forms of services at different times, I think, is a fallacy, and it doesn't actually tally. What we have to deal with is protections for these laws that are set out. So I would say that in comparison to the Victoria and Australia situation, Brian Whittle's proposals, in terms of that are in his amendments, I think should be a good contrast in terms of the kind of options that people are considering in the amendments here today. We should also consider, though, in terms of the proliferation of coercion, that the World Health Organization say that 16.6% of people over the age of 60 suffer elder abuse. And clearly people over the age of 60 are going to be more likely to avail themselves of this option than others do. I also thought that overall, Liam MacArthur rejected in his analysis of this bill that internal coercion existed at all. But maybe that's a question of how you see society, that class and poverty determine outcomes. For me, I think that's self-evident. That's how society works, whether we like it or not, and I certainly don't. But I would say that it concerns almost any other policy issue, whether it be health, addiction, mental health, educational outcomes, we recognise that the circumstances into which somebody is born makes those outcomes, sets you on a path of outcomes. And internal coercion is absolutely part of that. Pam Duncan-Glancy has ever set out powerfully how that is represented in the disabled community and how that feels on a day-to-day basis as a powerful advocate around those issues. So the idea that you reject systemic risk on the basis that there is not how you perceive societies, that somehow that people don't feel these pressures, I think just cannot recognise in the way that we concern almost any policy area in this Parliament, certainly.
Liam MacArthur.
I'm very grateful. I mean, I don't think anybody's rejecting the concept of internal coercion. That was reflected very much in the debates we had at Stage 2 on similar amendments in this area. I think what was, discussed at that point and agreed with in the committee was certainly that linking to the guidance around coercion, which certainly acknowledges internal coercion and other societal factors, is a more appropriate way of addressing this, rather than putting it on the face of the bill, which takes us away from legal concepts that are well understood, increases the risk of confusion and puts both medics and patients therefore at risk.
Michael Mara.
I think that actually wraps up my 2 points quite well. The first one being that actually I think that it's partly a question about how powerfully you see those fractures in society and the risks that are inherent within it. And also that we have to recognise that this is a significant departure in this law about what the state intends to do, and that actually current strictures are not appropriate. to be addressing, that we have to address them structurally on the face of this bill to give people the protections that they require. As I set out in my opening, Presiding Officer, I am mindful of colleagues' time in this regard. I don't believe that we can safeguard these issues sufficiently. I've come on some journey with that even since the lodging of amendments. It's on that basis that I withdraw Amendment 144 in my name.
Thank you, Mr Mara. Michael Mara seeks to withdraw Amendment 144. Does any member object? No member objects. Amendment 144 is therefore withdrawn. We now turn to Group 5 on training, qualifications and experience of health professionals. I call Amendment 3 in the name of Daniel Johnson, grouped with amendments as shown in the groupings. I point out that if Amendment 86 is agreed to, I cannot call Amendment 4, and if Amendment 88 is agreed to, I cannot call Amendment 6 by way of preemptions. Additionally, if Amendment 125 is agreed to, I cannot call Amendment 301, which is to be debated in Group 7 on assessments including support of terminally ill adults. That also by way of preemption. I call on Daniel Johnson to move Amendment 3 and to speak to other amendments in the group. Mr Johnson.
Thank you very much, Deputy Presiding Officer. One of the jeopardies of any Stage 2 or Stage 3 is that you don't quite know where in a grouping your amendments will be called. And I stand up somewhat self-consciously for two reasons. First of all, my amendments in this group, and I believe this is a very important group, in some ways were better covered off in the previous group because they in my view, they're about training regarding coercion and capacity. And what I would, and also secondly, I don't believe my amendments cover those aspects of training off as effectively as other members' amendments do. However, what I would want to do is just reflecting on the previous section. I think what Michael Matheson said is incredibly important. Coercion, I think, is something that is an evolving concept. And I think, therefore, we need to think quite carefully on. But most importantly, in terms of his contribution, is that ultimately, in order to detect it, in order to, deal with it effectively, it comes down to training and expertise and ensuring that individuals coming into contact with people who may be subject to coercion have that training and that ability to detect it. And therefore, I think this legislation must cover off that effectively. Secondly, and in terms of the broader amendments in this section, as I said in some of my earlier contributions, I think we all need to accept that this legislation, if it were to pass, will come down to subjective judgments. Yes, judgments made with a great deal of expertise and training, insight and understanding, but nonetheless subjective judgments. And therefore, I think a number of the amendments in this section are worthy of, I think, a great deal of consideration on this place. But what I would also say, with regard to training on coercion and capacity, I will, while I will move my amendment number 3 and 6, particularly 3, in order to enable the debate to proceed, I intend to withdraw it, and I would urge members to support the amendments in Miles Briggs's name, which I think do a far more comprehensive effort in terms of covering off the key elements that I believe require training. And with that, I will close.
Thank you, Mr Johnson. I would advise members that, of course, they will note that we will shortly reach the next time limit, and we have still to proceed with 2 more groups. In terms of debate. As a consequence, under Rule 9.8.5a, I am minded to accept a motion without notice to propose that the time limit be extended by 30 minutes. Minister?
Move, Presiding Officer.
Thank you, Minister. The question is that the time limit for debate on amendments be extended by 30 minutes. Are we all agreed? We are agreed. I now call Liam MacArthur to speak to Amendment 86 and other amendments in the group. Mr MacArthur.
Thank you. I'll speak first to my amendments. The bill as amended at Stage 2 allows the Scottish Ministers by regulations to set out the training, qualifications and experience required of coordinating registered medical practitioners, independent registered medical practitioners and authorised health professionals. As discussed, the Scottish Government considers that these provisions may relate to reserved matter regulation of health professionals, Section G2, Schedule 5 of the Scotland Act. So, amendments 86, 87, 88, 89, 101, 104, 105, 120, 121, 123 and 125. So, whole remove these regulating powers from the bill, including consultation requirements and other procedural matters, with a view to them taking forward under a Section 104 order. I'm also very conscious of the need to ensure that the public, and particularly any person wishing to access assisted dying, can have the fullest confidence in the assisted dying process. It's therefore imperative that only health professionals with the appropriate level of professional training, qualification and experience can participate. However, as I set out earlier, we must ensure that all the provisions of this bill, as passed, are within the legislative competence of this Parliament. Otherwise, they cannot have legal effect as Parliament intends. Taking a constitutionally precautionary approach is the only sensible one to take in such circumstances. I refer again, as I did earlier, in relation to the protections, about the strong commitments made by both Scottish and UK governments, the constructive approach that's been adopted at pace to reflect the will and respect and reflect the will of this Parliament. This gives me, and I think it should give Parliament, confidence that the provisions and those on protections will be taken forward appropriately through the Section 104 order, and therefore I urge members to vote for these amendments in my name. Turning to Daniel Johnson's amendments 3 to 6, I fully agree that training, as I say, is essential, and for this reason I made related amendments at stage 2. However, as already explained, given the concerns raised that training provisions on the face of the bill may touch on reserved competence, I believe the most appropriate and secure way of enacting any training requirements will be by way of a 104 order. For this reason, I can't support amendments 3 and 5. My amendments 86 and 88 preempt making 4 and 6 redundant. In light of my amendments, I also can't support Jackie Bailey's amendments 145 and 146, which would require the regulations, which I'm seeking to have removed, to include a certification process for medical practitioners to evidence their training, qualifications, experience, or Paul O'Kane's amendment 136, or Miles Briggsley's amendment 147, which would require the regulations to specify minimum training standards. All of these are very reasonable proposals that I would expect to be addressed in due course, but which fall to be dealt with through the Section 104 order process. Ross Greer's Amendment 238 provides that Scottish ministers may set out in regulations the training, qualifications and experience required in order to carry out the role of coordinating registered medical practitioner, independent practitioner and authorised health professional. Therefore adds to the legislative competence concerns raised by the Scottish Government. I note that regulations made under Amendment 238 would require the agreement of the Secretary of State, and that Mr Greer's Amendments 239 provides that the Secretary of State may set out in regulations the training, qualifications and experience required in order to carry out the role of a registered medical practitioner, etc. My understanding, and the Cabinet Secretary no doubt will state his own view, is that this would not address the competence concerns raised by the Government. I acknowledge very much the principle behind these amendments, as well as the huge amount of work that both Ross Greer and his team have put in on this issue ahead of stage 3, but consider that for the reasons set out, it would be better to reject these amendments and consider how to take forward in the context of the amendments I'll turn to now, namely 133A and 133B, which are obviously amendments to my earlier Amendment 133. 133A includes conditions in addition to those made by Amendment 133, which must be satisfied before ministers can make regulations to commence the bill as enacted and bring it into effect. The additional precondition that must be satisfied through the 104 order or otherwise is that provision has been made for the training, qualification or experience of participating health professionals. 133B is also an amendment to 133 and provides that precondition prescribed by 133A only be satisfied through the conferral of power on Scottish ministers to specify the training, qualification and experience that must be held by participating health professionals. It also requires that Scottish ministers have exercised that power to make such provision. As set out by the Cabinet Secretary's letter to the Health Committee on the 5th of March, the expected route for making provision for training, qualification and experience of participating health professionals would be via Section 104 order. I understand that this route could not be used for conferring regulation-making powers, such as seen as in the precondition on 133B. As highlighted earlier and consistently through stage 2, I consider it of the utmost importance that participating medical professionals receive the right level of professional training and have the level of qualification and experience deemed necessary to ensure the confidence in the delivery of assisted dying services. Therefore, spoken of the importance of ensuring that all provisions in this bill are within the legislative competence and agreement by both Scottish Government and UK governments that the best way forward to achieve requirements in relation to these factors is through that 104 order. The context of such an order is a matter for the Westminster Parliament, and we are not in a position to set out what that order may contain, albeit it will be through agreement between Scottish and UK governments and the commencement provision within Amendment 133. As I explained, I am sympathetic to the principle at the heart of these amendments. However, Parliament should be clear about the effect of imposing further brakes on commencement and ensure that they are not framed in a way that could prevent Parliament's intention from being realised. And on that basis, I would encourage Parliament to back Ross Greer's Amendment 133A, which I think gives effect to the substance of the issues that was debated earlier on, and perhaps reject Amendment 133B that would apply that break in a way that Parliament may find difficult to release in due course. But again, I thank Ross Greer for bringing those amendments.
Thank you, Mr MacArthur. And I call on Jackie Bailey to speak to Amendment 145 and other amendments from the group. Ms Bailey.
Thank you very much, Presiding Officer. I want to speak to Amendments 145 and 146 in my name, which I've been asked to submit by CHAS, which is the Children's Hospice Association Scotland. Both amendments seek to ensure that if Scotland legislates for assisted dying, the legislation explicitly recognises the unique complexities faced by young people under the age of 25 living with prognostic uncertainty and fluctuating conditions. While the bill applies to adults, Parliament has already acknowledged that many young adults, particularly those with serious or life-limiting conditions, continue to receive care in paediatric or transitional environments, including the service provided by CHAS. These young people often have different cognitive, social and clinical development compared to older adults. Without tailored safeguards, there is a risk that assessments could be inconsistent or unsafe. So these protections are needed because evidence submitted throughout stages 1 and 2 of the bill make clear that assessing capacity in young adults with complex conditions is highly specialised and requires advanced clinical knowledge. Coercion can be more difficult to detect where communication relies heavily on family or carers, and diagnosis in this age group often fluctuate, making terminal illness harder to determine with confidence. These are not routine clinical judgments. They carry significant ethical weight and irreversible consequences, so that requires a robust, nationally consistent framework. Amendment 145 requires the Scottish Government to set specific rules about what training, qualifications and experience doctors need when assessing young adults under 25 living with prognostic uncertainty or fluctuating conditions. It ensures these regulations are equivalent in safety to existing national frameworks that recognise reduced cognitive maturity in people under 25, such as is the case with the Scottish sentencing guidelines. Justice sentencing acknowledges that young people under 25 are more vulnerable and more susceptible to influence, less able to weigh complex risks and more likely to enter harmful relationships. This directly mirrors CHAS's concern that young people may be more vulnerable to coercion or self-duress when facing life-limiting illness, especially during such a difficult time in their life as they transition from child to adult services and when much of the support they rely on falls away. Amendment 146 seeks to strengthen the clinical framework, and regulations must include a method, such as certification, for doctors to verify that they have the appropriate training and experience to carry out roles specified by the bill. It should not just be assumed a doctor is qualified. There needs to be a formal system to show that they meet the required standard to ensure patient and workforce safety. Can I also support Amendment 147 in the name of Miles Briggs, which strengthens assessment, safeguarding and support for young people under 25 in the bill? All of that said, the central difficulty with these amendments is that the Scottish Government believe that many of them are not legislatively competent. But these are the amendments that provide reassurance. So I wonder if the Cabinet Secretary can give, when he comes to speak, an on-the-record commitment from the Scottish Government that the provisions in these amendments will all be included in the Section 104 agreement. If he can't do that, what assurances do we actually have?
Is Ms Bailey finished? Or is she
I'd finished, but I'm happy to stand again and take an intervention if it clears it up now.
Pretend you hadn't finished, Cabinet Secretary.
As I've already set out, I thank Ms Bailey for giving way. As I've already set out, the contents of a Section 104 order will be for negotiation. And I must correct some of what Ms Bailey has said, that it's not just our assertion that these amendments, some of which we're talking about, are out with legislative competence. This decision has been arrived at, as I've put on the record previously, through consultation with UK ministers too.
Jackie Bailey.
Intervention, but I'm sure the Cabinet Secretary will realise that people are trying to build safeguarding measures within this legislation, and to have them taken away with no absolute reassurance that they will return in a Section 104 agreement is incredibly worrying for those who want to make sure that this is the best legislation, if it's to be passed, that this Parliament can actually do.
Thank you, Ms Bailey. I now call on Miles Briggs to speak to Amendment 147 and other amendments in the group. Mr Briggs.
Thank you, Presiding Officer. And to pick up where Jackie Bailey left off, because regulations in relation to training of authorised health professionals is a devolved issue. And I think this set of amendments, which I'll be supporting all of them, does exactly what we want to see and make sure that these training opportunities are put in place. And my Amendment 147, again, I've been working with Chaz, as Jackie Bailey has, would look towards, if Scotland does legalise assisted dying, where professionals involved in eligibility assessments, information provision or application support must have the specialist training required to work safely with adults under 25. Young adults often receive paediatric or transitional care, including from Chaz, and present with very unique clinical, developmental and social needs. So why is this protection needed? Evidence from earlier stages of the bill show that assessing capacity in young adults with complex conditions is challenging and demands specialist expertise. Coercion may be harder to identify due to reliance on family and carers for communication and support, and prognostic uncertainty is greater in young adults, making terminal illness harder to determine. These decisions carry irreversible consequences and require consistently high clinical standards. So the amendment in my name would put in place mandatory minimum national training standards covering capacity assessment in young adults with complex or fluctuating conditions, would identify a subtle or relational coercion common in young disabled adults, understanding prognostic uncertainty for people under 25, working with rare and unfamiliar conditions, with sensitive communication with families and during emotionally complex decisions, signposting palliative, hospice and home-based care options as well across Scotland. These standards would therefore ensure, I believe, that assessments could be safer, informed and consistent nationally. So why does this matter? Well, I think Jackie Bailey touched upon this. Young adults' illnesses and trajectories are often unpredictable and often don't match adult timeframes. Many experience fluctuating capacity, communication differences, or also different periods of stabilisation of their conditions. This makes eligibility assessments particularly difficult and challenging and increases risks of misinterpretation and safeguarding issues. So to conclude, Deputy Presiding Officer, this amendment ensures training standards are developed with expert consultation led by the Chief Medical Officer. They're reviewed every 3 years to reflect new clinical evidence, and they're supported by guidance published when regulations commence. And if Parliament does legalise assisted dying, these safeguards would ensure young adults' assessments, I think, would be safer, ethical and consistent. And I move Amendment 147 in my name.
Thank you, Mr Briggs. I now call on Paul O'Kane to speak to Amendment 156 and other amendments in the group. Mr O'Kane.
Thank you very much, Deputy Presiding Officer. I don't intend to say too much on this amendment because I think it has been largely covered in the amendments of colleagues. So I think there are a number of amendments in this space that seek to do the same thing, which is to mandate that regulations be laid in terms of the training that will be offered to medical professionals in terms of identifying coercion, undue influence or coercive control, and situations of dependency which arise from illness, disability, age, social care needs or caring arrangements. And those are the wordings indeed of my amendment. I think what we've identified both in the previous grouping and the wide debate we had on coercion and coercive control, and indeed already in this debate in this section, it is clear that medical practitioners don't always have that specialist training that is required in order to identify the very complex and often conflicting issues that exist in terms of abuse and the patterns of behaviour that exist through coercive control. And that has to be monitored over a longer period of time. And colleagues have already made reference to the challenges, I think, in that the relationship with your general practitioner isn't the same as it was perhaps many years ago when there was a more constant relationship of seeing the same practitioner. So actually that has to be looked at, I think, more broadly. And it's of course why I have raised the issues about the need for a wider input, including from social workers and other professionals in a multidisciplinary way, because I think actually that helps to identify coercive control much more easily. Indeed, looking at some of the evidence that's been provided from elsewhere, other jurisdictions, the Jersey Review panel in its recent examination of assisted dying safeguard concluded that assessments should draw on as broad a range of professional expertise as possible, and actually acknowledged that medical training alone can provide cannot actually provide what is required in terms of identifying coercion or coercive control. So I say that to firstly back up the previous point about social work, but also to make a clear point that training is going to be required and training is important, and that would allow us to deal with some of the issues that have been raised in terms of the capacity of medical professionals to be able to identify these very pernicious issues. So, as I say, I don't intend to labour points that have already been made, but I'm very grateful, Deputy Presiding Officer, for the time in order to add to this debate.
Thank you, Mr Kane. I now call on Ross Greer to speak to Amendment 238 and other amendments of the group. Mr Greer.
Thank you, Presiding Officer. My contribution in this group follows on directly from what I said in Group 3 on conscientious objection and no detriment, because the way that we resolve these issues is intertwined, as Liam MacArthur has already laid out. Specifically, my 133A and 133B are amendments to Liam MacArthur's Group 3 Amendment 133, which tied commencement to resolution of the issues on the right of professionals not to participate and to be protected from any detriment if they did so. I'll briefly touch on my other amendments 238 and 239. These were a way to reach essentially the same outcome by replicating the structure of the Cabinet Secretary's amendments 110 and 111 on a Scotland Act compliant way of creating regulation making powers on this issue, training, qualification and experience. 238 and 239 are my least preferred options. I'm not planning on pressing them. But I did lodge them simply because I wanted to give Parliament the option, and there were only a few hours between the Cabinet Secretary lodging his amendment and the deadline for members to lodge ours. So I thought it was prudent to lodge an equivalent, structural equivalent of his amendments on poison control in relation to this area as well. I don't think that's now necessary, though I think we have come to a solution elsewhere, and that is in 133A and B. And for those, I am grateful for the support of the British Medical Association, the Royal College of Nursing in the drafting of them, and the support of Dignity in Dying and the Queen's Nursing Institute in Scotland. The Queen's National Nursing Institute in Scotland for their support with them as well. I think we would all agree it's not acceptable to have a system of assisted dying without having set out what the training, qualification and experience requirements are for those delivering the system. As Liam MacArthur himself said, we would not want to proceed in such a manner. Without these amendments, though, that is the bill that we could potentially have. The bill proposes a dispersed rather than a specialist service, so it's not automatic that those involved would have specific training and qualifications unless this Parliament decides that is necessary. At stage 2, the committee did decide that was necessary by supporting my amendments to include these provisions. Those provisions are in the section being removed now for the sake of legislative competence, and I recognise the necessity of that. So these further amendments, 133A and 133B, seek to resolve that. They make commencement of the bill conditional on this gap being closed by the UK Government in the same manner as we've just addressed the issue of no duty and no detriment provisions through Liam MacArthur's 133. 133A simply requires that a solution is found by the UK Government to provide for those training, qualification and experience requirements, but they can do so in a way that they see fit. That could mean making the arrangements themselves or devolving regulation-making powers to Scottish ministers. 133B would require a specific solution to that, i.e. that they have to confer the TQE, training, qualification and experience, regulation-making powers to Scottish ministers. This isn't a constitutional wedge issue, it is a fundamental point of safeguarding. The Parliament is trying to make arrangements for assisted dying schemes, so I do think it should be this Parliament that makes those decisions. So, while I imagine under 133A, if the UK Government set those standards themselves, I would hope they would listen to Scottish ministers and stakeholders and what they have to say. There isn't a guarantee on that, though. We could have training standards that this Parliament doesn't support, leaving us with the nuclear option of what to do with the commencement regulations. That's why 133B was my preferred approach, though. I'm going to ask Parliament not to support 133B, though. I'm going to ask them to support A, much as I think it's not ideal, because 133B would effectively give the UK Government the choice of either granting a Section 30 order that they clearly do not wish to do for whatever reason, amending the Scotland Act, or effectively blocking an assisted dying bill that this Parliament had voted for. I don't think that would be an acceptable outcome. So that is a roundabout way of explaining why, with all these options on the table, I am asking Parliament to support 133A. Just in closing on that, though, I do want to ask the Cabinet Secretary, because he said in his letter to the Health Committee, and I'll quote, "Our view is that the route of seeking to make provision in a Section 104 order, perhaps to give Scottish ministers power to make directions about such matters, is the appropriate one." The UK Government's letter on the Section 104 order is silent on the approach that they would take in this regard. So I would be grateful if the Cabinet Secretary could clarify if in these discussions, the UK Government have expressed any preference on how they would go about this in the Section 104 order. Would they do this themselves? Would they give Scottish ministers direction-making power, for example? Because the direction-making power point, I bring that up because it was in the Cabinet Secretary's letter, because direction-making powers would not require the approval of this Parliament. Scottish ministers have the ability to direct, in this case, the Health Service, without it going via the Parliament. The Parliament would have the final say via the backstop of the commencement regulations, but I think it would be far better if the Government were to engage with the Parliament up front on this. So, with that, I'm not going to press 238, 239 or 133B. I would urge Parliament to back 133A, but I would be keen to hear from the Cabinet Secretary if he can address... I would take that intervention, yes.
Cabinet Secretary.
I can confirm to Mr Greer that the UK Government has not expressed a preference for how it should be resolved.
I'm grateful to the Cabinet Secretary for that clarification. Disappointing as it is, and I don't want to rehearse a lot of the arguments we've had already about how much this has turned into a debate about the limits of the devolution settlement rather than the issue at hand. I would hope, given the strength of feeling the Cabinet Secretary has seen from around the Parliament, that at least from this Government there will be consistent engagement with Parliament, even if these come to Scottish ministers as direction-making powers, that they will make sure Parliament is engaged before they issue any of these directions, even if that doesn't need to go via Parliament. With that, though, I will conclude. Thank you, Presiding Officer.
Thank you, Mr Greer. I now call Alistair Allen.
Thank you, Presiding Officer. Liam MacArthur's amendments remove, of course, the power of ministers to set regulations defining the training, qualifications and experience of the coordinating registered medical practitioner. And that, as people understand in the Chamber, is because such powers would be out of scope for this Parliament. So should the bill ultimately pass, we face two options. Either Parliament agrees to Liam MacArthur's amendments, effectively outsourcing such important decisions as these to unelected UK officials, or Parliament does not agree to these amendments, with the legislation then all but certain to end up in the Supreme Court. Now, lest there be any misunderstanding, I accept that the areas in question here are pro tempore, indisputably reserved to Westminster. And I believe, however, also that it is not good lawmaking to draft laws that end up in the courts while issues of competence are settled. So I can understand the motivations of those seeking to make many of these amendments and do not intend to stand in their way. But it is difficult, however, to endorse these moves with much enthusiasm either. My concern is that we are being asked to pass legislation here without having any real idea of what the UK Parliament has in mind or how it intends to plug the holes in our own law. I've mentioned already today a letter sent to MSPs from the Royal Colleges of Physicians and Surgeons making their concerns about that very clear. So we can't interrogate any of what might be in a future Section 104 order today, Presiding Officer, because that has yet to appear. In any case, such an order by its nature receives very limited parliamentary scrutiny. So I really mention these things just to point to the dilemma that's been created here. I think that members in previous debates as well as this one have pointed to the central nature of this debate, to the discussion we're having. It's not a constitutional debate. It certainly engages issues around the Constitution, but it's a question about should this Parliament get to see the complete legislation and the complete implications of that legislation before it makes a decision.
Thank you, Dr Allen. I call the Cabinet Secretary.
Presiding Officer, the Scottish Government have worked with Liam MacArthur on Amendments 86 to 89, 120 to 121, 123 and 125, as well as Amendments 101, 104 and 105 in Group 8. Collectively, they removed the sections of the bill that currently requires the Scottish Ministers to, by regulations, specify the training, qualifications and experience of coordinating registered medical practitioners, independent registered medical practitioners and authorised health professionals, and make other changes consequential on that removal. As I've outlined previously, it is the Scottish Government's view that these provisions in the bill may raise issues of legislative competence, as they may relate to the G2 regulation of the Health Professions Reservation. I have already set out our intentions to address issues of legislative competence and our discussions with the UK Government, which has given an in-principle agreement to take forward a Section 104 order and to consider and make appropriate provision to specify the training, qualifications and experience required for participating healthcare professionals. Should the bill pass, the Scottish Government will continue to engage closely with the UK Government on the form which that Section 104 order will take, and I give my commitment, should I continue to hold this responsibility, to Mr Greer and his direct question, that I would seek to keep Parliament informed. Presiding Officer, as I turn to other amendments in this group, I would like to remind members of my previous comments on the responsibility of this Parliament to consider matters of legislative competence in passing legislation. On Amendments 3 to 6, 146, 145, 146, 147 and 156, as is clear, the Scottish Government's view is that Sections 4.5a, 6.6a and 15.8, to which these amendments varyingly relate, may raise issues of legislative competence and should therefore be removed from the bill, with any necessary provision made instead through an order under Section 104 of the Scotland Act 1988, should the bill pass. In relation to Amendment 133B, from a practical perspective, it suggests using a 104 order to confer a regulation-making power. It is considered that such an order cannot be used to confer regulation-making powers. Another vehicle would therefore be required to fulfil the requirements of Amendment 133B, such as provision in an Act of the UK Parliament. As I said in response to Mr MacArthur's previous intervention, we do not have legal or competence concerns with Amendments 133 or Amendment 133A. On Amendment 238, the Scottish Government's position is that this may raise issues of legislative competence in that it provides power to set training, qualifications and experience of health professionals. Amendment 239, which seeks to give power to the Secretary of State, would be out with the legislative competence of the Scottish Parliament, as the substance of the power is beyond competence. A specific power to confer such a regulation-making power on the Secretary of State would need to be identified, such as by way of a Section 30 order, as has been done in connection connection with provisions to do with substances and devices. And, Presiding Officer, for the remaining amendments in this group, the Scottish Government has no comment.
Thank you, Cabinet Secretary. Members will note that despite extending the previous time limit by 30 minutes, we will shortly reach the next time limit. And we have still a further group still to debate. As a consequence, I am minded to accept a motion without notice to propose that the last sentence of Rule 9.A.5a be suspended. Minister to move? Thank you, Minister. The question is that the last sentence of Rule 9.A.5a be suspended. Are we all agreed? We are agreed. Under Rule 9.A.5a, I am minded to accept a motion without notice to propose that the time limit be extended by 30 minutes. Minister to move formally? Thank you, Minister. The question is that the time limit for debate on amendments be extended by 30 minutes. Are we all agreed? We're not agreed.
The committee from 8:30 this morning. 8:30 this morning. I'm exhausted. A lot of our people. We've actually got a lot to pace ourselves over the next couple of days. We've seen endless speeches. We've not even had votes for a number of hours. It just goes on and on and on. And I do think it's frankly unacceptable. This just seems to be getting extended by every 30 minutes, and I think we should have a vote on it.
I thank Mr Gibson for his intervention. I would point out I'm not seeking per se to extend proceedings by 30 minutes beyond 10 p.m. What I need to do is just extend the timeline, and that's what the process has been here. I couldn't hear that, Mr Gibson, but I assume you're accepting that my position is what I've just stated, which is all good. So with that, I call Daniel Johnston to wind up and press and withdraw Amendment 3.
In the interest of Kenny Gibson's good humour, I have nothing further to add and withdraw my amendment.
Thank you, Mr Johnston. Daniel Johnston seeks to withdraw amendment number 3. Does any member object? No member objects. Amendment number 3 is therefore withdrawn. So, I call Amendment 86 in the name of Liam MacArthur, ready to debate with Amendment 3. I remind members that if Amendment 86 is agreed to, I cannot call Amendment 4 by way of preemption. Liam MacArthur, to move or not move?
Moved.
The question is that Amendment 86 be agreed to. Are we all agreed? Yes. The Parliament is not agreed. There will be a division and members should cast their vote now.
The vote is closed. I call Jackie Bailey for a point of order.
Apologies, Presiding Officer. I couldn't connect on the app. I would have voted yes.
Thank you, Ms Bailey. We will ensure that is recorded. I call Craig Hoy for a point of order.
Apologies, Presiding Officer. My app, I think, is as tired as Kenny Gibson. I would have voted no.
Thank you, Mr Hoy. We will record your vote. The result of the vote on amendment number 86 in the name of Liam MacArthur is yes 82. There were 29 votes against. There were 5 abstentions. The amendment is therefore agreed. And we move on. I call Amendment 145 in the name of Jackie Bailey, already debated with Amendment 3. Jackie Bailey, to move or not move?
It's been preempted. It's Amendment 4 first.
Sorry, Amendment, just for clarity, Amendment 4 has been preempted. And that's why I've moved on to Amendment 145. So I call Amendment 145 in the name of Jackie Bailey, already debated with Amendment 3. Jackie Bailey, to move or not move?
Moved.
Thank you. The question is that Amendment 145 be agreed to. Are we all agreed? Yes. The Parliament is not agreed. We'll move to a vote, and members should cast their votes now. The vote is closed. The result of the vote on amendment number 145 in the name of Jackie Bailey is yes 21, no 94. There were 3 abstentions. The amendment is therefore not agreed. I call Amendment 146 in the name of Jackie Bailey, already debated with Amendment 3. Jackie Bailey, to move or not move?
Not moved.
Thank you. I call Amendment 87 in the name of Liam MacArthur, already debated with Amendment 3. Liam MacArthur, to move or not move?
Moved.
The question is that Amendment 87 be agreed to. Are we all agreed? The Parliament is not agreed. There will be a division. Members should cast their votes now. The vote is closed. The result of the vote on amendment number 87 in the name of Liam MacArthur is yes 86, no 25. There were 10 abstentions. The amendment is therefore agreed. I call Amendment 147 in the name of Miles Briggs, already debated with Amendment 3. Miles Briggs, to move or not move?
Moved.
The question is that Amendment 147 be agreed to. Are we all agreed? Yes. The Parliament is not agreed. There will be a division. Members should cast their votes now. The vote is closed. The result of the vote on amendment number 147 in the name of Miles Briggs is yes 41, no 70. There were 8 abstentions. The amendment is therefore not agreed. I call Amendment 148 in the name of Michael Mara, already debated with Amendment 142. Michael Mara, to move or not move?
Not moved.
Thank you. The amendment is not moved, and that concludes proceedings on amendments for this evening. Members will be aware that the Parliament is beyond the timetable agreed by motion earlier today. The Bureau will require to consider how business is rescheduled where current progress suggests that we cannot meet the unanimously agreed timetable, and Bureau will meet tomorrow. The next item of business is a committee announcement, and I call Ruth Maguire, Deputy Convener of the Standards, Procedures and Public Appointments Committee, to make an announcement on pastoral support for MSPs.
Thank you, Presiding Officer. The SPPA Committee wish to draw the Chamber's attention to a matter relating to when an MSP is subject to a complaint. As MSPs, we are office holders rather than employees of the Parliament. However, there may be times when it would be appropriate for MSPs to have access to the pastoral support that any organisation should provide for its workers. Depending on the terms of a complaint, it may not be appropriate for a member to share information about a complaint or seek support from those they would ordinarily turn to, such as individual colleagues or party structures. We understand that when they are subject to a complaint, they may not find support from those usual structures. The committee has advised the SPCB that the current telephone support line is wholly inadequate for the circumstances in which a member may find themselves when subject to a complaint. The Ethical Standards Commissioner's evidence last week was both powerful and unambiguous. Members navigating a complaints process require robust, professional and trauma-informed support, and the present arrangements fall substantially short of that standard. Crucially, the Commissioner confirmed that he has raised these concerns directly with the SPCB earlier this session. The failure to respond meaningfully to those warnings represents a clear and troubling gap in the Parliament's duty of care to its own members. As a committee, we wish to draw the attention of Chamber to the fact that the SPCB is considering this issue. We hope that positive progress will be reported soon. Presiding Officer.
Thank you. It's now time to move on to the next item of business, and as there are no questions to be put at decision time, I close this meeting.